Hot enough. What is up, guys? Welcome to Truth and Transparency. Today's episode is sponsored in part by Big Dick Energy. Yes, and Micro Wrestling Federation. The little midgies. Big Dick Energy. It is said when you have Alan Jackson on your team, you might as well wear a kilt when going out in public because big dicks will be swinging. Welcome, everybody. Come on in. Today, Karen Reed is back in the courtroom. She's back in the courtroom for a pre-trial hearing. And here's a pre-trial video.
Nicole, was she there?
Yeah, she was ready to leave. Yep.
And
Caitlin was in there, right?
I'm using sort of you in the plural. So you drove, is that correct?
I drove. Yep.
And who, if anyone, went along with you in your car?
Nicole, my sister-in-law, and Caitlin, my niece. And Brian did not end up coming with us.
While you were there, as far as during sort of the meal portion of it, was there anyone else that joined you?
I know my niece's boyfriend, Tristan Morris, came. I don't remember exactly when it was during that, but I know he was there. And then during the meal part, I don't think during the meal part anyone else. I don't think.
So you recall, as far as the meal part was concerned, it's you, your sister-in-law Nicole, your niece Caitlin, and her boyfriend Tristan.
Correct.
And Ms. Morris, did he stay for any extended period of time, or when was it that he left?
I know he stayed for a little bit, but I honestly can't remember what time exactly he left.
Why all the lies? This one is about Tristan Morris. Why the confusion? Julie says that Tristan Morris was late to arrive with them and that Caitlin drove with them to the waterfall bar. That would put Caitlin with a vehicle at the house, motherfuckers. Meanwhile, Nicole says that her daughter didn't drive with them and that her and Tristan already had a table and they were sitting there waiting for her sister and herself to arrive at Waterfall Bar. The lies continue. Welcome. Come on in, guys. Again, today's episode is sponsored in part by Big Dick Energy and Micro Wrestling Federation. So Big Dick Energy, when you are rolling with Ellen Jackson, you better be wearing a kilt because dicks will be swinging. I have to tell you guys, there's a reason I love Karen Reed, and because I'm going to tell you why I love Karen Reed. She's a fighter. I'm a fighter. Okay. And she takes her tits and stuffs them in the Commonwealth's mouth every fucking chance she gets. And I just absolutely adore her for it. So cheers to Miss Karen Reed. Big Dick Energy swinging as well. Hi, Miss Potts there. We are going to take a look here. Hector the Projector. Today, we're going to be hearing from God knows who on the stand. God knows what's going on around there. I honestly have no idea what's going on in Norfolk County because it's just a shit show. But video file, stop sharing that screen. We're going to share this screen. I'd like to invite Hector. Their defendant's opposition to Commonwealth's motion to exclude certain testimony of defense witness Richard Green. Unless she came swinging with 24 pages. 24 pages. I mean, just, there's supposed to be a Daubert hearing. I honestly, I have no idea what the hell is going on. You guys know a Daubert hearing is to say like, oh, this person isn't qualified to be an expert. He is clearly qualified to be an expert. Okay. Just because he has a different opinion than your expert, you don't go and have a Daubert hearing because you know what, his opinion is different than my expert's opinion. Okay, it's just that's not what these are for. I don't even know how this is happening. I don't understand. I think Bev likes to see her bangs on local TV. Um, uh, and I love the bangs, girl. Keep blowing them out. But I wanted to play you guys that. I made this video a long time ago. I have a nut all video as well. But I mean, if somebody is truly paying attention to these people on the stand this next time, and you have a photographic memory, and if I had transcripts that could read through, I could freaking be ready to pop all of these people on cross-examination and impeach the shit out of them in trial 2. How anybody can find Karen Reed guilty of anything, literally of jaywalking. There is nothing that could budge me in a first grade mindset to convict her. So yes, Bev's taking blowouts both ways, if you know what I'm saying, from the backside. But I went back to watch I love when Microdots drops some of their stuff because that's why I'm doing this red flag project with the Idaho 4 case. But when you go back and you listen to these hearings, they are just so ridiculous. Like Auntie Bev, she is married to a Frank. Okay, right? And clearly these people in the world are saying that they know you, and it appears to be that you would have bias. And I don't have to prove that there's bias. It's just simply I have to show that there appears to be bias. How this broad is still on this case appears to be corruption. It appears to be corruption. I'm not saying that it is corruption, but it appears to be corruption because it's apparent that there appears to be bias with Auntie Bev. I mean, the statute doesn't say I have to prove that that's not the statute. The statute is I have to show that there appears to be a connection here. There appears to be bias. There appears to be, and we want to look into this. Like, who is this Sean? Who is this Sean guy claiming that, who is Julie Nagel to be paying people on Cash App, Venmo, whatever the hell was Venmo, because people are such idiots and write what they're paying people for, like a drug dealer taking Venmo payments. Like, what a moron, right? I just love morons. I swear I wanted to start a second channel and call it like just dumbest criminals, but be like way sweeter of a title. I just wish I could clone myself 4 ways. There's just not enough time in the day, especially because I go so hard. Like, I won't stop researching something until I find what it is that I'm looking for, or I say, okay, it's not there. But, people that are just covering cases and skimming over them or whatever, dude, I could read documents and say, okay, on to the next. No, I want to find some nuts, and give you guys some nuts. Like, But anyways, I love Karen Reed. Like, as a human, in terms of, like, her internal, like, fuck them up. And she's doing it, man. She's just like, let me just throw my dick on the table. But I said, like, she's just powing the Commonwealth with here, just shoving her titties. And she doesn't even have big tits, So I just love it. And they're just getting their asses handed to them. But she's fighting. She's like, I'm not going to take a plea deal. What do you want me to plead to? Disorderly conduct? What do you want me to plead to? Drinking and driving? Fuck yourself. How are you going to charge somebody for a DUI after the fact by days? That's ridiculous in and of itself. You want me to plead? I'm so glad that Karen Reed doesn't have any children, even though she acted like a mom to John O'Keefe's kids, because it would totally change, though, probably some of the stuff that she would have to consider, right? When you have a kid, a lot of things change. You're just not fighting, for yourself. You're fighting and trying to make the best decisions for your kids, stuff like that. But yeah, Karen Reed. Fucking yeah. Just love it. Look at these fools. Look at this. Look at this. If you guys are just joining me late, check this out. Again, I made this video a while ago during the first trial. And I've upgraded for this next trial. I have 5. Oh no, what happened there?
It was still snowing out?
Yes.
You guys remember I said we need to have a car count where these cars are, right? Where are these cars at in this driveway, right? Because the pictures, wait, we're missing cars here. We're missing cars here. I said it during that trial live. I was like, oh my God, give me all my exhibits. Boom, boom, boom. Look at this. You know, that was one of my big things. I'm like, hello. And then my other big thing is I want a map of the inside of the house, and I want to show that everybody was sitting on everybody's lap. Okay. And I want a big poster board that you have to mark when you're taking the stand. Where did you sit? And watch just people just sitting on each other's laps. Show that shit to the jury. Everybody was just lapping it. Like, just give the jury a little chuckle. I'm this close to going to law school, you guys. This close.
You approached the house, he opened the door, correct?
I approached the car, not the house.
Oh, okay. You approached, whose car was it?
My nephew Brian's.
Brian's?
In the driveway. Yes.
All right. And then...
One car.
And we went to the waterfall, and I believe my daughter and her boyfriend Tristan were already inside at a table.
What
did Julie just say?
And when your sister Julie came to pick you up the house, in addition to yourself and your son Brian Jr., with anyone else?
Chris said Tristan arrived later.
I believe 2 girlfriends may have already had come, and they were just sitting in the kitchen when I left.
And so you go out to the waterfall. When you get to the waterfall, where within the establishment did you go?
We came in, walked in. I believe to the left there was just some small tables, and I think Caitlin and Tristan were already sitting there. So
That would be where the band is. I've been to the waterfall a couple different times to literally eat, drink, and win at Keno. I won at Keno the first time I walked in there. I hit 4 numbers for $5. It's 72 times 5. So I bought everybody their meal. Literally, I hit the Keno. I was like, it's going to be a good trip, motherfuckers. Woo! Waterfall. But right when you walk in to the left there, it's not really it's just, when I say to the left, it's like literally, it's where the band would be set up if she's talking about that. That's why I had to go in to the waterfall, and I want to check it out. I want to see how small it truly was. You guys, the camera makes it look way bigger than it is. Okay, is small. Small.
I know my niece Caitlin was in there, my nephew Brian. I
know my niece Caitlin was in there. Nicole says Caitlin wasn't there. You want to know why she had to say that? Because of a vehicle. Why would Tristan come and pick up Caitlin if Caitlin's car's there, right? What vehicle did he drive? Things like that. So if Brian's vehicle is there, Brian Jr., Caitlin's vehicle would be there. Okay. Unless they're going to come on the stand trial 2 and try to say like, no, Tristan dropped me off at my parents. Then he left and went to the waterfall bar by himself. And then we met him up there because he went to save us a table. You guys see how crazy that is? No. But here, this is the sister that's going to pick up her other sister. And she thinks that she's picking up Brian Jr. too because they're going out for his birthday. But Brian Jr. says, I'm just going to stay here. Okay. So she picks up her sister, Nicole, and Caitlin. Well, Nicole, Coco, takes a stand and she says that I only got into that car. That Caitlin and Tristan were already there and we met them there. But you have to think that like, this isn't somebody just forgetting, oh, maybe she should come. There's a reason that they have to say this. And this has to be pointed out because you can use it because you have the pictures of the cars. Okay. So the reason that Caitlin and
Nicole are lying is because of the number of vehicles in the driveway. And it doesn't make any sense if Tristan came to pick up Sugar Tits, then they would have left her vehicle there. Okay. Also, the order that the defense decides to call witnesses, you have to recall them if this is going to be a long trial. The jury has to hear from these certain witnesses again for that pow. You know, that's just me, and I'm not an attorney, but I'm saying it from a juror's perspective. Like, people are forgetting things, okay? When you're propelling them on cross-examination, they're forgetting that. So recall these people to the stand, because you can open up the scope, because then they become your witness on direct. You're going to get them with that pow, but you can say, when you testified earlier on cross-examination, you were asked, do you recall that? And now if something else would have come out during the trial, you can then show them evidence of something else because it's already come out. Do you recall this? You know, if Julie was to say blah, blah, would you say that she's mistaken? Or here, the pictures of the house with the cars weren't in the driveway yet in evidence. Recall, hey, this is your house. What cars are these? Where's Brian Jr.'s car? Now, you have twins. Did they have a car? Where are their cars? Now, Brian has a vehicle and a work vehicle. Do you have a vehicle? And then so Caitlin, or any of these, you guys get where I'm going with that? Like, blah, just all lies. Anyways, let's see. Welcome. Again, today's episode is sponsored in part by Big Dick Energy and Micro Wrestling Federation. My favorite wrestling. Midgets. Little people. Yes. If any of my mods have the link for today's, I think, let's see. Bev's always late, you guys. She has an issue with that, so I'm not too concerned. Oh, I got some information on Sheldon Jeter Jr. We're going to be back in the courtroom in August or in April. So please follow along with that. They don't allow cameras there, but I will be meeting up with NBC, Nicole Ford, and Delsha, Sheldon's mom. We're going to be doing another interview, and I got more stuff that I'm showing to the news. We have camera license plate readers, so we're going to talk about that with some evidence. Thank you so much there. You're so freaking brilliant and funny. Oh, I love that. Thank you. I wish I had Alana during my college years. Oh, McTooth is going down. I bet she's sad. Oh, God. You guys are awesome. Is it Josie? Josie's on a vacation far away. Is that it? My other people's names, I like to get them right. My name's Lana, not Lana. But you know how many times people mess that up? Yeah, all right. Sweet. Josie Lou, nice. I like it. It's pretty. Let's see. Kedden Reed. See, I think here we go. Long Crime has it. I think. Yeah, Long Crime. There you go. Get your shit together, Long Crime. Long Crime. Long Crime. Live, Gary. Let's see. Oh, shit balls. Karen Reed. You know. Oh, here it is. arriving. So it's not- AJ's got his beard. Let's see. I like to get Mr. and Mrs. Reed. Oh, there's Karen. Remember that mic sign? You got a hot mic there, AJ. Okay, so let's think about this, guys, again, man. This is just wild. Let me put myself over here. How much money this is costing, okay? Oh, Tim Bradle's in attendance. Oh my God, what the fuck? Wait, why is Tim Bradle there? Holy shit. What is going on? Oh my gosh, Tim Bradle's in attendance. B? I heard there was fireworks popping off. What is up, Forensic Fury? What is up? What is good? Love seeing you in here. What's up, DMC? Hey, I gotta call you today. I gotta tell you something. DMC, be ready to get my phone call. Love your face, DMC.
Oh, hey, David.
What is up, Holly? Holly says, did anyone else hear that there was something in a new filing proving Brian Higgins lied at trial? I hope it's that big dick energy. So we're gonna get some today's sponsor. We're gonna get some shirts made, but Micro Wrestling Federation. We're gonna see if we can do a fundraiser for Karen Reed for midget wrestling. So if they would agree to put on a midget wrestling tournament in honor of Karen Reed, but we can have all of the people can dress up as the participants of this trial, and they can dress like them because they do like superheroes and stuff. Yeah.
Folks that just showed up, please, no cell phone use whatsoever. You can enter at sidebars and breaks. I don't want to see your cell phone out at all. No cell phones.
Thank you. I'll be with you.
When you're in the whole 5 million, I think you'd agree to anything. Sidebar. You know what? We had the best sidebar. All right, so we have Mr. and Mrs. Reader there. There's a brunette that's there. They put the media in the jurors well right here underneath, if you guys can see. See that? So we're back into the original courtroom where the trial was held. We got a lot of... Okay, you see the guy that has the white hair there? He's the attorney for the Boston Globe.
That was great for you.
Dude, Holly, wasn't that sweet? That was great. Holly, that sidebar, nobody topped it. That setup. Everybody said hands down best setup. So we're gonna have to do 2.0. Okay, put a 1 in chat if you like Alan Jackson with the beard. Put a 2 in chat if you like him without it. Put a 3 if you'll just take Alan Jackson any way you can get him.
You're a gentleman.
That's it.
Your bar is
Yeah,
printing a copy right now.
it's coming in now. That's right. That's right. Thank you.
The bar is printing you a copy right now.
Put a 4 in chat if you have ADD and you asked your own question and you can't remember it. Was 1 for the beard, 2 for the without it?
One was for beard. I will. Just,
Susan says, I'm putting 0 because I have ADD too.
put a 5 in chat. You think he needs to wear a kilt?
Yes. Love it. All right. Okay, I'm curious how many people have to be at work right now and they are like, oh my God, who is that? Is that who I think it is? How many people are at work right now and they have to hide in their cubicle and put like hide that they're watching it?
What's that? I'm good. What's that?
Has anybody checked the
Your kick-ass timelines are evidence against ADHD. I just pushed through it, girl.
That's okay. Thank you.
How many people just quit their job because of the Karen Reed trial? And they were like, I just need to watch Lana all day, every day. Babs Bangs, welcome to the game. How many people love the fact that their husbands work like awesome and make awesome money and they get to stay home and they're like, yeah, man, I found this new channel, True the Transparency. This bitch gets me rolling. And I just watched these trials with her. Anybody?
Oh my God.
You guys ready for Bev's Bingo 2? Sequel. Jen, I love it. Like, Mary, I work with nobody pays me. Stop telling on me, Lana. I know. I love it. How many people just pretend? Okay, yeah. Listen. Do they not know that they have hot mics? I love it.
I said, Alexa's like, can we make sure that our mics are off? And Alan like pushes the button so like because he's an old pro at it, they're just talking like, and Alan's like, poor Alexi. He has to go first.
Reed and Cobra Trials 2025 is a good year to retire. That's great. I'm going into family law so I can fucking just kill it against all these blood-sucking vampires. What is your organization? Can you just write down your organization? I love accents. The organization. Look at Lally. Look at him. He's like, God, I am not BDE today. Lally never has big dick energy. You think his wife's ever like baby, come here. Let me give you a little kiss. And you go in there and you find that big dick energy, okay? You show him what you're made of, baby. Do you think his wife gives those type of pep talks? You got this, honey. Grab some. Mwah. Lally limp. Honey, you give him hell today. You hear me? You object like a motherfucker. What, if anything, do you want for dinner tonight? This is Lally when he goes home. Hey, hon, how you doing? What, if anything, do you want for dinner tonight? Or what, if anything, do you fancies you tonight? What, if anything?
Want to go to the sidebar?
Let's head up to the sidebar. What is up, Jacqueline? Sorry about that. You're down your feathered pillow. We got some new twists in our. I've been working with my my bingo exec over here. We got some new twists this year to the bingo. It's actually sweet. It's a automated digital ball dropping in when trial's going on. And it'll pay you right out to Cash App. It's $2 a card. It just goes, well, the trial's going. It's just going to be so insane. So I'm like, hey, you know what? I'm going to probably have people in here that don't even give a shit about this trial, but they're like, oh my God, I can go on there and play bingo. So I'm bringing out all the retirees, you know. It's pretty sweet. Oh, thank you so much. Pro se in my own support case. Aw. Member for 14 months. DCRUCERU. Pro se in my own support case. Thanks to me. Oh God, can I help you? You might want to hit me up. Let me give you some last minute pointers. You need to preserve the record. Ask for everything to be a preliminary hearing. Say you have a preliminary matter you need to take up. Preserve the record. Hit me up. Email me. Preserve. Lana, thank you all. Pam, thank you for all you put into your work and standing up for those being railroaded. I try. Thank you to all the mods too. Aw. How can the chat support the mods? Buy them a car. Buy them a house. I don't know. Oh, you guys, it's 9:17. This is why I was taking my time looking at my videos and okay, so I told you guys I got a new laptop for all this new editing. I got a new software. I applied at the Ohio State and I was accepted into the, well, I didn't realize what I got accepted into. I had to tell you guys a story one time when I actually have time and not rushed. But I was like, oh, I just want to go take some Celebrate classes. Like, we're going to get these Celebrate classes. Come on, man. I could totally just like, hello, I want to sign up. So I'm close to Ohio State University. And I was like, oh, dude, I'll just like get on. And these people were like, hey, we want you to come and be part of our cybersecurity, blah, blah, blah. And I'm like, wait, what? I want to like, I don't give a fuck about cybersecurity. I'm like, what kind of classes are in your cybersecurity program? So I'm looking to see if like, hey, maybe I'll just do it because I want to take a couple of the classes. And they're like, you can just all do it from home. You just have to, do like 10 hours, come on per week. And I was like, I'm way too busy to be coming up to the campus. And they're like, oh no, it's all remote except for just 10 hours a week. I was like, 10 hours? And he's like, yeah, and you could still do that by Zoom or whatever it was. And I just said, I was like, so I just started asking him, like, do you have Celebrate classes in there? He's like, how do you know all of this stuff? What are you trying to learn? Like, I was like, well, I'm really trying to look at like how the versions work, and if you upload stuff, can you ever represerve to find the older versions? How would that work? How could you do like tests with it? Do you want to just go out and buy phones and then you want to test certain versions of these? Like that's what I'm really into. I'm into the data. I want to know why something would happen if something was to come up in like a report. I get that you guys manually extract or that you logically extract with like a button and you download and you plug stuff in, but is there other way? He's just like, okay, this is not the class for you. This is not what you need to be doing. And I was like, oh, okay. He's like, can I ask what you're trying to do in life? Like, what is this? Like, what is your career goals? I was like, my career. I said, I'm sorry, I'm not like 21, just so you know. Oh, I have a career. I'm a YouTuber. I am a content creator. I work with Google.
Oh, thank you.
Dad, what are you trying to do with your life? Well, I'm trying to free Karen Reed, Brian Kohlberger. I'm trying to free every criminal. So he's like, I would just hate to see it. You're not going to do anything with this. I was like, well, I'm trying to also build my resume. So like, maybe it'll be like a good resume booster for me. Like when I want to put my CV in so I can testify in criminal homicides. He said, what? I said, yeah, if I want to be an expert witness on the stand. I'm just trying to beef up my CV. I'm dead. You guys, he's like, man, you have a really good personality. I was like, well, I'm being serious. I'm not joking. I was like, but if you think I'm joking, then yeah, I'm joking. Is that Carrie Roberts back there? Oh my God. Is that her resting bitch face right there? Oh, bless us all. Oh, shit. Oh, I'm here, Mozzolana, but sicker than a. Oh, you just gave me a good idea. I thought it said sticker. I know what we can do for. Oh, here we go. All right. What the heck? Okay.
All persons have any business before the Honorable Beverly Canoni, Justice of the Norfolk Superior Court, in the County of Norfolk. Draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. This court is now open. You may be seated.
Judge, this is 22-117, the Commonwealth versus Karen Reed. Can I have counsel?
Your Honor, Hank Brennan for.
Good morning, Mr. Jackson.
Good morning, Your Honor. Robert Alessi.
Good morning, Mr. Yannetti. Good morning, Ms. Reed. Oh. Good morning, Mr. Birchie. Okay, let's see. So we've got.
She got a trim
for this morning that I want to discuss. So first, there's filed a motion to recover expert related expenses from the Commonwealth, and we'll discuss that in some manner at the end of the hearing today. We've also got Mr. Birch is here on Ms. Voss's opposition to the notes. And then there's the Commonwealth's motion for reciprocal discovery pertaining to the employees of ARCA. And the last one is the Commonwealth's motion to exclude witness Richard Green's debunked opinions. So those are really in that order, except I think we should start with the non-party Gretchen Voss's motion to reconsider regarding the notes. And I do want to say that I received this morning a motion to file an amicus memo. The signatory is Mr. Albano. I've received that. I will allow that to be filed, and I've read the motion and the memorandum. So I will hear you, Mr. Bertie.
Good morning, Your Honor. Rob Berchi for Gretchen Voss. I'd like to start by just thanking the court for taking the time and giving me the opportunity to revisit
Sure.
the court's ruling of December 5. That ruling allowed in full the Commonwealth's renewed motion for all audio recordings, interview notes, emails, text messages, and voicemails in the possession of Gretchen Voss or Metro Court. Ms. Voss and Metro Court complied with the court's order for production of documents on January 2nd by producing to the court all of the responsive materials, the unredacted tapes and the text messages that involved on-the-record communications by Voss with defendant Reed. I'm here today to implore the court to reconsider that part of its ruling, but also would require Gretchen Voss to turn over handwritten notes of an interview with Reed that the parties had agreed in advance would be off the record. What's in those notes is really a black box. The Commonwealth has provided no information indicating what it believes the notes will reveal, or why it has a particular reason to delve into them. So the question before the court is whether the Commonwealth should be entitled to forage through this reporter's notes and compel her to break her promise of confidentiality with the source in the ungrounded hope of finding relevant and material evidence somewhere in those notes that will aid in a prosecution of the defendant. The stakes for Gretchen Voss are considerable. As she set out in her second affidavit submitted to the court with our motion for reconsideration, her effectiveness as an investigative reporter depends upon her having the ability to use the tools of the journalism trade. And among them is the opportunity to reliably assure her sources that certain information they provide to the reporter will be off the record. The precedential stakes are high as well, because the Commonwealth is essentially asking the court to give no weight whatsoever to the off-the-record nature of the notes. And that is what renders a journalist's promise of confidentiality illusory. Off the record is a phrase you hear in virtually every conversation between a reporter and the source. Frequently, it's an interjection in the course of a sentence. This is off the record. The kind of lubricant that allows a source to have a free and full exchange with the reporter without having to guard every word they speak. And receiving information off the record is often a technique by a reporter to establish trust and rapport with the source. That source might be a whistleblower, might be a frightened migrant, or might, like Reed, be a criminal suspect. On page 2 of our motion for reconsideration, we quote from Primer on Journalism that says, off-the-record interviews, quote, are essential in building trust between journalists and their sources, allowing for candid discussions that can provide context or background without the risk of public disclosure. The result, it says, is to enhance the depth of the reporting and provide leads for other sources. In Ms. Voss's case, she states in her second affidavit, which we filed with motion for reconsideration, at paragraph 11, she says, obtaining information from sources off the record is a normal and critical part of my work. Like most investigative reporters, I frequently agree with sources, including named sources, to keep certain of their statements or interviews off the record, not to be published anywhere. Keeping my word on this is critical to maintaining credibility and trust, and thus maintain source relationships while not interfering with the flow of important information to the public. The court's December 5 order forces Gretchen Voss to choose between either keeping her word to her source and thereby violating the court's command, or else obeying the court's order and establishing herself as a reporter whose word cannot be trusted. It's an unnecessary choice to present to her, at least on the facts of this case. The court shouldn't insist on publication of the off-the-record notes because the Commonwealth has failed to meet its burden under Rule 17 to show that mandated production of the records on the facts of this case would not be unreasonable or oppressive. And also because requiring Voss to turn over these confidential notes would damage First Amendment interests more than it would benefit the public in achieving justice for this criminal defendant. Now, I keep saying on these facts, because it's very clear that the inquiry is a fact-sensitive one. The First Circuit wrote in the Bruno and Stillman case that under Massachusetts law, the task is one that demands sensitivity, invites flexibility, and defies formula. While obviously the discretion of the trial judge has wide scope, it is a discretion informed by an awareness of First Amendment values and the precedential effect which decision in any one case would be likely to have. And in Re Cusimano in 1998, the First Circuit said, that was a case like this one, that involved a demand for confidential information from an identified source. The same court reinforced the fact-specific nature of the inquiry. In Cusimano, they said, when a subpoena seeks divulgement of confidential information compiled by a journalist in anticipation of publication, courts must apply a balancing test. This test contemplates consideration of a myriad of factors, often uniquely drawn out from the factual circumstances of the particular case. Now, as I noted in the December 5 order, the court drew no distinction between the on-the-record and off-the-record interviews when it applied the Massachusetts balancing test for mandating production of reporters' notes, texts, and audio texts, audio recordings. It did not treat this confidentiality promise as a factor in the equation. That we submitted was critical oversight, because whether you call it a privilege or not under Massachusetts law, Massachusetts does recognize that there is some degree of deference to be given to a promise of confidentiality. In Bruno and Stillman, the court said courts faced with enforcing requests for the discovery of materials, note it says materials, not source identities, and courts faced with enforcing requests for the discovery of materials used in the preparation of journalistic reports should be aware of the possibility that the unlimited or unthinking allowance of such requests will impinge upon First Amendment rights. In determining what, if any, limits should accordingly be placed upon the granting of such requests, courts must balance the potential harm to the free flow of information that might result against the asserted need for the requested information. So what are the factors that the court should look at when conducting an analysis under Rule 17 and under the balancing test? Taking Rule 17 first, set out in the LaRouche case, they cite the Nixon case where the Supreme Court ruled that in order to require production prior to trial, the moving party has to show, number one, that the documents are evidentiary and relevant, number two, that they're not otherwise procurable reasonably in advance of trial by the exercise of due diligence, number three, that the party cannot properly prepare for trial without such production and inspection in advance of trial, and that the failure to obtain such inspection may tend unreasonably to delay the trial. And number four, that the application is made in good faith and, critically, is not intended as a general fishing expedition. In short, the court was explaining that the special prosecutor in Nixon was required to clear three hurdles: relevancy, admissibility, and specificity. And the court held in Nixon that there was a sufficient likelihood that the tapes contained conversations relevant to the offenses charged, and sufficient preliminary showing that the subpoenaed tapes contained admissible evidence. In this case, however, there's been no showing that the handwritten notes contain information relevant to the offenses charged, and no showing that the handwritten notes contain admissible evidence. When you apply it to the facts of this case, there is uncertain relevancy of the information in the off-the-record notes. Not seeing them, it's hard to know whether they're relevant or not. But there's no specificity whatsoever in the form of a preliminary showing by the Commonwealth that the notes contain admissible evidence. Compare that to the materials the court ordered disclosed. The court found that there were indications in the redacted audio tapes that when unredacted, the tapes would contain relevant and admissible evidence. That's on page 5 of the court's order, which says the Rule 17 standard is satisfied, not only based on the tape. But there's no examination whatsoever of whether the interview notes would be anything more than a fishing expedition. To the contrary, the fact that nothing from that interview that resulted in the handwritten notes, nothing from that interview was used in the story. And that would suggest that the interview did not contain significant relevant information. As to the balancing test and the First Amendment interests, here too, the December 5 order ignores the on-the-record, off-the-record distinction. That distinction matters. Confidential information is extra protection because, as stated in LaRouche, disclosure of such confidential material would clearly jeopardize the ability of journalists and the media to gather information and therefore would have a chilling effect on speech. The court in LaRouche identified First Amendment interests that militate against disclosure of confidential information. One was the threat of judicial intrusion into the news gathering process. Another was the disadvantage of a journalist appearing to be a research tool for the government. Number 3 was the resulting disincentive to keep outtakes, or in our case, keep notes. And number 4, the burden on journalists' time and records and resources in responding to subpoenas. And if you look, Your Honor, at the affidavit of Chris Vogel that was submitted with our original opposition, he talks about each of those factors in his affidavit from paragraphs 13 through 18. He says he worries that compelled disclosure may lead to a public perception that Mrs. Voss is taking sides in this case or is acting as an investigative arm for the judiciary. Trust in the news media is already fragile because reporters compile information for a living. They will always be attractive targets of discovery for one side or the other. The unrestrained use of subpoenas to compel testimony or documents from reporters will create or reinforce the impression that objective journalists are working as agents of the government or the defense. The Fourth Estate can only serve its role as a pillar of democracy if it has the public's trust. Second concern that editor Chris Vogel pointed out in his affidavit is that another risk of compelled disclosure is that if it becomes easy or routine to subpoena journalists to hand over their interview notes, the legal and administrative costs of battling or complying will chip away at the precarious resources of much of the media. A third factor that was concerning him was that easy allowance of media subpoenas also risks leading to a decline in investigative journalism altogether. This is the most expensive kind of journalism. Reporting, writing, editing, and fact-checking investigative pieces take significant time and resources. Magazines like Boston Magazine will not be able to risk becoming enmeshed in situations such as this one, with the result that they shy away from controversial topics and the flow of vigorous reporting will suffer. We'll feel we have no choice but to select tamer, less controversial topics for our coverage. Another concern expressed by Editor Vogel is that reporters will be incentivized to destroy notes and interview tapes after a story is published, and that could harm the news outlet if it later needs to follow up on that piece. A fifth consequence is that reporters may tend to be circumspect in the way they gather information, in the way they conduct their interviews, and not be so vigorous in their questioning of sources and their documenting of interview notes, aware as they will be that their work may become the subject of public and judicial oversight. And finally, one factor that separates this case from many other cases out there is that Gretchen Voss has been the subject of invasive vitriol simply for writing about this controversial and very public matter. Public disclosure of her interview notes in this case risks putting her again in the limelight. Now, the court mentioned in its ruling that it appeared that she was no longer in fear of harassment because she had attended every day of the trial. I would submit that that shows that she was dedicated to covering the trial, come what may. She tells me she has in the recent past gotten more pushback on social media, including the fact that one commenter on Facebook, who I won't name, posted her personal telephone number for everyone. And the commenter to that post suggested I'll call her right away. And she's received several strange phone calls since that time. Because of the disproportionate harm to First Amendment and Article 16 interests caused by production of the confidential interview notes, we ask this court to consider its December 5 ruling and deny that part of the Commonwealth's motion that seeks those notes.
All right. Thank you very much.
Thank you, Your Honor.
I do have one point to make to you, Mr. Burt. In the amicus brief or the memo that was filed this morning, I just want to be clear that I am not looking for Ms. Voss's own interpretations as well as her likely impressions and thoughts about the interview and overall story to be provided. But it makes sense to me, and I'm going to hear from the Commonwealth, and if you want to respond first, that any information that reflects or relates to conversations with the defendant must be turned over.
I'm not sure what the question is.
So I'm not looking, the amicus brief and your argument suggests that if I order these notes to be provided, and just to be clear, I do appreciate that they were provided to me to review in camera. So I can see a distinction between what I'm being told that generally all notes reflect the author's interpretations as well as her likely impressions and thoughts about the interview and overall story. That's not what I'm considering releasing. But I think in this criminal case, the Commonwealth has proven that any material that reflects or relates to communication with the defendant must be turned over. So what I'm going to propose is that I do believe that there's some material in these notes that I don't need to provide to the Commonwealth, that I don't need to order be provided to the Commonwealth, that are just sort of observations. It's the communication between the defendant that's critical here. So I'm going to give you the opportunity to propose redactions to me. I have the notes, and you can propose redactions to things that are not reflective of communication with the defendant, observations, things of that nature.
Well, Ronna, there's nothing in the interview notes that is reflected in the story except architectural details, that there was a rosary on the bureau and the wall was blue, or whatever it might be. And I went through the notes with this question in mind. Can you separate the impressions, integrity of the thoughts of the writer from the statements of the interviewee? And I don't think they're distinguishable. I think they're all melded together in one. And frankly, it's her selection of questions that she asks Ms. Reed that gives an eye hole into what her thoughts are about the case. She shouldn't have to produce that work product. And the Commonwealth hasn't shown that there's any more relevancy to these conversations with Gretchen Voss than there would be with any other conversation that Ms. Reed had with anyone else. There's no reason for the Commonwealth to be going after Gretchen Voss as a reporter for this, other than the fact that she's a reporter and she's done the investigative work already that presumably the Commonwealth has already done.
Okay,
Thank you.
thank you. Commonwealth?
Your Honor, I'll simply say we defer to the court's judgment and whatever limitations the court imposes. I have no further argument.
Okay. All right, so I'll take this under advisement. Thank you.
All right, so that's handled now. The second issue.
So, paper 442. This is the Commonwealth's motion for reciprocal discovery pertaining to employees of ACA. And I know from when we were last in court, the Commonwealth was perhaps having conversations with the federal people to see if you could get anywhere with this. Is there anything I need to know in that regard? And if we need to do it at sidebar, we can do it at sidebar.
I don't think there's a need, Your Honor.
Okay.
Although it's not incumbent on the Commonwealth to pursue Rule 14 discovery of a party that's going to proffer an expert, Commonwealth made best efforts anyways. I filed a TUI letter, and I was unexpectedly not disappointed when I received a response last night. It's insufficient, it's inadequate. So the issue of pursuing Rule 14 discovery through the proponent of the expert, that being the defense in this case, is something that is a matter we're going to have to address.
Okay.
I did speak to the defense this morning. Since the TUI letter came last night, they have, I don't want to speak for them, but have asked if we would consider some time so they can respond. I am content if it gets deferred until the next date, but it is an argument that needs to be made.
Okay, who's arguing now for the defendant?
Good morning, Your Honor.
Morning.
I agree with Mr. Bennett's recitation of our conversation this morning. If it pleases the court, we did get that TUI letter. I was copied in on that letter late last night. Reviewed it last night. I think that it'll be incumbent for me to at least analyze that letter in a little bit more detail and utilize that letter in my response to the Rule 14 argument. So if we could have another date.
Sure. Well, we have next week, Thursday and Friday scheduled.
That's what I was thinking.
So we'll do this next week and come up with proposals on how we can certainly not violate anything that the federal court has said we can't do, but ways that we can go about it.
We'll be mindful.
All right. So if you can work on that, I'd appreciate that.
Sure.
So I will take the lead from the two of you on that.
Thank you.
Okay. All right. So this brings us to the Commonwealth's motion to exclude defense witness Richard Green's debunked opinions. So I have received a great deal of pleadings on this. So the Commonwealth's motion, and there was a affidavit attached, a report attached from Mr. Whiffen. The defense has filed an opposition, an affidavit from Mr. Green, and then another affidavit from Mr. Green that doesn't, they're two separate affidavits. And the affidavits are clearly different in substance. So I'm a little, I don't know what you want me to think about that, but why don't we hear the Commonwealth on its motion first?
Hank Brennan, baby. Woo!
May it please the court, we filed a motion to exclude Mr. Green as a witness regarding 2 points. The first is a claim that a witness's phone made a search for a phrase to the effect of how long to die in the cold at 2:27 a.m. And secondly, to exclude an opinion that there was some type of intentional deletion of that entry. This case, I propose on behalf of the Commonwealth, is appropriate for a Lanigan hearing. At that Lanigan hearing, I suggest that Mr. Green should testify and answer questions about his affidavit and his opinions that he would like to subject the jury to. In fairness, the government would call an expert as well. This case, as the court proposed, potentially scheduled for next week. Mr. Whiffen would not be available, but Ms. Hyde would be available, and I would call her as a witness. Mr. Whiffen, if necessary, is available later in the month as a witness. My suggestion is there should be 2 witnesses, Mr. Green and 1 witness from the Commonwealth. The Commonwealth witness will be able to explain the science, the data, forensic science, and methodology. And Mr. Green, I suspect, should be in a position to explain his ultimate opinions because what we see in his affidavit is an absence of methodology. Mr. Green has filed 2 affidavits in this case. They are very similar, but there are very significant changes to those affidavits. And it stands out as very interesting, the changes to the affidavits, when I look at them. On number 3, he changes his characterization of what his profession is. He originally calls himself a forensic technician, and then the updated affidavit cites that he's a computer network technician. Now that is odd because usually a professional knows what they do for a profession. Simple explanation of what he does stands out. Also stands out when using technical terms. They either were wrong or changed from the first affidavit to the second affidavit. For example, number 9, he talks about the download as a full file system extraction, then changed to an Apple iOS full file system. My point is that when you look, this isn't simply misspellings or poor grammar. There are terms of art that are wrong between the affidavits or changed. When you're using the terminology of an item that is a forensic tool, such as gray key, it is spelled wrong throughout the affidavit. And so it seems to me that Mr. Green's affidavit had some assistance in building it. And the tone of the affidavit supports that thought. When we look at Mr. Green's affidavit, it is not that of a forensic examiner, it's that of an advocate for the defense. When we look at his affidavit, there is quite a bit of advocacy, insinuations and surmise and conjecture and claims that have no factual basis, but there is little on methodology. In ways, it is a very dangerous affidavit to simply make assaultive comments that a user did something, purposely deleted a very important phrase, how long to die in the cold, without any forensic data or evaluation or validation. Similarly, when we look at his affidavit, it is replete with accusations suggesting, but never proving, never providing fact, that there was some type of manipulation or tampering with evidence. Now, this is not the role of a forensic examiner unless there is proof, in fact, that happened. But when we look through his entire affidavit, we don't see any attachment of raw data. We don't see an updated report. We don't see any viable information that in any way supports his speculative accusations. And so the defense, without having an opportunity for Mr. Green prior to trial, stand behind these statements under oath, would like him simply to come before the jury, make these salacious comments, and then leave it to the government to knock it down. And that might be a common view in the transcripts of this case, but the Commonwealth does not intend to simply let evidence come in that's not qualified, that's not factually sound, and then go knock down glass houses. That is not the approach the government is going to take to this case. Mr. Green is going to testify. He should have a report that is factually based with methodology supporting these claims, these narratives that he's proposing. Considering testing in this case, there are certain tools that are used. The defense wants to propose that there is some type of race that Mr. Green looked at or used more tools than a Commonwealth expert. The tool is simply software. A good analogy is that of an X-ray. Anybody can take an X-ray, but it takes an expert then to interpret the X-ray, to interpret the data. In this case, Mr. Green, in his affidavit, proposes that because he used a number of tools, because he has a number of X-rays, that somehow there's significance to it. But what it lacks is a forensic analysis of that information. And it is clear in his affidavit that it lacks that. He cites two opinions. His first opinion is based on Cellbrite processing and Axiom processing. I'm not going to go through all the little details that we dispute or go through a technical assault on each point, although that the overall idea of this evidence is why this should be subject to a Lanigan hearing and why we are willing to call our own expert as well, so that the record is clear and the science and data is clear. Instead of doing validation or testing, relying on Cellbrite, what Mr. Green has done in section number 13 of his affidavit is step aside from methodology, and instead he cites that he called Cellbrite technical service. Now, this is the forensic examiner who is supposed to go through the process, and yet he defers it to technical support of Cellbrite. Technical support in Cellbrite, he relies on to say that this artifact where this search is stored is appropriate. And he remains standing on that foundation as why somehow there's some validation that this search occurred at 227. But then when he learns that Cellbrite, after actually doing analysis and study and updates and engage in methodology and review, determined that the way that was assessed is unreliable and the program has been updated, which no longer shows the 227 search at 227, and I'll explain why for good reason, and I'm sure the court has heard this before. Mr. Green then denounces the very source that he relies on. And so on one hand, he's saying, I relied on technical assistance of Cellbrite, but then when they told me what I didn't like, I can ignore that part. He then defers to Axiom. Axiom, the government, the defense touts, is a separate source that reinforces the same point when clearly it doesn't. You can see in number 14 of Mr. Green's affidavit, he talks about the fact he uses these different programs because he wants to view data. And that gets back to the X-ray analogy. He is viewing data from many different programs that say the same thing, but he never goes on to analyze it. What is troublesome about his affidavit in section 14 is he attempts to use resource material to convince this court that rather than methodology, these summary statements are something that the court should rely on. And so what he does is he takes an excerpt, page 7 of his affidavit, number 14, and he says that the Axiom user manual describing the artifact as follows, that the artifact is in Safari suspended state tabs, and then has the last interaction date time, and the date and time of the current tab state when it was last interacted with on the local device. And so he's taking a piece of the manual, they don't introduce the manual, and he tries to use that to buttress that this search happened at 227. What you're not offered is that in the Axiom notes, in their artifact reference guide for the description of Safari suspended state tabs, which he's referring to, and this is the death knell, really, for the analogy that the defense tries to make. The Safari suspended tabs contains the current state of each browser tab in Safari that is currently open on the local device. The date and time are only updated when the user interacts with that tab on the local device. Since these are local tab states, results from the artifact may contain an earlier date and time compared to the results in the Safari history artifact if multiple devices on one iCloud account. And so by Axiom itself, it makes clear that an artifact in a tab can reflect a time that is much earlier than the actual search. And this has been presented to the court. We've provided the trial transcripts of Ms. Hyde and Mr. Whiffen. When a tab is open, many tabs can be open. It is open at a particular time. And if that tab is reused, the original time will imprint. And so certainly Mr. Green knows of the Commonwealth's argument. He knows of the opinions by Mr. Whiffen and Ms. Hyde because he takes shots at them or makes mention of them in his report. And yet he does nothing as far as validation to consider the arguments and dispel them. He does nothing in his affidavit to address the methodology. Quite to the contrary, when you see Mr. Whiffen and Ms. Hyde's reports, it isn't baseless opinions and advocacy of a side. When you look at their reports, it is replete with methodology, fact-based, information-based, the study of the particular device at hand. The contrast between the actual use of methodology that is reflected in Ms. Hyde and Mr. Whiffen's report and this affidavit is so clear. Now, there are two opinions that are proposed pursuant to this affidavit. The first is the claim that how long to die in the cold was somehow inputted at 2:27. The only effort that appears in this affidavit by Mr. Green is in section 15, where he did a low-level analysis of the wall file. Now, I am not an expert, and that's why the court should hear from Ms. Hyde or Mr. Whiffen and Mr. Green. But a simple understanding, wall file can contain information as a repository. And the description or misunderstanding by Mr. Green of the wall file is clear in his affidavit. In fact, he implies that there were 3 searches in his affidavit, number 16. Let's look at this phone that there were 2. Surprised that his second opinion is an attempt really just to create confusion, to disparage, and to make claims that are factually untrue. It's necessary to have this claim because number 1 doesn't have any resonance. Somewhere, somehow. Not an uncommon. The claim or the opinion number 2 the defense would like the jury to hear is that somebody somehow, whether it was a person, presumably the witness in this case, or the police somehow manipulated the phone. I dare say there's no evidence to support that. And yet, in an affidavit under oath to the court, in an attempt of advocacy, this witness is comfortable and willing to promote a claim that has no factual basis. If a witness, an expert, is going to promote in an affidavit a claim with no factual basis, we should not trust, without vetting that witness, that their other claims have any merit or value. In opinion number 2, this expert, so-called expert, takes the liberty to say that the McCabe cell phone could have been manipulated. Not that it was, not that I did a study, not that I have a fact. It could have been manipulated, then rehashed after manipulation with the PDF being modified. Wow. It's an extraordinary conspiracy in the world of forensic science to be able to accomplish all of those tasks. So if he has no basis in fact or methodology, no good faith basis to make this assertion, why is he? Why is he? It is because the claims he makes in opinion number 1 are so scientifically and forensically unsound. This is a tactic to confuse the issue. And think about the import of this baseless claim by Mr. Green. It is suggesting that a witness with no other evidence whatsoever, was involved in a conspiracy to murder somebody. That's the implication that he wants the jury to be confused by. Otherwise, there'd be no other reason to make the suggestion. That is an extraordinarily harsh claim when you don't have any facts. Now, how could one cause manipulation? There is scientific ways that could be explained how manipulation could occur, but we don't see any of that in this affidavit because it didn't exist in this case, because there was no deletion or manipulation by the witness. There was no manipulation by the police who processed this phone. If there was, there would be some proof. This affidavit speaks volumes by the absence of fact and data and science. Mr. Green does nothing to try to demonstrate that there was user deletion on this phone or that there was manipulation by the police. When you look at the data in the phone, the question arises, why is there a 624 search and not a 623 search? The phone stores the last entry into the tab. It's not just science, it's common sense. Common sense that Mr. Green ignores. And so not being able to prove user manipulation because it didn't happen, he turns to police manipulation. And he says that there can be a problem where the hashes don't match, but the problem is the hashes do. They match. He complains that he did not receive the PDF when he received the download. And because there was a production at different times, he then sprints out into a different universe and suggests that somehow it must be because there's manipulation. And again, doesn't prove it. There's actually ways that a real forensic examiner can look at the PDF, gray key file, and the phone and determine whether manipulation occurred. There's a program called XMP and another one called Magic. Most expert witnesses went through that process. No manipulation. But Mr. Green doesn't even go through the process to disprove his own theories. If he used methodology, he could simply dispel his own claims. It's either he doesn't understand the forensic technology to do that, or he chooses not to do it so he can just posit hand grenades throughout the case and let them resonate wherever they fall. In an attempt to create some doubt or uncertainty or merit some conspiracy, he lists a number of what he calls anomalies, which are really not anomalies at all. I could go through each one of them. I could give a difference of opinion. I could show that Mr. Green's anomalies have no basis in fact, but suffice to say, I think this should be done by qualified experts, and that's why there should be a Lanigan hearing. There is such misunderstanding of forensic science in Mr. Green's claims and anomalies. If he's going to make these assertions before it goes before a jury, he should sit in the witness seat under oath, as the Commonwealth witnesses should as well, and he should justify, explain to the court why he did not engage in methodology and how he has come to these extraordinarily baseless, inaccurate, and prejudicial claims. The Commonwealth has to, the court rather, has to look at Lanigan and whether or not a hearing is appropriate in this case. When we look at the different non-binding factors of Lanigan, we look at number one, whether it has been generally accepted in the scientific community. The software has been generally accepted in the scientific community. So hasn't the effort of a forensic examiner, the expertise. And the defense complains in their motion, the Commonwealth has not properly addressed the methodology of Mr. Green. Well, the reason why is Mr. Green does not provide any methodology. So this is the way to address the methodology. Number two, the opinions have been or can be subjected to testing. Well, we see Ms. Hyde and Mr. Whiffin's report directly contradict the assertions, the unsupported assertions of Mr. Green. There is no testing that his opinions have been subjected to. There is no peer review. There's no other alternative support for his opinions. They're just broad, baseless claims. Number
Nope.
3, has been subjected to peer review and publication. Certainly the science, the forensic science has, the software has, but the interpretation and Mr. Green's interpretations, it hasn't been subjected to anything. In fact, it changes. Has an unacceptably high known or potential rate of error. Well, if we see and read Miss Hyde, and it's just a high level of error. It's gross error. It's total error. It's wrong. And is governed by recognized standards. Well, if you look at the history report that the defense filed as an attachment, it talks about a forensic examiner's obligations to verify, to test things that Mr. Green didn't do. Their own report that they offer in support undermines the idea that Mr. Green did anything to validate or support his opinion. And as we see from both Selbright, he does not follow the protocol. He does not follow Axiom or the guidance that they give him. He sidesteps both of them to give the opinion he wants to advocate for the defense. At every turn, positions of Mr. Green are not only unsupported, they're unverified. And so what arises from this subterfuge is that Mr. Green is really just a vessel or an attempted vessel for the defense, third-party culprit defense. It is not lost on me, I'm not unmindful of the data on the phone being a search how long Diana Cole that occurred after 6 a.m. in that morning coincides with first responders' testimony that the defendant herself was asking these very same questions around that time about Mr. O'Keefe and how long he could survive Nicole. Under the extraordinary broadness of circumstances in the depth of the amount of witnesses and information in this case, it is hard to think that that just happened by happenstance, that there is a inquiry, something forming in the mind of the accused is then shared with the witness, Ms. McCabe, and in response, she makes the search, which is entirely supported by all the credible forensic evidence. If Mr. Green is going to be a witness in front of the jury, in light of the fact that he has no methodology and he's wrong on the science, in addition to the fact that he wants to now appear as advocate for the defense and accuse everybody and anybody without articulating who, just anybody other than the defense, he should have to stand behind those claims under oath. And so I'm asking for a landing and hearing. We are not shying from our burden. We're more than happy to bring in a witness so the court can contrast the two. Thank you.
All right, thank you. Mr. Lessing?
May it please the court. Mr. Green is eminently qualified to provide testimony in this case with regard to the subject matter that has been challenged by the prosecution in this case, and that is with regards to the search of House Long to die in the cold that occurred at 2:27:40 a.m. on January 29th, 2022. Mr. Green, and I want to cover the baseline for this hearing first. Mr. Green testified at the first trial. He testified without objections as to his qualifications. He testified without objections to his methodology. Your Honor sat, obviously, and presided over that trial. Your Honor did not issue after his testimony any limiting or curative instructions with regard to either his qualifications or methodology, nor did the prosecution after his testimony stand up and ask for any such limitations or qualification. The baseline for his qualifications and methodology was established, again, without objection. And
But they are being challenged now.
I was just waiting, Your Honor. They are being challenged now, but the reason I state that is because what Mr. Green has provided in response to this motion is even more detail than what happened in the first trial. In Mr. Brennan's argument, he did not make one argument about Mr. Green's qualifications. Zero. So I'm assuming, because there's nothing in their motion that even goes into why he might not be qualified. So to me, Your Honor, that's a tacit concession, if not expressed, that he's qualified. And of course, he has to be qualified in digital forensics because there are 5 other areas of digital forensics opinions and methodology that Mr. Green is testifying about that has not been challenged. So to me, it is rather odd right off the jump that there's no challenge to 5 other areas of data forensics, and there's just this challenge to one aspect of his whole testimony and opinions. I have provided Your Honor with 2 exhibits demonstrative in support of my oral argument. Exhibit 1 is entitled Digital Forensics Methodology Regarding Subject Artifact, and Exhibit 2 is entitled Digital Forensic Product Tools Used by Witnesses. The Commonwealth has agreed to my use of those exhibits. They had some, I agreed to theirs. And I would like to, Your Honor, use those in a moment. The Commonwealth, in its oral argument, said 10 times just now that there's no methodology and that Mr. Green does not articulate a methodology. That is incredible to me because the opposition and Mr. Green's affidavit, in fact, are replete with the methodology. And here is the key, Your Honor. While Mr. Brennan challenges the methodology, none of his witnesses, neither Mr. Whiffen nor Ms. Hyde, challenge the methodology. As a matter of fact, in their 2 reports, neither of them even describe Mr. Green's methodology, nor do they challenge it. And of course they can't, because it's the same exact methodology that they use. And that's what I would like to go to now. Exhibit 1 is entitled Digital Forensics Methodology Regarding Subject Artifact, J. McCabe iPhone Data. And I prepared this. This is just what's in our opposition. It's in Mr. Green's affidavit, but it summarizes what the methodology is that we're talking about here. What is that methodology? Step 1, you receive, and this is to answer the question about what is the proper interpretation of the artifact in question that everybody agrees is the artifact. Step 1, receive a full file system image of extracted data from the Commonwealth. For example, the defense received it on a USB thumb drive. That's undisputed. If you look at the reports of Ms. Hyde, you look at the reports of Mr. Whiffen, they all say they received a full file system image of extracted data. So step 1 in the methodology that everybody agrees to, everybody agrees that occurred. Number 2, verify hash signature value of image file of data received. This is very important because hash values with regard to forensic data is extraordinarily important for it to be proper because it's the signature, the fingerprint that allows data forensic examiners to be sure that the data that they're giving is sacrosanct. It is not possible for manipulation. The Commonwealth just said that Mr. Green has hurled several accusations without a basis, one of which regards the potential for manipulation of data. And it's remarkable that there is even an issue about this dispute. Mr. Green did put in his affidavit an unprecedented situation, and it is this. Mr. Garino, Trooper Garino, in his April 2023 report, which is an exhibit to our opposition, states that when he got the phone of Ms. McCabe, he used Celebrite UFED, a tool of Celebrite, to image the phone. And that's all he sent to the defense in the beginning. Why is that unusual? Because what happens in every case, without exception, is that the law enforcement sends the raw image, original data that has the hash signature on it. And the hash signature is an algorithm that produces, they call it, in this case, SHA-256. What it is it's a stamp of reliability that says, as soon as we got this data, we immediately processed it the proper way and put a hash signature so that there can be no contest. What the Commonwealth fails to tell the court, Your Honor, is value, and that leads any proper data forensic investigator to question the integrity of the data. If you turn to, Your Honor, Mr. Whiffin's very long December 2024 report, which is Exhibit 1 to the Commonwealth's motion on page 3, and I'm going to read it verbatim. This value is talking.
What the fuck, long crime?
Here's the key point. However, this requires authentication of the original hash value, which is not possible with gray key extractions, as the PDF containing the extraction hash value is unsigned. Therefore, this hash value could be used as a suggestion of authentication. That's all a fancy camouflage way of saying, Mr. Whiffin saying, I can't validate this hash value because of the way Trooper Garino processed it. Do it, Mr. Garino, Trooper Garino, the right way when he got it. And why is this of concern? Add to this point that's conceding that the hash value in this data cannot be validated. How did the defense get this? When Mr. Garino used the Celebrite UFED reader, all he turned over in the beginning was the UFED reader report. He didn't turn over the data, the full. So Mr. Green had to ask for the data. Then what happens, misstep number 2, Trooper Garino only provides a PDF of the hash value. He used gray key, which was a mistake, because gray key, you can't get the original hash value. Mr. Green had to go back a second time and say, no, we don't want just a PDF. We want the full extraction. Finally, after the second time, the defense got the full extraction. And that's when we discovered that the validation was improper. It's not Mr. Green that is coming up out of thin air with these issues. This is the job of a data forensic person, and the first principle is to see whether the data is valid. So not only does Mr. Green justify in his affidavit why there's a big concern over this, Mr. Whiffin concedes it on page 3 of his report. That starts, and I'm going to get to it, all the concerns now about the data and deletions But that's the foundation for it, and it wasn't caused by the defense. It was caused by Trooper Garino, who didn't do this properly. And with regard to the methodology, I want to go back to Exhibit 1. So, importantly, Your Honor, 1 through 4 of this methodology is undisputed by all of the data forensic persons. Mr. Whiffen, Ms. Hyde, and Mr. Bean all agree on 1 through 4. They all agree that this is the methodology. Number 3, once you get the image of the file, each examiner saves the image to their lab storage system. Some use computer servers, some cloud storage. And 4, the methodology, you then process the data with appropriate tools. Nobody disputes that Cellebrite Physical Analyzer and Magnet Forensic Axiom are 2 of the many tools that are available to use. There's a dotted line that I've put there, Your Honor, because 1 through 4 is undisputed by all 3 data forensic examiners. Number 5, and 1 through 4 is usually all one needs to do as a data forensic examiner, but Mr. Green went on to do more. Number 5, further processing of data as warranted, and he explains why it's warranted here, with additional tools. So he then went on to use Sanderson Forensic Browser, ArtX, Belkasoft X, and then he didn't use iLeap, Ms. Hyde used iLeap. So it's important to line up the methodology. I just don't understand how it can be stated that there's no methodology stated. Not only does Mr. Green state it, we prove undisputed that everybody agrees this is what the methodology is. And that is what is so flummoxing as to why we're even here, because the methodology is agreed upon. What is disputed, Your Honor, is what are the opinions from when you apply the methodology and you apply these tools. So, interestingly, it is Mr. Whiffen who provided the most lengthy report in this motion. Mr. Whiffen only used 2 forensic tools. He only used Cellebrite Physical Analyzer and his own software, ArtX. That's it. What I'd like to, Your Honor, is ask if I could, please, if you could turn to Exhibit 2, which is entitled Digital Forensics Products Tools Used by Witnesses. And I just want to make sure Your Honor has that.
Thank you, Karen.
Okay.
So I prepared this demonstrative exhibit to show the tools that all parties used. And the purpose of this is to show how closely Mr. Green and Ms. Hyde match up with the tools used, and how insufficient Mr. Whiffen and Mr. Garino are. So if you look in the left-hand column on Mr. Green, and I color-coded it to try to make it easier, you see 7 tools used by Mr. Green. You see 6 tools used by Ms. Hyde in May of 2023. Many of her tools exact same as Mr. Green. You see Mr. Whiffen, who used really 2 tools, but to be conservative, I listed them as 3 because they're just different versions of Cellebrite Physical Analyzer. And then Mr. Garino, Trooper Garino, used 2 tools. But here's what's really important and I think remarkable that springs from this chart. Mr. Green did more, had a more encompassing and comprehensive review than any of the witnesses here. And back to Exhibit 1, he did 2 more steps in his methodology than everyone else. So 1 through 5 of the methodology, everybody did. 6 is analyze overall user activity, artifacts of interest, timelines of interest, and anomalies such as deleted data. 7, reporting as appropriate pertinent artifacts, other artifacts. For this motion, Mr. Green did 6 and 7, and no other witness did that. The issue in this case as to whose interpretation is correct is an opinion issue. It is not a methodology issue. And Mr. Green makes that very, very clear in his affidavit that the difference is in opinions. Interestingly, on the very key subject of whether the artifact and the interpretation of it is a difference in methodology, a difference in application of methodology, or an opinion, which is not the subject of a Daubert-Lanigan hearing. Opinions are not. Here's what Mr. Whiffen had to say about the issue. This is Exhibit 2 to our opposition. It's the June 17, 2024 testimony of Mr. Whiffen, page 1-10, starting on lines 14, the question. And what, if anything, did you find with regard to the web history artifacts? Answer, this is Mr. Whiffen. So the 2/27/40 timestamp was correct insofar as that is the time that is shown within the database. It was indeed a deleted record. But the interesting thing was why the timestamp said 2/27/40. And I did some testing on this and discovered the reason why 2/27/40 was actually listed in the database, even though that's not the time. Here's the key, in my opinion, that the search was conducted. So Mr. Green's opinion is, after applying the methodology that everybody agrees to, after using the same tools as every other witness for the Commonwealth used plus more, Mr. Green's opinion is, to a reasonable degree of scientific certainty, that that search and that record that everybody saw at the time of trial at 2/27/40, House Long to Die in the Cold, Mr. Green says it means what it says. The search occurred at that time. Now, the Commonwealth, in its recent reports, and they did this also at trial, they said, yeah, we see it, it's in there. Ms. Hyde said, I see it. It's not only in there in Celebrite Physical Analyzer. I used Axiom, just like Mr. Reed. Mr. Whiffen didn't use Axiom. Ms. Hyde said, and I'm going to point to it specifically, Axiom shows it as a 220, that search is a 224. In fairness to trying to get the best decision for Your Honor here, they disagreed, Mr. Whiffen and Ms. Hyde, as to whether that meant the search actually occurred at 2/27/40. That's the opinion that's disputed. So in fairness to the issue and accuracy, those witnesses diverted at the end as to whether what that timestamp showed, 2/27/40 a.m., did the search really occur then, or as the Commonwealth said, did it occur at 6:23 in the morning? Mr. Whiffen says it's a difference of opinion because he says it's my opinion. The Commonwealth in this motion tries to make it seem like it's an issue of fact, and that Mr. Green doesn't have any fact. Well, Mr. Green's got a lot of facts, and he also, of course, has an opinion. So what we have from these two demonstrative exhibits, Your Honor, is a statement of the methodology in Exhibit 1 that every witness agrees to. Not only is it Mr. Green put a methodology, but we prove up in the opposition that there's no dispute. What's interesting, Your Honor, and I think quite remarkable, is that neither Mr. Whiffen in his 40-plus page report of December 24, nor Ms. Hyde in her December 24 4-page report. Neither one of them say Mr. Green's doesn't have a methodology. They don't say we dispute his methodology. It's the Commonwealth's attorneys that are making that dispute. And that is not appropriate. It's got to be your expert. And I think there's a reason why the experts of the Commonwealth are not talking about methodologies or saying there's a dispute, because it's objectively verifiable that there's not a dispute over the methodology. What is also important is what has happened since the trial. And what I want to do is give a baseline of the trial, because I think it underscores the two issues that Your Honor have in front of you: qualifications and methodology. And the qualifications, all I'm going to say about that is Mr. Green has 25 years of experience in computer forensics, and he has 18 years in digital forensics. And the 18 is only because digital forensics became a thing 18 years old. There can be no dispute, and I think that's why the Commonwealth didn't really say anything about it, is because if you lay down Mr. Green's experience next to Mr. Whiffen, Mr. Green testified 23 times as a qualified digital forensic expert in 7 different states. Mr. Whiffen, he's testified in 2 states, one of which was here, and he does not have anywhere near the years of experience. Here's another very important point: certifications. Mr. Green lists 3 certifications. He lists an enormous amount of constant updating. And I just want to state a point about digital forensic experts. They're not like medical doctors where you see people with PhDs, etc. These are folks that keep updated because the computers change so much. So that's why you see such a great listing of Mr. Green in terms of his training in certificates, etc. However, if you compare Mr. Whiffen's qualifications to Mr. Green, and I'm again going to use Mr. Whiffen's own words with regard to his qualifications on his June 7th, this is again Exhibit 2 to our opposition, his June 17th trial testimony, page 1-6. Question, and this is a question from Mr. Lally. Now, with regard to your education in this area, what, if any, certifications do you have?
What, if any?
Answer, no specific certifications. I've done the Celebrite coursework since joining Celebrite, but other than the 3-week course in Ottawa, and then again the 2-week course in Ottawa, those are police training things when he's a policeman. I don't have the SANS training or any of that kind of training certifications. Now, I am not here today to challenge Mr. Whiffen's qualifications, but how could it possibly be asserted that Mr. Green's not qualified if these are the qualifications of Mr. Whiffen? With regard to what has changed since the first trial, and I think this is incredibly important with regard to the methodology inquiry of Your Honor. I went through on Exhibit 1 the methodology that everybody agrees to, but the court doesn't have to take my word for it on this demonstrative exhibit, because Ms. Hyde gives the best explication of the methodology that Mr. Green used, because she used the same one before trial and at trial, but she's now narrowed it for purposes of a report, and I'm going to state and show exactly how. So Exhibit 4 to our opposition, Your Honor, is the May 2023 Digital Forensics Analysis Report of Jessica Hyde. And in that report, on page 3, she talks about, under forensic analysis, that she used It's the exact same methodology.
What are you, I thought you said Exhibit 4. Exhibit 4 is a transcript. It's a transcript of Ms. Hyde, but it's not a report.
Okay, my fault, we have different numbering, but I'll go to the transcript. I'm going to go to the transcript with regard to it. So
I'm happy to look at the report if that's what you're referencing.
I'm
but
going
Where
to
do I
go to the
find
report
it?
next, but if Your Honor's already at the, I can do it either way. If Your Honor is at the transcript, I'll go to the transcript right now. This is the June 14th transcript, Your Honor, of Jessica Hyde.
Yes.
Thank you. So we're just, and please keep in mind that in Mr. Hyde's 2024 report, that Mr. Whiffin's report that is now before you, Mr. Whiffin only used in his analysis now Celebrite Physical Analyzer and Ardex, his own tool. He only used 2 tools. Ms. Hyde, in her 2024 report, which I will get to, is now down to just using 1 tool, Celebrite Physical Analyzer, because she states that's the only one I was asked to look at. So the Commonwealth went and narrowed the request of Ms. Hyde to just Celebrite Physical Analyzer. And what is going on here? It's very obvious. The Commonwealth is ignoring in its 2024 December reports all the other tools. Even though those tools show this timestamp of 2/27/40 still, at that time, they now just ignore it and go to the Celebrite Physical Analyzer. That it's undisputed that Celebrite went back and changed it in the middle of the first trial with regard to one physical analyzer program. And then after the trial, the other physical analyzer program, they went and changed that and took it off. But in contrast, Axiom, that Ms. Hyde used before, still shows the timestamp. It's undisputed that that's the case. And it's undisputed because they don't contest it, that Mr. Green went and looked at it in Belkasoft, Sanderson. He did a manual, he did a low-level analysis, and in every one of those tools, the timestamp still occurs. So now back to the transcript. Your Honor, I am looking at, the question of, and this is, again, a significant point, is it better to use more tools? It's common sense. That's what Mr. Green says. That's what Ms. Hyde did the first time, but now all of a sudden she's down to just 1 tool that unilaterally removed the timestamp. So here is the page of the transcript of what Ms. Hyde had to say. Page 1-13, Your Honor.
Okay.
Line 4, question, again, of Mr. Lally. Now, with reference to the tools that you use that you just went through, are those fairly common tools? Are those tools that are commonly used within your industry? Answer, yes. And what are those tools that she talks about above? Starts on page 1-2. Celebrite Physical Analyzer, Magnet Axiom, Artex, iLeap, and I later used Sanderson Forensic SQLite. Those are 4 of the tools that Mr. Green used, and he used more. So her answer is, now with reference to the tools, are those tools that are commonly used within your industry? Answer, yes. They are commonly used digital forensic tools that are very standard for other forensic examiners to use on mobile exploitation. It gets better for the defense. Next question, line 15. So different forensic tools, question, and why were you using the different tools? So different forensic tools have different capabilities and look at data a little bit differently. Skip down. Commercial forensic tools that they can only support so many applications, so they each work and support different bits of data. Here's the key point, line 22. This is Ms. Hyde's words, under oath. So it's important to use multiple tools so you can see the results from different different data sets, and be able to compare those results and enhance those with manual analysis. Next page. Question, and with respect to, and this will be the last question and answer, and with respect to using those sort of different variety of tools, Cellebrite to Axiom to Artex, etc. Is that something you typically do as far as your normal process of documenting a forensic analysis? Answer. Yeah, that is very, very typical for me to process with multiple tools to ensure that I'm getting the most complete interpretations from forensic tools. Of course, you go beyond that with your analysis, but it's absolutely pertinent. And down below, he asked, can you explain the interplay of these tools in analysis? And her answer is strikingly the same as Mr. Green in his affidavit and in our opposition. Her answer, the Sanderson's tool, which Mr. Green and Ms. Hyde used, but Mr. Whiffen didn't, is meant to look at specific type of data structures called the SQLite database. SQLite databases are very nuanced, and this particular tool allows you to take that database and explore it at a deeper level than the other forensic tools allow. Mr. Whiffen didn't use the Sanderson tool. So here we have Ms. Hyde, and in her report of 5/23, 2024, her first report, and I'm going to get to her report here, she basically goes through and documents this methodology, and she documents the use of those tools. And she also documents that she saw the House Long to Die timestamp 2/27/40 in every single tool that she used. Where she diverted from Mr. Green was her opinion as to whether that timestamp meant the search occurred at that time or did it occur sometime later. That's an opinion issue again, and Mr. Whiffen agrees it's opinion issue in that regard. So now let's come to where we are for this motion and what was submitted by the Commonwealth. And I want to first go to the report of Ms. Hyde now.
The defense is destroying. If this was like a basketball game, this is a second half blowout. I mean, this is insanity right now. This is
Exhibit 4 to the Commonwealth's motion. And it's entitled Digital Forensics Analysis Report. And there's been much said in the Commonwealth's argument this morning about allegations made by Mr. Green, which are all supported. Every single one supported with facts. But what the Commonwealth didn't tell the court is what the request was of Ms. Hyde. I just went through all the tools she used, why she used them, why she said it's best practices, why you use all these tools. What does she do now in December of 2024 to assist in the myopic approach of the Commonwealth to say, here's our studies, we only look at Cellebrite physical analyzer, and it's gone. The search is gone, right? And we know why it's gone, because Cellebrite, Mr. Whiffen, concedes that he went back and talked to the researchers, and what we have, Your Honor, is a total black box. And I'm going to point it out in a moment. Why is this no longer appearing on Cellebrite physical analyzer? We don't know the answer. All that is stated is a bald conclusory statement that it's no longer reliable. That's it. We don't know why it's no longer reliable, but we know it's gone. And Mr. Whiffen never says, even though it's gone in one, he doesn't even address the other 4 or 5 tools where it still appears. It still appears. Now to Ms. Hyde. Disquietingly, on page 3, look at the request, please. The request was to understand changes made in newer versions of Cellebrite Physical Analyzer to artifacts pertaining to the timeline of a Google search on January 29, 2022, namely House Long to Die in Cold. That is stunning. The request to her was simply to look at one tool that everybody knew by then Cellebrite had deleted in their program. She then looks at evidence analyzed, second paragraph. This full file system image was processed with Cellebrite Physical Analyzer, version blah, 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 decoding engine, etc. Where is her analysis of Axiom that was in her May 2023 report? Where is her analysis of Sanderson? Where is her other analysis that if she went and did it, she would have to say it's still there? So what she goes on to say is very interesting, but it's buried, and here's what it is on page 4. After she goes through and states what everybody knows is Celebrate just went back and for some reason deleted it, she says under the chart, while manual analysis of the database still shows a 2:27:40 a.m. ET timestamp, the determination in prior analyses and from Celebrate is that this timestamp does not demonstrate that the URL was visited at the time of the last visit timestamp. So here she did a manual analysis and it still shows up, but she doesn't explain the significance of that. If we want to talk about reliability, Your Honor, the real question should be the reliability of the prosecution's witnesses in Celebrate physical analyzing.
So are you telling me that we should have a hearing?
Your Honor, there's no need to have a hearing, and here's why. There's no need for a hearing because there's no disagreement on the Daubert issues. The dispute over what is the interpretation of this data, what are the people's opinions, is never one for Daubert. If that were the case, there'd be a Daubert hearing on every expert because experts, almost by definition on each side, disagree on the opinions. We don't need a hearing, Your Honor, because they agree on the methodology. They agree that more tools are better. They agree that the difference is at the very end of the analysis, which is the opinion. So in terms of the issues with regard to Mr. Green's report, which is my final point to get to, there's been so many mischaracterizations by the Commonwealth this morning of what Mr. Green did and what he said. So what does he do? He says, and Your Honor, digital forensic analysts are the equivalent of a medical examiner. Their job is to apply the methodology that is agreed to. Their job is to use the tools, everybody agrees on it, and then they're to give opinions on what those mean. And everybody here has the same data, right? Everyone's got the same data that they're using, so there's no dispute over that. The Commonwealth said that there's no factual basis for what Mr. Green did. There's a factual basis for everything, and it's undisputed. So everyone has the same data, and this I call the MB postulate. And the MB postulate is, why are people using different tools, etc.? Is because nobody has the source code for the Apple phones. So you use these tools to try to help interpret what these source codes mean. And it's an accepted methodology to do it. But the data, once it's produced, and we have an issue about what happened before it got produced, but in terms of the methodology that was applied here in the tools, there is no disagreement. So what, Your Honor, would an evidentiary hearing do? We're just going to come in and have witnesses talk about their difference of opinion? That's not what a Daubert is for. There's no basis for an evidentiary hearing because there's no dispute over the methodology. I've done a lot of Daubert hearings. I've never even gotten past a motion, let alone an evidentiary hearing, where the experts don't disagree on the methodology. So what is it that caused Mr. Green to raise questions? And again, I said data forensic examiners are just like the medical examiners. They don't look at just the body of the medical examiner. They look at circumstances surrounding it and all information. Well, that's
great
what
argument.
Digital forensic examiners do, and that's what Mr. Green did. So there's great criticism of Mr. Green from doing what is proper for a digital forensic person, And it's a bit of a camouflage, respectfully, because the December 2024 reports of the Commonwealth now myopically go down to just one tool. So what did Mr. Green say that caused him to say, I think it strongly suggests that there's been manipulation here? He used the fact that there's no hash value for the data. That's conceded. And when there's a issue over hash value, every single digital forensic expert is going to raise concerns about the validity of the data. And Mr. Whiffen is one of them who did that. Secondly, what Mr. Green pointed out on the issue of was this search deleted, there were 4,056 searches on the phone of Miss McCabe. 4,056. There was one deletion out of 4,056, and guess which one it was? House long to die in the cold. There are no odds that that can happen randomly, that one search out of 4,056 is deleted. So what does Mr. Green say? He says that strongly suggests one of two things. Either there was user interaction deletion, or there was post-imaging manipulation of the data. He doesn't accuse individuals. He says user interaction or post-imaging. That is the job of a digital forensic person, to point that out and say that raises concern. The fact that there's only one deletion of a search out of 4,056, I think it's malpractice if a digital forensic examiner doesn't point that out. Another key thing he points out is an anomaly. The Commonwealth said there was a tab number for Hockomock Sports, in that they said it was the same tab number for how long to search or how long to die in the cold. But Mr. Green points out that's incorrect. They had two different tab numbers. So that theory of the prosecution can't be right. So Mr. Green wasn't hurling accusations. He was doing what data forensic examiners do, is pointing out all these anomalies. These aren't things you normally see, and they're not explainable. Here's the last point I'll make, which there's also agreement. There's this deletion of this one search. Mr. Whiffen can't explain why. He says, well, maybe it was a spontaneous deletion. There's no such thing in data forensics as spontaneous, and he doesn't cite any. Maybe it's because the search didn't load. Maybe it's because there was bad connectivity at where this search occurred. Well, that's interesting, because a harder thing to load, the image that came up with food, did load. So you got to have stronger connectivity to get an image that dense. So what Mr. Green simply points out is that doesn't make any sense either. That is the essence of Mr. Green's affidavit. And Your Honor, just to be clear, when we sent in the second affidavit of Mr. Green, we put in the cover, and Your Honor may not have gotten this, that it was to replace the first affidavit because there were some typos, et cetera, et cetera. So you'll see two dates of the affidavits, and it's the later date, and I'm going to give you the specific one that controls.
No, I have both.
Okay,
but
right, yeah.
The second one on the body of it does not say it's a supplemental or anything. If it was in the cover letter, that's what, they're both docketed, so they'll both remain
I was
docketed.
just going to say, we wanted to have them both there for whatever purpose Your Honor wanted, but there's been some question about why two, and it's a simple explanation, one supersedes the other. So Your Honor, in terms of, and this will be the concluding part of my remarks. In terms of the allegation that Mr. Green relies upon technical support at Axiom, and he relies upon technical support of Axiom and the statement that is just remarkable, that that's the basis for his expertise. Mr. Green makes very clear that he did his own analysis. He used the tools himself, but here's why he called Celebrite. At the time of trial, Celebrite had 2 versions of physical analyzer on the market at the same time. One physical analyzer set showed the 22740 timestamp. It showed it, and it showed it in a deleted state. But the recent one, the one that Celebrite updated 1 week before trial, didn't have it. So that was the Insights, spelled oddly, INSYEES. That didn't have it. So Mr. Green did what any good digital forensic person would do. He called up support and said, well, you know, what's going on here? You got one that shows it, you got one that doesn't. But he did what the NIST standards, the National Institute of Standards, and that's attached to Mr. Green's affidavit, says that good digital examiners use multiple tools, and when they have questions or they see anomalies, you call up the program people, you talk to their technical support. That's not someone inexperienced and relying upon them. That is the proper methodology. So Mr. Green did that to corroborate and get explanation for what he found. So in sum, Your Honor, here is what is before the court and what is pertinent for this motion. What is pertinent is the inquiry under Polk, which Your Honor cited in your decision on Dr. Russell. It comes down to, is Mr. Green qualified? There's not even a contest. Second, is his methodology reliable? And Your Honor, those are the only 2 subjects that are ever proper for a Daubert hearing. Why would we have what will be a very long hearing? Now, Mr. Brennan suggests bringing in Mr. Whiffen. I've never heard of that happening in a Daubert hearing, where one party challenges the witness of the other and then says, and oh, by the way, I want to bring in my witness to show. That never happens in Daubert. It's the person who...
I wouldn't say never.
Well, let me take that back. Good point. I won't say never. It is so unusual to have that happen under these circumstances. And this is the key, Your Honor. Why would we have a hearing about whether his methodology is proper and reliable if all of the witnesses agree what the methodology is? So, Your Honor, in conclusion, I would urge the court to deny the motion of the Commonwealth to exclude Mr. Green on 1 of 6 data forensic issues. He's going to be testifying, obviously, at this trial. And I would urge Your Honor to not have the evidentiary hearing, because Your Honor has before you everything Your Honor needs to perform the gatekeeping function. And again, it's almost all undisputed with exception of one thing, and that's the opinions of the expert, which is never proper. I will respectfully state that never is appropriate for a Daubert hearing. Thank you, Your Honor.
Okay. Any follow-up, Mr. Brennan?
I do.
Alessi throws his big dick energy on the table there. Passion.
A little bit of knowledge of forensic data analysis can be dangerous. So when you hear representations or arguments that Mr. Whiffen's opinion that there may have been a connectivity issue is undermined because there was a picture of food which is suggested through a application search, misunderstands the basic premise that that's a cache picture. And that is meant for the user of a phone for the user experience. And so there is cached items that are available without connection that register and come up quicker from a different source while it's waiting for a search to be conducted. It's simple, it can be explained, it's science, it's data. So when you take a little bit of data and you twist it because you misunderstand it or you want to advocate, that is the danger, and that's why it's best left to experts. What the defense apparently is mistaken about is that using a number of tools does not substitute for methodology. You can use one tool, you can use 30 tools. They're all going to say on the timestamp that how long to die in the code occurred at 2:27 on that browser. That is the time that was opened. That window was opened at 2:27. But you can't just look at 8 different tools that are all going to say the timestamp is the same. You have to look into the data and into the databases, knowledge C, the history, and you have to determine what artifacts exist to show that occurred at that time. And when you do that in this process, it is clear that 2:27 search happened after 6 a.m. in the morning. And so that's what Mr. Green doesn't do. He doesn't engage in methodology at all. There's an agreed methodology. He doesn't use it. The defense points to Ms. Hyde's report, how it's narrow. It's narrow because it's an addition to her 2023 report. Mr. Green has not written a report. He has not provided data. He has not provided that he has used methodology. He has not engaged in the process of studying the data. He made a couple of phone calls. And so you can't simply look at the timestamp and then give a reckless opinion not based on the methodology. We still haven't seen a report from Mr. Green. There is none. Because if he actually does the testing and takes a phone and tested his hypothesis, he would dispel his own hypothesis. And if he doesn't do that, we'll do that for him. There is no hashtag concern. And when the defense raises issues, postures, ideas, we never hear what the problem is. What is the hashtag done? Who manipulated it? And that is the MO. Blame anybody, don't articulate who. Be like a ghost, evasive as possible, and then when it gets knocked down, just posit a new theory. The government offers to bring in Jessica Hyde next week or Ian with at another time. Is it common? No, it's not. It's because the government has no fear of a hearing to help educate the court on the data science that is at play here. And so while we don't need to, we have no reluctance to. So there is a real accuracy on the fallacies that Mr. Green promotes in this case. And so we're happy to do it. We welcome it.
Okay. Did you want to say anything very briefly, Mr. Alessi?
In 60 seconds or less, Your
Okay.
Honor. Thank you for the opportunity. The Commonwealth said a little knowledge is dangerous. I don't know what a hashtag is. I've never heard of what was just said as a hashtag. It's a hash value, and it's a very important concept to get right. With regard to the whole premise and point of my argument, Your Honor, that this is a difference of opinions, it was just made by the Commonwealth foreman. What was said, it's alleged that Mr. Green has reckless opinions. My point exactly, take away the reckless. They're going after his opinions, and it's been stated now by the Commonwealth itself. It's the opinions, and those are not proper for a Daubert hearing. Thank you, Your Honor.
All right. Well,
There are 4 exhibits that have been marked.
thank you. So it sounds a lot like it may just be a disagreement in opinions, but for the Commonwealth, I will look more closely at your methodology arguments that were made today. If I decide that we need a hearing, an
Defense one.
evidentiary hearing, and that I cannot decide this motion based on everything before me, I will let you know no later than Monday.
Oh, see, it's over.
Okay.
Woohoo.
So we'll keep
Yes,
next
thank you.
week and I'll let you know. All right.
All right, next up. Here we go. Good
So-
stuff. Here we go. Here we go. Here we go. Here we go.
and not that I would exclude something simply because it takes a lot of time, but we really need to make sure we keep this case on track for the April 1st trial. So I have a question for the Commonwealth on where we stand in discovery. And then we're going to talk a little bit about the motion to recover expert-related expenses.
Your Honor, we've been producing discovery as we've gone along to try to give the defense as much notice as we can. I had anticipated having discovery finished last week. We've sent over most of our discovery last night, or is in the process of being turned over. There was one further report. We've retained Dr. Wolf as a neurologist. I'm waiting for his report. He is away. So my expectation is I can have that report by Wednesday.
Okay.
Further, there was a witness interview earlier in the week. I will have that report as well. My Rule 14 commitments are ongoing. They are involved. Enormous amount of time over the months has been spent trying to satisfy that I can account for all the discovery and make sure the defense gets everything that I can as soon as I learn about it. We'll continue to investigate this case all the way to trial, but our discovery should be completed by Wednesday.
Okay. Does that include the analysis of the data from the Lexus?
That has all been turned over, or we're sending it over on link. It's something like 8 gigabytes on my expert, so it takes a long time to download. It was all sent to us yesterday, and it's all included.
All right.
The analysis is done. The accident reconstruction is done. Mr. Crosby, with expertise in bites and dog bites, his reports are in. Ms. Hyde and Mr. Whiffen have further reports that have been provided. Ms. Hyde has one more that's outstanding. We may have it. I expected it last night. I have not reviewed. And I think that accounts for. We've been through the entire amount of discovery that was prior. It has all been Bates numbers. It hadn't been before, and it's marked as previously provided. I've made a very, very thorough accounting analysis with help of all of the information that isn't in those Bates numbers, and provided everything that I've come across as soon as I come across it.
All right.
Continue to look through all of our materials. There was an issue regarding a phone that we hired a third party to look through the phone and produce all Rule 14 discovery. I mentioned that my position was that it was a very broad view that the assessor should look at. I was uncomfortable reporting to the court that the phone had been reviewed by somebody else, so I did it myself. And so I've gone through the entire phone, every email, every page, thousands, and I've provided not only Rule 14, but broad discovery. This went to a protective order this morning to the defense, so they have anything that, from my perspective, from my experience, would be remotely important or interesting to them. Also, I've gone through, well beyond my obligation, emails of members of the District Attorney's Office, and that continues, and I have another production as well. I wouldn't call it Rule 14 because it's not necessarily statements of witnesses, but again, I've taken a very, very liberal and broad view of what I would potentially want if I was defending the case. And I've provided that again under seal today.
All right.
And so we do not have an official discovery order, but I would like the defense to have the discovery meet 30 days after I complete mine, which will be next week.
Okay.
We filed, but I did not see on the docket, or we sent in, we did not file a motion for clarification, and Your Honor did not mention that. That's an important notice that we had sent in, because I am greatly respecting the April 1st trial date, and there's work to be done. And so I would like to address that motion to clarify when appropriate with the court.
Okay. All right. I'll need some time to review this, obviously.
Yes, Your Honor.
Okay. All right. That's great. So the Commonwealth expects to be ready for trial April 1st.
Yes, we do.
Okay. All right. So now let's just take a look at a preview, if you will, of the defendant's motion to recover expert-related expenses from the Commonwealth. Okay. I see there's a written opposition that I just received. We're not going to hear this motion today because I didn't have the opposition, But one of the things that I'm hoping you can tell me before we hear this, all right, there are a couple of things. Let me just, in this motion, there's a footnote that references, so this motion from the Commonwealth was filed, from the defendant was filed on January 23rd. So more than a week ago, and the motion, I believe, is a footnote that highlights a pending motion to dismiss. I need that motion to dismiss. We need to get this moving. When will that, well, I'd like that filed next week so we can hear it next week.
The reason that we haven't finalized it, the reason we haven't put the full contours on that motion is because we haven't received all the discovery. And I think it would be premature for us to figure out exactly what the parameters of our motion to dismiss are until we know exactly what the Commonwealth is putting in front of us in terms of the second trial. But as soon as we get that, we think that we have the grounds to bring that motion relatively quickly thereafter.
So you expect to have everything to the defendants by Wednesday?
I do, and really what's missing is a report from a neurologist, a witness interview that is really inconsequential. And Ms. Hyde has a report regarding a phone. That's all that's really left for discovery. So that's all I can say.
All right, so if you get it by Wednesday, we're here Thursday and Friday. I'd really like to see something by Friday. You've obviously been working on it, even if we end up having to do it in piecemeal. So
we've been thinking about it, but we have not. I don't know what you mean by working on it. Yes, obviously we're working that direction, but Your Honor, there's no way for us to reasonably get that done by Friday. That's just, there's so many other things that we're dealing with, including hearings like this that keep coming up over and over and over. I'm not, the court knows we don't drag our feet. As soon as we get something, we act on it. I just can't promise that we could get it done by Friday. We are working on it, and we're not.
So
there's no strategy for us waiting, I promise you.
Be prepared to discuss it next Friday. I will be looking for it very shortly thereafter, and we will have a hearing on it very shortly. Time to respond.
Understood.
So we need to come up with a scheduling order, or I've got a scheduling order that we need to discuss. But regarding this motion, what I need to know before I hear the motion on the expert-related expenses is what sort of protocol you all worked out. Maybe it's in the Commonwealth's opposition that I just saw. What sort of protocol was worked out? Who was notified? What the arrangements were? How this all was set into play, and why there was a violation?
I can certainly brief that for the court. We addressed it pretty significantly in our motion in terms of the conversations that were had, the expectations that we had, the protocol in terms of getting our expert out there from Arizona.
No, what the agreement was, right? People don't just show up for the other side's expert. I just need to know what the agreement was for your expert to view this on that date.
Most of this was reduced to email. I think it'd be
so
probably a little bit more accurate for me to just go back and file a supplemental brief.
Yeah, so I need all that information from such egregious conduct.
Sure. Okay. I'll submit a, that won't take very long at all.
Because then we'll address this next week.
Okay, that's fine.
All right. If we do not have an evidentiary Daubert hearing, do we need both days? Or does it make sense to schedule everything for Thursday? What's the Commonwealth's position on that?
Absent that, I don't think there are a lot of matters before the court.
What?
The motion for clarification should take probably less than 20 minutes.
Okay.
And the motion for fees is a very simple discussion. So I don't think there's any way we'd need 2 days unless there is actually an evidentiary hearing, and then it'll take some time.
Okay. What do you say, Mr. Jackson? You're nodding.
I agree. I think if there's an evidentiary hearing, it's going to take multiple days. If there's not, I think we can pack everything into Thursday.
All right, because I don't want to waste everybody's time. I want us to get this case moving.
Of course.
So you will then file that motion to dismiss the following Monday or Tuesday, and we need to set it up for a hearing. if you are indeed filing a motion to
I'm sorry,
dismiss.
the motion to dismiss on which Monday or Tuesday?
After we meet next
The
week.
following week.
Yes. I just want to get a scheduling order going, so I need some of these
I can file my
dates,
motion to dismiss
because we're
whenever the
going to
fuck
need
I
to
want.
Schedule a hearing on that. I do not anticipate an evidentiary hearing on that, but I expect it will take time.
Look at Alan. Look at him talking to Karen. What do you
All
want me
right,
to do?
so the
Want me to tell her what's
Commonwealth
up?
will have all of its discovery to you, it expects, by Wednesday, the 5th.
That's correct.
Okay. We'll be back here at the end of next week. After you have that discovery, I can give you until
What are you talking about, Bev?
February 11th, the following Tuesday, to file a motion to dismiss.
It just raised it as a preliminary matter. What do you mean? Like, it's...
And Commonwealth, I'll give you until the 14th to file an opposition to the motion to dismiss.
Oh, God, they get 3 days. Oh, put Lally to
And
work.
let's hear it the following week.
So then February 20th. Valentine's Day?
We're also going to have to, does the defense anticipate any evidentiary motions?
Yeah.
Yes, but I can't tell you exactly what those are, but in an abundance of caution, given the fact that we're expecting new information from the Commonwealth.
The Lexus.
Court can
All
safely
right.
say yes.
So February 21st, and I'll put this in writing. Filing of all evidentiary motions, that can be an out of court date unless we choose that day to hear the motion to dismiss. Why don't we figure out what's your availability the week of the 17th? The 20th is actually the best day that week for us.
Something school vacation. What is it? Something vacation, I heard.
Your Honor, that is, that week of school vacation week. Both Mr. Jackson and I have young children, but one of us, I think, could probably be here on the 18th.
On the 18th?
Right, yes, Your Honor.
Okay.
Wait, what?
All right, so I'd like you to get me, can the Commonwealth get me the opposition by midday on the 14th? So I'll have it to review over the weekend.
Unreal. No, they need to be with their
I
kids.
know you haven't seen
Fuck
it, so
that,
it's hard
man.
to figure out how much time you need. Is the Commonwealth available on the 18th?
I'm available anytime.
Of course you are. So is your right hand.
I mean, we'll put all our effort into it. If we have a problem, we could let the court know.
Okay.
We'll do our best.
Okay. All right. Okay, so the 14th will be an out-of-court filing date. The 11th, an out-of-court filing date. So the motion to dismiss hearing will be on Tuesday, the 18th. Filing of all evidentiary motions will be the 21st. And that will be an out-of-court date.
So what is this about the 18th? But what?
We will do the hearing on all evidentiary motions March 4th and or 5th. I'd like you to block off both days at this point. And if we don't need them, we'll try and, I don't want everybody coming in for just one motion. I know how much work you all have to do to get ready for trial. There's a lot of work I need to do to get ready for trial, but I'd like you to block off those 2 days because we can't have motions to suppress going on and on past that date. I'm going to need some time to review them and write them. So, all right. Can you all come back in on March 7th? You'll file all motions in limine. We'll have a final trial conference. And then we'll have to set up a date for what I anticipate will be at least a day, maybe two, because it was last time on motions in limine. All right, so March 7th will be an in-court date. And file all motions in limine. And at that time, I want you to tell me how long you expect your motions in limine to take.
Your Honor, do you want those filed by the 7th? All motions in limine filed by that hearing date, the 7th?
Yes. And on the 18th, which only gives me 2 weeks to decide them. Because we're starting the trial on April 1st. Jury Commissioner's Office has been fantastic.
Told you guys,
about
April
getting
1st.
us as many
April
jurors
Fool's
as
Day.
possible.
April Fool's Day.
And we'll talk about empanelment, obviously, a little bit later. All right.
I told y'all, somebody was trying to tell me that was at the end of April. I was like, I don't know where you're getting that from.
Anything else we need to discuss today?
April
No,
1st.
Thank you.
No, thank you.
Okay. All right. Thank you all.
There you have it. I mean, she almost ruled from the bench. She basically did rule from the bench, guys. Let's like not take it away from the defense's win today. It was huge. She basically ruled from the bench in favor of the defense. So wow. I think it's interesting though that why not be heard if it's just a brief conversation about this whole money thing? Okay, how was this supposed to go down? Like, I don't understand how this even happened. Did you hear about everything? That's why I was like pumped about this. I'm like, we're going to talk about this a little bit. The defense is over here just like, yeah, no, we don't care if we hear about this now, later. We're good. I feel like the defense has got something up their sleeve, y'all. Like something's brewing. But this is crazy. Where's the fucking video? I don't know what Hank is literally drinking. I don't know what he is reading. I don't know what he is doing. He literally got destroyed. I mean, bent over on a Friday night, like destroyed. Why would you ever, like, does this man not have any like self, like, I'd be like, fuck that, I'm not putting that shit in there. I'm not doing this. I'm not gonna get up. I'm not gonna look like a fool. Like, there's just no way. Like, go get somebody else to be your pony. But here he's like running the show, man. This is Bev's lost her damn mind too. She's like, I see that there's a motion to dismiss here for extraordinary government misconduct based on the destruction of this and other exculpatory evidence is forthcoming. You guys, other exculpatory evidence is forthcoming. Blow my head off. God. I want to play something. For those of you guys that did not, I want you guys to just see something. If you did not, just joined us, okay? Listen to this right here. God bless America.
Anywhere or taped anywhere on law, correct?
Correct.
It was still snowing out?
Yes.
Brian Albert, when
Right there, that line of question needs to say the same. And then every single person needs to be asked that to include, did you place a shoe on the lawn? Did you place a hat on the lawn? Did you see anybody place a shoe on the lawn, a hat on the lawn? What time were you there from?
you approached
Like, get it in the jury's minds about that shoe.
the house,
Like,
he opened the door, correct?
I approached the car and not the house.
Oh, okay. You approached, whose car was it?
My nephew Brian's
Brian's?
in the driveway. Yes.
All right.
Brian Jr.'s car was in the driveway. There's only 3 cars that were in the driveway, right? Or is that with Matt McCabe's SUV being there that it would be 3? So where are these vehicles? Where are all of their vehicles?
And then
I said this in trial 1.
And we went to the waterfall, and I believe my daughter and her boyfriend, Tristan, were already inside at a table.
She testified that Tristan and her daughter were already there. Okay. And this is really important because this goes to the cars for the next morning. This would be Nicole.
And when your sister Julie came to pick you up at the house, in addition to yourself and your son Brian Jr., with anyone else?
Chris said Tristan arrived later.
I believe 2 girlfriends may have already had come, and they were just sitting in the kitchen when I...
And that's Sarah and Julia Nagel. And Sarah and Julia Nagel both said that Caitlin was there. Like the sister.
And so you go out to the water. And when you left, I'm using sort of you in the plural. So you drove, is that correct?
I drove. Yep.
And who, if anyone, went along with you in your car?
Nicole, my sister-in-law, and Caitlin, my niece. And Brian did not end up coming with us.
That would mean that Caitlin's car, her Jeep, is at the house. Okay, her Jeep is there. Okay, her Jeep is there. So that would mean that Tristan, when he came to pick them up, right? Because her testimony is that Tristan met up with them once they got to Waterfall. He comes in, has dinner, and then he leaves. Okay. So Caitlin has a vehicle there. If Tristan came to pick up Caitlin, then Caitlin's vehicle would still be at the house at 6 o'clock in the morning because she left at 2 a.m. Right? So we have Brian Albert's vehicle, Brian Albert's work vehicle, Nicole's vehicle, Brian Albert Jr.'s vehicle, and then Caitlin. That's 5 motherfucking cars. And then do the twins, because at the time I think they were 16. Did they share a car? And they testified that their garage was used for storage, not to store cars. Okay. At 6:08, 7, whenever the cops rolling up, we see what vehicles are there. Where are all these vehicles? They're missing.
While you were there, as far as during sort of the meal portion of it, was there anyone else that joined you?
I know my niece's boyfriend, Tristan Morris, came. I don't remember exactly when it was during that, but I know he was there. And then during the meal part, I don't think during the meal part anyone else, I don't think.
So you recall, as far as the meal part was concerned, it's you, your sister-in-law Nicole, your niece Caitlin, and her boyfriend Tristan.
Correct.
And Ms. Morris, did he stay for any extended period of time, or when was it that he left?
I know he stayed for a little bit, but I honestly can't remember what time exactly he left.
Why?
Okay. And then, because my big thing, if you guys don't know and following my channel, my big thing is that if you want all these people to say what they're going to say, which is John O'Keefe's body wasn't on the lawn, which is really, really awesome. If John O'Keefe's body is not on that lawn when all of these people are leaving and coming, you know, and walking out and talking to my brother, and then this person rolls up, that lawn is so small, okay? Nobody sees a body on the lawn, which means that the Commonwealth, their victim, okay, it would just be like the Idaho 4 case. The victims are unaccounted for. John O'Keefe is truly unaccounted for because they say he didn't go into the house. So when he gets dropped off there, clearly Karen leaves and John's not with, Karen. She leaves and she's at home at his house at a certain time, and they label it, and their own witness testified that she connected to the Wi-Fi at 12:36. Okay. And so John O'Keefe, their victim, is unaccounted for from 12:30 until the camera is on him and they find his body and they call 911 at 6:03 a.m. That means that if you're not going to say that John O'Keefe went into that house, but we have movement with the cell phone, at least taking steps, where's the other place that is logical and common sense for a jury to wrap their head around on where John O'Keefe could have gotten into, and what would prevent your phone from continuing to take steps, but really you could technically be moving. And that would be if John O'Keefe got in a vehicle, right? That's the common sense where, like, John O'Keefe, for nobody to see him and he didn't go inside, he could have then gotten into a vehicle, right? That's how I would be saying it to the jury, because I would use Nicholas Guerrero's testimony against him and saying that the up and down like a roller coaster, we ain't quitting till the show is over, Tupac. That, oh yeah, we're hitting, if we're going up and down bumpy roads, we're able to hit flights of stairs and shit like that. Okay. Oh, okay. Awesome. Nobody saw him come in. Nobody saw him on the lawn. Higgins dips out early, but Higgins testified that he saw somebody come in with dark hair, right? He couldn't really see. And so nobody saw Higgins's Jeep, and it was parked right by the mailbox, and it couldn't have been parked there if what's his name pulls up. The Maxton crew and Julie Nagel's brother, the Nagel crew. So that Jeep, which when Higgins testified, he said at first, he goes, yeah, I was in the Jeep Cherokee. I mean, the Jeep Wrangler. He said, how would you ever, if I owned a Jeep, I would never, ever say that I owned a Jeep Wrangler, because that's like a thing. Like, you're proud of Jeep Wranglers if you're a Jeep person. You would never say, oh, I was in my Cherokee. I mean, oh, my Wrangler. Does he own a Cherokee? Does Higgins own a Cherokee? I know that Caitlin Albert owns a Cherokee, and I know that a Cherokee wasn't there that morning, right? But it should have been there that morning if Caitlin Albert got picked up by her boyfriend Tristan, right? Her vehicle would still be there, right? You would never say on the stand, I was in my Jeep Wrangler. Or I would never say, yeah, then I had my Jeep Cherokee. I mean, my Jeep Wrangler. Just like you would never say, oh, I gave birth to my 5th kid, and you never had 5 kids. Like, how does that even come out? Oh, I was under so much stress that year because I had my 5th kid. Oh, I mean my 4th kid. What? How does it 5th kid? How do you even fucking fuck that shit up? Like, bitch, you didn't even have, like, what? So the whole point of this is that if I'm the defense, I want to take what I've learned from trial 1 and use the Commonwealth's witnesses as my own witnesses. Their own witnesses say that John O'Keefe is not on the lawn, because he's not on the lawn. He's not on the lawn. He's not on the lawn. All these people believe these witnesses. You're supposed to believe these witnesses. He's not on the lawn. Karen Reed is not testifying, but They say he didn't go in the house. Okay. His phone, though, has steps, right? And show that the amount of steps would actually put you to walking and getting into actually somebody's vehicle. Oh, how do you account for the up and down? Account for the up and down the same way that they accounted for the up and down. Say that it was because of the fucking elevation. And the jury, okay, is going to believe it because leave them with that narrative. Okay. So nobody saw him because Higgins gets out of there, right? There was no more fucking liquor. And Higgy Poo, how do you know that Higgins doesn't have John in a car? The jury can get behind the fact that, like, let these witnesses, yep, exactly. Nobody saw him on the lawn. Nobody. And if Karen Reed hit him, that's where he would have to be. You understand that? These people would have to see him there in order for Karen Reed to be the person that caused the death. She only has one opportunity to do this. And that's right there at 12:28 when everybody's there to be able to be a witness to this. And they weren't, and they didn't see any, but they did not see a body on the lawn. It's because there was no body on the lawn. They said there was no body in the house. They didn't see him come into the house. It's because he didn't go into the house. Now, where, ladies and gentlemen of the jury, where's the other place that you would go and get into? A car. And then he takes these, he goes up and down these flights of stairs, right? Well, Nicholas testified that that can happen because you're going up and down. So he traveled back the same way that he just came, going up and down those hills. Then they turn around. There was nobody on the lawn. The state, or in this sense, the Commonwealth, you guys, they don't know where their victim is. They don't know where their victim is from 12:30 until 6:03. Where is your victim? Every single one of your witnesses just took the stand and never saw the guy. He didn't go into the house. He wasn't on the lawn, right? And then you're going to show a video of Higgins arriving at 1:30 to move cars, rearrange cars, right? Rearrange cars. And then you're going to show him that he was on the phone, right? Ask him who he was talking to. Did you forget something did you call Brian? Did you forget something at the house that you had to go back and pick up? Did somebody call you and they asked you to come back? Did you say, hey, I have his body in here, but what the fuck do you want me to do with it? You want to show that the only person that there was an opportunity, there's this little opportunity, the reason that nobody saw him inside and the reason that nobody saw him coming up and pulling up like the Julie Nagels of the world and the Richie and all this shit is because They only saw Karen by herself, so John wasn't in the car. They didn't see John on the lawn. And then so if he didn't go in the house, where's the only place that he could have went and got into? Could it be that Karen is mistaken when she says that she thought she saw John walk up to the side door and then in fact wasn't John? Okay. Because he gets met before then and, hey, come with me. Let's go have a talk. Let's go talk. And then Higgins and John are in a vehicle that pull away and then therefore able to have the Maxon crew be able to pull up right behind Karen. But then they testify that, no, I was tailgating Karen in there. Well, if you were tailgating Karen in there, how did any of you motherfuckers pull up? This is almost why you may want to consider having, we need to have a map of, and everyone needs to put where their vehicles were and where they were at in the house at certain points in time. And everybody will see that none of this is possible. You cannot have cars in parking spots where other people's cars are. Why are there only 3 vehicles in the driveway at 604, 608? Why were there only 2 vehicles in the driveway with when Matt McCabe gets there? Fuck, there's only 2. Because he's the 3rd vehicle. Where are all these fucking cars? From all the people that are supposed to be in that house that have vehicles, where are their fucking cars? And it's logical. It's logical, and you want to use the Commonwealth's case against them. Yep, you put up every single witness that they had, and none of them said John went into the house. None of them said that John was on the lawn. So the Commonwealth has their victim unaccounted for from 12/28, 12/24 until 6:04. Where is John O'Keefe? Well, he was on the lawn. No juror is going to say that if you keep it to this fucking little scope here. And then you recall every one of their witnesses after they testify, and you show them the driveway, and you say, where's your vehicle here? Where were you parked at? Then you call in these girls. How did Julie get there? How did Sarah? Oh, we got picked up and we were dropped off by what? Family. Call those motherfuckers up there to the stand. How do we even know that that's true? You know what I mean? Get those parents involved. We're just supposed to believe people. I got dropped off. Everybody just got dropped off. Well, let's make sure that that's true. That Sarah and Julie Nagel got dropped off. But right there, that clip to show why that part of the lie. Fuck, I forgot to say that we didn't take her. That's really, really important. It's because they're missing a vehicle. It's because of Tristan had to truly go back and pick up his girlfriend to then bring her back, home, which is like 30 minutes out of the way, right? Then that means her vehicle would have still been there. And I just know off of the face of this, you have Julie saying that I didn't walk up to the house. I walked up to Brian Jr.'s car. So we already have her admitting that one of the cars is Brian Jr. That's why I clipped that. So you have Brian Jr.'s car. Where's Brian's car? Then where's Brian's work vehicle, right? Then Nicole has a car. So right, and then you have Caitlin's car. 1, 2, 3, 4, 5. 5 vehicles. Brian Jr., Brian's work car. And how do we know that Brian has a work car? Well, because Nicole got caught up on that shit. So 1, 2, 3, 4, 5. Caitlin's vehicle is 5. Because according to Julie, Julie's mistaken though. Oh, she is? How the fuck would Julie possibly mistake the fact that she wasn't even the one that was drinking that night? Julie's the one that had a pounding headache, right? Julie's the one that dropped the ball and forgot to lie right there. She forgot to lie about that part of it. Okay. Fuck, let's even say 4 cars. Where are all the cars at? They're missing. Where are all the vehicles? And that's a really big problem when you have Matt McCabe's vehicle there, because then you have Matt McCabe's and you're missing vehicles. And then I find it hard to believe that family, those twins, were they 16? If they could drive, I find it really hard to believe that they wouldn't have a vehicle that they shared that was like a, I don't know, Honda Civic or some shit. Yeah, right. Put John O'Keefe in a fucking car. Put him in a car. Look at the timeline if you put him in a car. Here's another video. This is crazy, though. This is absolutely absurd. Nobody saw John O'Keefe. Their victim, or have the jury be asked very simply, hey, jurors, where was John O'Keefe from 12:30 until 6:03? Because every single one of the Commonwealth witnesses has testified to saying that he wasn't on the lawn and that he wasn't in the house. So where was he from 12:30? Because he's not with my client, and she had to leave at this time to make it. You heard the testimony. She's on the Wi-Fi by 12:36, and it's at least an 8-minute drive in that type of weather, and you'd have to be moving it. So where is John O'Keefe? Where has the Commonwealth suggested that he is? Where is every single one of their witnesses saying that he is? Not in the house and not in the lawn. So don't you normally have to have a witness be there to say, or evidence of it in some capacity, that he is in fact on the lawn? Tell me, if you're a juror, how you're possibly going to sit there and say to yourself, yeah, every single person's lying on the stand. They really did see him, but they just didn't help him. Or are you going to say, they must have missed it. They must have just all been so fucking hammered. So then it's unreliable testimony in and of itself. Okay. As a juror, how can you what would you go back there and say? And then you would actually be able to say, hey guys, they didn't find any of the stuff, the plastic shit, until everything came after they had her car. That's all you have to say. After they had her vehicle is when everything started turning up. Why wouldn't you call to the stand the guy across the street and say, you have Ring camera footage at your house, don't you? Or you have a Ring device, don't you? Yeah. And you were an officer, right? Like, so safety's probably a pretty big thing that you have, like, you're a police officer, right? Yep. When all of this happened, they came over and asked you for like red Solo cups and all that shit, right? They didn't ask you to, hey, can you look at your cameras and can you see anything? Did they ask you that? Get these motherfuckers on the stand and just make. You didn't think to look at your Ring camera when someone's saying, like, you're not nosy? I mean, where's your wife? Call the wife up on that motherfucker. Hey, you have access to your Ring camera. Did you see anything? I don't get it. Make all these people look like fools. Show that it was a police officer that was murdered or killed, rather, or lost their life, or it was an accident, but show how they didn't do anything to try to find out what happened to this man who's a police officer. The Commonwealth does not know where the victim was, period. How does the Commonwealth not know where their own victim is? Why would you ever bring people as witnesses up on the stand to literally not corroborate your narrative? That is so ridiculously, I've never heard of something like that in my life. That you're calling people to the stand that are actually going to say that he wasn't on the lawn. And this is all you have to talk about in the closing. Don't bring up any of this other fucking bullshit. Jen McCabe Google search something. Yeah, she's a fucking piece of shit. But you know what, guys? This guy says it didn't happen. This guy says it did happen. How about just simply this? It's there. It's there. It is there. And that should just be enough to say, like, wow, like, why would this even be there? And then we have to believe Jennifer McCabe when she's saying, oh, I Google searched that at 6:23 because Karen asked me to. Well, go back and run the film back. Karen and Jen aren't even together at 6:30 or 6:23, whatever the fuck time it was. Why isn't that being pointed out? They're not even together. I've never ever watched a trial where the state or the Commonwealth is putting on a case and they're bringing up witnesses and their witnesses are not corroborating their fucking narrative. I just never seen something like that in my life. So if I was a defense attorney in this case, I would say, you guys, their own witnesses came up and said he wasn't on the lawn and he didn't go into the house. And we know that he didn't go back to the house with Karen because the niece didn't see him. And he wasn't found there. Okay? So where was John O'Keefe from 12:30 until 6:03? And the state, the Commonwealth, has not answered that question. They say that he was hit by a car and he was struck and he laid right there and it was just curtains. It's over. They cannot say that. They can, but they've just come into a courtroom and literally provided witnesses here to say that nobody saw him on the lawn. Nobody saw him got hit by a car and everybody is looking out the fucking window. How do you see somebody make a 3-point turn? How do you see somebody's tracks in the fucking street that they turned? Those type of things that they are witnessing from sitting on each other's laps, okay? These people are walking out the front door. These people... It is not... And just say they came out these ways. It's where they didn't see a body. It's not because they're sitting here, all of them lying to you. Nobody saw a body. Do you believe them? We believe them. We believe them as the defense. We believe that none of these people saw John come inside the house and none of these people saw John on the lawn. We have no reason to believe that these people aren't telling the truth. So ask yourselves this, jury. The Commonwealth has provided their own witnesses to say they don't know where John O'Keefe was from 12:30 until 6:03 when he is now on police body cam or dash cam rather and being worked on. It's not our job to tell you how he got there. It's their job to tell you that. And what they've provided here in this courtroom is that they're saying Karen Reed only went over there once. So she had to have hit him between 12:26 and 12:28 because then she got out of there to be on the Wi-Fi by 12:36. But then you heard Richie testify that they tailgated Karen Reed in there. They tailgated her car. She turns left first, then they turn right. We asked them, did you see Karen Reed plow this motherfucker from behind? No, we didn't see her hit him and he go flying. You didn't see a body flying by because she went at him 60 miles an hour or 20 or 30. No, I didn't see anything like that. Okay. Well, I would like to redirect. Did you leave before Karen Reed left? Yes, I did. So it could have happened after you pulled away. Okay. I would like to recross. When you left, you said you looked over and you could only see Karen in the car, right? You didn't see another person in the car, right? That's right. So only one person was in the vehicle. Yes. And you didn't see a body on the lawn when you drove by? No. And you didn't see him hit him? Or her hit him? No. And then in closing, you would say, in order to believe the Commonwealth, you're going to have to say that every witness that they brought up here is lying. They brought in witnesses, and they want now you to believe that these witnesses were all lying. Absolutely unfucking believable. So how I could possibly go back, I would go back there and be like, you guys, I don't know how the man died. No idea what caused these fucking, no idea. No clue. But I watched that fucking leaf blower and I didn't see one piece of shard blow up. Red piece, big piece. It's all the way down to the ground. How would these motherfuckers miss this with a leaf blower that now I'm going to use to my advantage to say, because you could get all the way down to the grass, couldn't you? That's why there's dirt and little pieces of grass in your little solo cups, right? Because you got all the way down to the grass, right? Because you got this blood, right? You got grass, blood, and dirt. Yep. Awesome. So I would be a juror going back there and saying, guys, I have no idea how this man died. None. So it's not guilty for me all the way across. I believe that those witnesses would have saw the body. Okay. And I believe that that those witnesses would have actually witnessed the act. And I think that those witnesses, if they did see a body, I believe that they would have called. Something would have happened, right? In order for that jury to come back with guilty, all of those people in that courtroom that's a juror would have to go back to that deliberating room and say, we think that all of these witnesses are lying. And, or I believe them all, but the reason that they didn't see a body is because of the snow. And nobody saw it because they weren't looking at the time that she did it. How much snow do you think there was on the ground at that time, y'all? If you can see somebody back up because you can see in the street, that means there's not that much snow, that you're able to leave like that tread, like you could see the tread, like because then you can see then like part of like the ground coming out of it. It's really hard when there's a lot of snow and you're looking outside that it all kind of blends. It's all white. Do you want to? We don't have the ring video. Just miraculously didn't work that day. Nobody sees a body. His shoe is missing, but then it reappears. His hat's missing, but then it reappears. We use a leaf blower. Nothing's coming up from using a leaf blower. And none of the evidence is obtained until after they didn't see a body because there wasn't a body. And then if the jury then goes back there and they said, hey, yeah, I think that he did get out of the car. And what makes sense to me is that if he didn't go into the house, right, there's all these vehicles that are there. Okay. And if something happened, an altercation happened before he got into the house, then somebody, get in the fucking car. We're going to go talk, So to get in, to one of the vehicles, which should have actually been there the next morning and it wasn't, that could be a reason that one of the vehicles is missing. But it's logical and common sense to say that, well, we all know that he got out of the car, right? We can all say this because he wasn't found dead in a vehicle or in a house, right? So he had to get out of a vehicle in order to get fucked up to die, right? All right, perfect. So in the back room when we're deliberating, well, guys, can we all admit that he got out of the vehicle? Yes, we can. Whew, thank God. Let's put a check there. All right, he got out. Now, he either A, stood there so that somebody could run into him after she kind of pulled up and then decided to go backwards at him and get over that, like, Humpty Dumpty little curb and hits him. But if that happened right when he got out of the car, then Richie and them who tailgated him in there would have seen it. So we have to rule that out because they would have seen that. So the only thing that's plausible is that he gets out of the car and he starts walking to kind of go like, in. But if he doesn't get into the house, guys, where else would you go? Where else could you go? And then it would make sense that it stops moving steps. But how do we get the flights of stairs? Oh, well, that guy testified saying that when you're in a car and you're going up and down a hill, that's how that could happen. Oh, yeah, that makes sense then. I mean, that's how give it back to these jurors. Treat them like they're dumb. Sell them that good a book. Like, sell them that. Because there's people going to be back there and be like, yeah, it is because you went up and down the hill that these flights of stairs are happening. Testify that way. Go right ahead. Awesome. So then he gets in a car, and he got into a vehicle almost at the same time because that Higgins guy testified that he left early, and they were having beef that night, right? And so if he wanted to talk to him and tell him, hey, I got to come clean with you, bro. Your girl's trying to get with me. And so I'm telling him that, right? And then for all we know, we have no idea why Karen didn't testify, but, her saying that, she pulls off because he's going to go hang out with these fucking pervs. I don't know. So I think maybe the defense should talk about the act of the killing. The time. What time did this happen? what time. And I think that when you stick to that, then a jury is going to say the state's timeline of when this would have happened, because Karen Reed didn't come back to the house to be able to hit him like at 2:45 or something like that. So if you stick to the fact of their theory is that this had to have happened at no later than 12:28 a.m. No later. But every single witness that they brought in that was there said that there's no way that I would have seen a body on the lawn. I would have seen, my vehicle was right there, right behind Karen's. I would have seen her fucking hit the motherfucker. So you want to pin that and say that that's the act time. You can't say, it's not on you to say, we're simply saying that didn't happen at that time. And they're saying that it did. And in order for Karen Reed to be responsible, it has to happen at that time. And all of their witnesses are saying that the body's not there. So we don't need you to decide what caused his death. Okay? We need you to decide, do you believe that John O'Keefe was injured, began to become injured at 12:28 or earlier? And that nobody there would have seen it. And every witness says that the body wasn't there. Because I would even say, fuck it at that point to talk about even what caused the damages. It's when the damages were caused, when these damages were caused. And if you can't, if there is no evidence to suggest that these damages were at 12:28, these are the damages. Awesome. Awesome. We have experts over here saying that this couldn't have happened. We have experts over here saying that, yep, that's what caused it. Great. Awesome. Just like we have the phone stuff, that happened here, that happened here. But we have 12 motherfucking people that are telling you, not just one eyewitness, but 12 people are telling you that they were at that house, they were looking out the window, they were coming out, they were going in, and that they never witnessed this vehicle hit this guy. But most importantly, they never saw the guy. They never saw him go in the house, and they never saw him on the lawn. And I'm asking you to employ your common sense, which is when I'm telling you that there should be 5 vehicles in that driveway in the morning, and there's only 3, that isn't at all possible that John O'Keefe would have gotten into a vehicle and that vehicle potentially had blood in it, and that vehicle then couldn't remain there because it had blood in it. Because it would be a vehicle of somebody that's inside that home or left with somebody else while their vehicle is still there. Where are these vehicles? Say they got in a fight outside. We're not going to bring John O'Keefe. Why would we bring John O'Keefe inside the house when we can just throw his ass in a vehicle after we knocked him out? Throw his ass in a vehicle. He'll wake up. Well, no, I'm going to go talk to him. So I'm going to take a ride with him. I got to tell him all about what's going on. And fucking Higgins had him driving around. He's like, what the fuck, dude? He's not waking up. What the fuck am I supposed to do? I'm coming back over there. He's out. I can't get him to wake up. He's fucked up. He's in bad shape. And he goes back over there. I don't think that he went inside that house. Something's off with the cars, you guys. Something is seriously off with the cars. Don't you think it's weird that what are the odds that on a night that John O'Keefe would be murdered, right? That on the night that John O'Keefe would be murdered, that Allie McCabe happens to find a stray dog, rescue it, put it in her car, take it to the police on the same night that John O'Keefe would be murdered, and that there would then come out to be like dog, isn't that just wild? Like, talk about like, whoa, like so fucking crazy. It's just like, I just believe that one of these cars has blood in it. And it could be because there's blood because somebody got into the car because it's blood that they had. It's one thing to explain your own blood. Like, fuck yeah, I had a bloody nose or my fucking shirt. I was working out and then I got a bloody nose and I threw my shirt on my chair over there or on the seat in the Jeep. But to be able to explain why John O'Keefe's blood would be in your vehicle, now that's not going to be, these vehicles, man. These vehicles bother me. And I think that the jury could get it when they're like, okay, he didn't go in the house and he's not in her vehicle and he's not on the ground. Well, where was he during the time that, like, clearly he had to get out of the vehicle? Oh, wow, yeah. And see, to me, it makes sense because, like, if a bro wants to talk to another bro and say, hey, yo, we need to talk. Yeah, let's talk. Let's take this outside. I'm not going to talk in front of all these fucking schmucks, right? So before we even go in there and here, let's go for a ride. We'll talk. All right? Because Higgins wants to let John know that, hey, your woman, da-da-da, this is what happened, da-da-da-da. And then who's to say it didn't start like that? And I don't fucking know. Like, if truly Higgins had a plow on his truck that night, just really. So rather than saying that some big conspiracy with all these witnesses, I would use the witnesses to my advantage and say that they're all telling the truth. John wasn't on the lawn and John didn't go in that house. Okay. They're telling the truth because they didn't see it and they would have seen it, right? They would have definitely seen the body on the lawn. Okay. Maybe they were out dancing around and doing whatever. And John went right in and went right downstairs, whatever. But they would see a body on the lawn when they left, but they didn't see it. And we have no reason to think that they're lying. We don't want to portray that they're lying. We want to portray that they are telling the truth because those witnesses support our theory as the defense is saying John O'Keefe would have been on the lawn if Karen Reed hit him because she would have had to hit him before 12:28 to be able to make it back on the Wi-Fi by 12:36. And then everybody who's saying they're looking outside, and especially Jennifer McCabe, who's saying that she's calling John's phone and he's calling her phone and all this shit, right? Like, they're all looking outside. People are coming outside. People are going back inside. People are pulling up with their headlights on. Then you have Tristan, who comes at 2:40, 2 o'clock to pick up the girl, right? He has 2 stabs at it. Don't see. Pull in the driveway. Then he's waiting there. Well, where did you pull in? Because the driveway would have been stacked, right? You pull in, you're waiting there. So when you try to pull into her driveway, then you back out to go like this. All these people missing a body at 2 o'clock. And then you have Lucky. And I believe that Higgins messes up when he says, I was driving a Jeep Wrangler, because I want to know, if you listen to Tristan Thompson's testimony, didn't he say he was driving Caitlin's vehicle? And doesn't she have a Jeep Cherokee? Because I don't believe that he came there and went and picked her up. I believe that's part of the fuckerage. And it's all about these cars. It's these fucking cars, you guys. I'm telling you, it's these cars. Nobody will move me off of the cars. Ready?
Firefighting structural gear out with ambulance 1, just in the event that there was an emergency. And as I was doing that, the emergency tones went off for a medical.
Do you recall what was the report in regard to, what was dispatch in regard to as far as the medical was concerned?
The overhead dispatch came in as a unresponsive male in a snowbank at 34 Fairview Road, outside. Unclear any further information. So
unresponsive in a snowbank. Snowbank, you guys? Do you know what the word snowbank means? Not unresponsive in the lawn. On the lawn, outside in the snow. A snowbank. The only way that John O'Keefe would have been in a snowbank, okay, is if the snow was placed in a specific way. Okay. It came across as he was in a snowbank. It's very interesting.
When that came on, we had one of the paramedics that morning and one of the firefighters who was a relatively new firefighter. I made the decision to step onto the ambulance to provide an extra set of hands as one of the more senior paramedics in the station at the time.
And correct me if I'm wrong, when you step onto the ambulance,
the overhead dispatch came in as a unresponsive male in a snowbank at 34 Fairview Road, outside. Unclear any. Dispatch came in as a unresponsive male in a snowbank at 34 Fairview Road, outside.
who, if anyone, or what, if any, other sort of vehicles were dispatched on this call as well?
The initial dispatch was Canton Engine 3 and Canton Ambulance 1. Due to the severity of the call, depending on how it comes in, the shift commander, which is car 5, he will usually respond to any significant incident. So he also added himself to the call, just as a senior officer with us. So the final dispatch, I believe, was car 5, engine 3, and ambulance 1.
You know who was on engine 3 and who was in car 5?
Car 5 was Captain Robry. Engine 3 was Lieutenant Greg Woodbury, firefighter Frank Walsh, and firefighter Katie McLaughlin.
As far as the ambulance 1 that you were in, obviously there's somebody driving and there's somebody in the front passenger seat, correct?
Correct.
And so who was driving and who was in the front passenger seat?
I don't want to speak out of turn. I honestly can't tell you who was driving. I was in the back. I was in the back patient compartment of the ambulance, just because there's only 2 seats up front. So I hopped in the back.
Okay. And so when you're in the back of the ambulance and you're going to the call, what is it that you're doing in sort of preparation? Where was it in relation to the roadway?
I estimated it about where the sidewalk met the front lawn of that residence. That would be my best estimation.
You have any estimate as far as footage or anything like that?
I would say about 6-8 feet, perhaps. Correct.
And when you get to the ambulance, what, if anything, did you note as far as what, if any, difference was there in the lighting in the back of the ambulance versus on the front lawn?
Lighting was significantly better. All of our ambulances have fluorescent lighting in the ceiling of the ambulance. So those were on, and we were able to see that there was some more injuries once we were able to get him out of his winter clothing.
And so to that point, when you sort of
out of his winter clothing. Out of his winter clothing. You guys know who had like a puffy jacket on, right? The night of the murder.
Others were removing clothing, I honestly couldn't tell you the number of articles of clothing, but I believe a winter jacket and a sweatshirt were removed. And then eventually he was, all the clothing was removed. And that's
Anyone else from your apartment is in the back of the ambulance, and what, if anything, are they doing at that?
so at that point, I had myself and Nat Kelly, EMT Kelly. He was kind of with me for the head. One of the, for lack of a better term, easier operations of a cardiac arrest is ventilation. So Matt Kelly was assisting me with ventilations, is just squeezing the BVM to provide ventilation.
Okay, so now what is the odds of this anomaly of craziness? Remember when the McCabe's were leaving? Matt McCabe had to go back inside to go get his jacket that I had to go back inside because I forgot my jacket. John's found with a jacket on. Okay. But I'm telling you, if you go and watch the waterfall videos, watch them doing their little fight, their little fake fighting man, broing it out, hugging, wrestling thing. Yeah. Check out who has a puffy winter jacket on. I'm just saying. Remember, John didn't have a jacket on that night at all. And he remembers, taking off a winter jacket. He only had on this little thin hoodie and a t-shirt underneath, like a long sleeve t-shirt. It was a short sleeve t-shirt. And his jeans and his hat and his Nike shoes. He did not have a coat.
The lead paramedic for the cardiac arrest was Anthony Flamati. He was running everything else. He was running the application of the cardiac monitor. He was monitoring the status of medications being administered. He was assisted with that by Katie McLaughlin, Lieutenant Woodbury, and Firefighter Walsh.
And at some point, Firefighter Flamati, excuse me, at this point that you're in the back of the ambulance, you don't have any sort of demographic information in regard to your patient, correct?
Yeah, craziness. Let's just remove this. I think I have another video I want to show. I think I made a different one. It's just this case is so stupid. It pisses it like how like what a it's Do I have my Karen Reed box over there? I want to take a look at the cars again. Well, let me just go to this trial day when fucking Higgins does. Yeah, I want to take a look at something. Let's go like this. Well, thank you.
For us, who he is.
Oh, it's not that. It's titled.
Okay, so Brian Higgins is an ATF agent, so a federal agent, but he worked out of the town of Canton. He has an office in the Canton Police Department, and he friends.
Your interest in Miss Reed with your work supervisor at the DOJ. You've indicated that you took your Jeep, your personal vehicle with the plow on it, over to 34 Fairview, correct?
Yes.
And you were among the first to arrive because you were doing that thing with the sort of playing around by plowing his driveway.
It was a sweep of the driveway, yes.
Okay, right here. You guys, there was going to be no plowing of any driveway, a sweep of the driveway. There's all these cars in the driveway. Like, what? Like, nobody drops plows when they're... My dad owned a landscaping construction plow. You don't drop plows when there are vehicles in the driveway, okay? You don't drop plow, okay? We can drop trowel, but we do not drop plow.
And then you indicated that you parked in front of the house, correct?
I did.
I know you've been over this before, but I'm gonna ask you one final time so it's completely clear. Exactly where was your Jeep in front of that house?
By the mailbox.
Okay. Can we have, with the court's permission, exhibit 66? Okay.
Right here, guys. I mean,
This
like,
is a graphic representation of 34 Fairview, not photograph. Just to orient you, do you see what's depicted in exhibit 66?
Yes.
Do you recognize it?
I do.
Do you see the mailbox, which is out right there?
Yes.
Okay. Where was your Jeep in relation to that mailbox?
So the back end of the Jeep, the rear, would have been around equal with the mailbox, and I was not blocking the driveway.
Okay, so you would have been about there, correct? If the right edge of that highlight is the mailbox being right there, you'd have been about right there on the street, correct?
Well, that would have been the front of the Jeep. We a laser pointer is, it would be the front.
Okay, so the front of the Jeep is facing the flagpole,
Towards Chapman Street, correct.
and the rear of the Jeep was basically even with the mailbox strut or stanchion.
It was definitely past the driveway, yes.
Okay. You indicated the plow was a 6 foot, what inch plow?
so
I think it was a 6'8", 6 foot,
meaning the width.
meaning the width, yes.
How deep is that plow?
How deep? Like,
2 feet, 3 feet, 6 inches?
I mean, it's probably a few inches.
Okay.
It's light duty. It's on a Jeep.
Okay. And it's obviously curved and curved to the right.
No, it wasn't canted at all. It was straight down.
Okay, so it's not like I guess I'm picturing in my mind, I don't know that I've ever seen one, that the front of the Jeep is not parallel to the plow. In other words, it would plow stuff off to the right. Is that all right?
I'm not understanding what you're trying to communicate to me.
How is the plow positioned as it relates to the front end of the Jeep? Is it perfectly parallel to the front end, or is it canted one way or another?
So when you're driving straight locally, where you're not going to worry about overheating the Jeep, I would just have the Jeep plow straight. If I was on the highway for a long distance, I'd be worried about overheating, so I would canter the plow, tilt it up so that air could get through the front grille.
So in other words, you can control it.
I can, yes.
How is it that?
So
How was it canted that? Was it straight or canted?
it was straight and straight on.
All right.
okay, so can the defense try to maybe switch up? Because I know everyone wants to talk about the dog, right? But there's other ways to suggest that John O'Keefe got those scrapes. Okay, and I'm telling you, it would go through my mind if I was defending somebody to say, hey, do you want to talk about the fact that, this could the plow have caused it, on the arm?
When you walked into 34 Fairview, you indicated that there were people congregated basically in the kitchen area, correct?
There were some people in the kitchen area, yes.
How many people were at the high top table that you described?
Initially, when I walked in, I believe there was Brian Jr., and he was flanked by one, possibly two females.
And you indicated that basically you were positioned in that area with your back to the door for most of the evening.
I was I would describe this diagonally across from him and had my back to the door that I had come in, which would be the breezeway door.
But at some point, you had moved out of that kitchen area with Brian Albert, correct?
Well, I briefly went and looked at some photos.
Right. So you moved out of that area with Brian Albert alone to go to a different room.
Yeah, so I think his wife, Nicole, might have popped in the room for a second, but it was brief.
Did you have anything to drink while you were at 34 Fairview?
Well, when I got there, they didn't have any whiskey. I believe they might have put a beer or something else in front of me. And, I knew it was going to be a short night there because I just wasn't I'm not a beer drinker.
You've indicated in a prior testimony that
Because Higgins can't hang out unless there's fucking whiskey, man.
you've never been upstairs in Brian's house, correct?
When you say upstairs, like you're talking like second floor?
Correct.
Yes. No.
Okay. You testified to that in a prior hearing. Is that right?
Yes.
In May of 2023.
Yes.
And you said specifically, quote, I've never been upstairs. Is that
Yes.
right? All right. You understood when you gave that statement that you were under oath?
Yes.
You were telling the truth?
Yes.
Same oath that you took here today, correct?
Yes.
You indicated that the photos that you saw were on the first floor living room area. Is that right?
I believe that's where they were, yes.
So the only floor downstairs from the first floor would be what?
The basement.
And the only floor upstairs from the basement would be what?
The first floor.
So if someone were to describe going upstairs to look at the photos that you've described on the first floor, where would they have to be to go upstairs to look at those photos?
Are you saying on the first floor?
Correct. If the photos are on the first floor,
yeah,
and someone said, we went upstairs to look at those photos, where would they have to be?
I guess upstairs.
No.
The people would have to be upstairs?
Well, the photos would be upstairs. Is that what you're saying?
Where are the people? Where would the people have to be to go upstairs to the living room to look at the photos?
I'm not understanding the question.
If the photos are on the first floor, Mr. Higgins,
yes,
the only floor beneath it is the basement.
Okay.
And someone says, we went upstairs to look at the photos, where would they have to be?
Well, who said they went upstairs?
All right, so Mr. Jackson, you can save this for argument. Next question, please.
If Brian Albert said you went upstairs to look at the photos, where would you have to be?
Objection. Sister.
Now, Brian Albert had a weight room someplace in the house, right?
Yes.
And a gym.
I guess he called it a home gym.
Where was that?
In the basement.
Had you ever been down to that basement before?
Yes, one time.
When was that?
That was during the twins' graduation party. Summertime.
Summertime before.
Summertime before.
See, the twins' graduation party. They fucking had a car, motherfuckers. Why aren't we talking about this? You're gonna tell me that motherfucking graduates, 18-year-olds, they don't have a car? You're an Albert and you don't got a car? Get out of here. I mean, where are the twins' vehicles? Because they could potentially both have a car. Where are all these goddamn cars? I'm sorry, but this is just, please talk about the vehicles.
Before, yes.
Summer of 2021?
Maybe.
So Brian Albert testified that he'd never been in the basement. That would not be accurate.
Objection. Sustained.
Now, you do recall giving testimony in another proceeding on June 1st, 2023, correct?
Yes.
And of course, the same thing applied. You were under oath. Is that right?
Yes.
You knew that it was a crime to lie under oath?
Yes.
In that proceeding? During the course of that proceeding, you were asked who was in the house and who you saw come into the house, correct?
Yes.
And during the course of that testimony, you admitted that you observed a tall, dark-haired male enter the Albert house that night, correct?
I believe that was in reference to ask to somebody's brother in a pickup. I don't know if that was during.
All I'm asking you, Mr. Higgins.
Wait, do you hear this right here? He's basically saying that he's This just gives me ugh.
Did you say that? Did you say a tall, dark-haired male entered the house while you were there?
I said they might have.
Did you say they might have?
Yes. And that was in reference to somebody's brother.
Yes.
And that was in reference to someone's brother. Well, what dark hair? Let me tell you that what's her name? Julie Nagel's brother doesn't have dark hair. Colin Albert has dark hair.
Isn't it true that you indicated that a male showed up who may have been Julie Nagel's brother, correct?
I said might have, yes.
Right. But there was no question in your mind that a male did in fact show up, and you described him as tall and dark haired, right?
Yes.
You were asked, a male showed up where? And you answered, quote, showed up at the house that I didn't know. I think he was there very briefly. I was half paying attention to it. Question, did that male come inside the house? Answer, I believe he did. Do you remember that?
Yes.
So a male did come in the house that night, correct?
No, I said I believe he did. I wasn't sure.
Well, when you testified at the prior hearing, you were asked, so you saw someone else come? Question. Answer, somebody else. Yes. End quote. That's what you testified to under oath, wasn't it?
Is that in reference to that?
Wait a second.
What page are you on, Mr. Jackson?
Page, he did.
Hold on.
His brother, correct?
I said might have, yes.
Right. But there was no question in your mind that a male did in fact show up, and you described him as tall and dark haired, right?
Yes.
You were asked, a male showed up where? And you answered, quote, showed up at the house that I didn't know. I think he was there very briefly. I was half paying attention to it. Question, did that male come inside the house? Answer, I believe he did. Do you remember that?
Yes.
So a male did come in the house that night, correct?
No, I said I believe he did. I wasn't sure.
Well,
So this proves, okay, ready? This proves that where he says he was parked with the Jeep, this would mean that when Julie Nagel's brother arrives, they would have been parked on top of his Jeep, where the mailbox is. Okay. Also, Julie Nagel's brother, Richie, they were asked, did you see a Jeep with a plow? No. No, I did not see a Jeep with a plow. I was half paying attention. Did he come into the house? Yeah, I believe he did. Well, what were you doing that you were half paying attention? Is it because basically one of two things. Either the person that you're referring to was not Julie Nagel's brother that went to the house, because you couldn't have been parked where you were when Julie Nagel's brother arrived, because you weren't, because they were parked there and they were the ones that came in following, Karen Reed, and there was no Jeep there. Unless you weren't in a Jeep at all and you were in a different vehicle. I just wish I had the fucking discovery.
When you testified at the prior hearing, you were asked, so you saw someone else come? Question. Answer, somebody else. Yes. End quote. That's what you testified to under oath, wasn't it?
Is that in reference to that?
What page are you on, Mr. Jackson?
Page 485, 46, I believe. Yes. If I may?
Yes.
Thank you.
Look at the top part that I highlighted. Mr. Higgins, do you have that in mind?
I do.
May I approach?
Yes.
You were asked the question, quote, did that male come inside the house? You answered, I believe he did. Question, so you saw someone else come? Answer, somebody else. Yes, correct?
Yes, but I also said that I wasn't paying attention.
I realize that you want to explain your answer. I've asked you a very simple question. Was that your testimony in front of another proceeding?
Yes, it was.
At another proceeding, which you were under oath?
Yes, it was.
Okay. You also said that you only remember seeing that person come in briefly. And it looked like he was having a conversation with the two girls, briefly, correct?
Yes.
You were asked how long was the person in there roughly, and you said it was quick. Less than a couple of minutes. I mean, it was quick, correct?
Yes.
And then you were asked what he looked like, and you said, I feel like they were a little bit taller. He had dark hair, correct?
Yes.
So you testified that a tall, dark-haired male came into the house, at least briefly, in your testimony, correct?
Yes.
Approximately when in the timeline of events did that unidentified male enter the residence?
I don't know the time frame. It would have been while I was there.
When you gave your statement to the Massachusetts State Police, you didn't tell them about a tall, dark-haired male coming into the residence at 34 Fairview, did you, on February 3rd?
I don't recall.
You were specifically asked by ADA Lally, when you testified before the state court grand jury on April 28th, 2022, who else was present, correct?
Yes.
And you never mentioned a tall, dark-haired male coming into the house, did you?
No.
However, on June 1st, 2023, at this other proceeding, you were specifically instructed at the start of your testimony that it was a crime to give materially false statements in that proceeding, correct?
Yes.
And that's the proceeding in which you admitted that there was a tall, dark-haired male who came in the house. Yes or no? Yes or no? Is that proceeding?
Can you answer that, yes or no?
No, I can't, Your Honor.
Next question, Mr. Jackson.
The quotations the quotes that I just read you and that you just looked at,
yes,
that was from the June 1, 2023 hearing, wasn't it?
I don't know.
Okay, so I'm going to tell you how I feel about this. The jury has no fucking clue what's going on here. You understand? Like, they're not following this shit. We may be able to follow it because the jury is supposed to not know all the ins and outs of what has occurred, right? And they don't. Like, people that aren't like fucking crazy like us, they wouldn't. So this type of stuff, I'm sorry, but you're going to lose the jury. Not because Alan Jackson's wrong and this guy's a complete fucking piece of shit, but because, listen, man, we're playing a game. That's how they have to look at it. And the people that you have to win over are lay people, are people that don't know this stuff. Either they have to make a push for it in the motions in limine to say that we can use the federal case in terms to identify what proceeding and what it was for. Because otherwise, I'm sorry, you got to throw this shit out, man. You got to throw this stuff out, or you got to compact it differently, because they're not following. I agree, Sleuthy. Yeah, I wish more people were crazy like us. It's no knock on Alan Jackson, man. And he's thinking and hoping and praying that these people, like, how can you not get it? But it's not his fault. He's not able to say certain words, and that just can't be. That has to change. So and the elicited testimony that you just need to get is that you testified at the first trial, and you said that a guy came in the house that was tall with dark hair, and he talked to the girls, right? Okay. Can you describe what is your definition of tall with dark hair? That's not like a blonde-headed person, right? All right. Would they be taller than 6 foot? Like, make him describe what he means by tall. Okay. And then remind the jury that the Nagel brother said he did not go into the house, and Richie, the driver, did not go into the house. Okay. And Julie Nagel said that she actually had to go outside to speak to her brother, right? And they parked where he was parked. So either they're on top of each other or he had already left, right? And it's because I personally believe that he had already left, and he just had left really close thereafter, in my opinion, because I believe John O'Keefe got in his vehicle. I do. And it goes totally with the story of why Karen would have been saying stuff about being a perv and like that he was out fucking somebody else. Because at that time, you know, when you wake up the next morning, you're thinking, well, no, he went into the house. You know what I mean? But maybe that's what you thought he did. But really, oh, fuck, wait. He did. He got into what I would have said. I would have been calling a perv. He's going to go fucking somebody else. Like, it just seems like to me that the person that he's referring to that was taller, darker hair, that's Colin. That's Colin. So Colin would have still been there when he was there, right? And that comes out in the trial that yes, he was, because when Brian Albert gets home, Colin, like, they have like this brief exchange, and Colin's leaving and going out the door. So who do you think fucking got into it with John? Do the people in that area, like, are they the type to break up a fight, or are they a type to be like, oh, I hate that motherfucker, let me get some punches in too? Oh, fuck yeah, get him, Higgs. And then, like, I'm just, because I'd be the type to, I wouldn't go in and gang up on somebody and I would be trying to break something like that up. Like, hey, what's going on? You know what I mean? But this timeline right here is really, really significant. Because if all you're trying to do is establish that Colin's in the house, we've already established that with Brian, Albert, and Nicole by them saying that when they got home, like, oh yeah, I was coming in and like he was leaving, because then I went to the bathroom, is what Brian Albert says. I went to the bathroom. By the time I came out, he was already gone, right? Well, Higgins testifying that he was even there before Brian Albert, and then making it that it was Colin Albert. To me, is it just to corroborate that, like that Brian Albert's already saying that Colin was there? You know what I mean? Or is it about a time? Are you saying that Colin was there longer? That he didn't just, dip in, dip out? So I think that this needs to be cleared up of what you're trying to push here with, I'm only saying this from the jury standpoint. After I've listened to these interviews with these jurors, I'm sorry, these people that are human like us check their common sense at the door, and they are followers. Okay? You need to make really strong points to just say things like, so that somebody in that room can be like, wait a second, no, that can't be possible because of this, when they're giving all these possibilities. But then you don't want them to go back to the jury room, and you're not here to solve the case. We're here to show you that the Commonwealth does not know what happened to John O'Keefe. Nobody does. Their own witnesses didn't see the body. Fucking That is what you're going to beat into them. And if they don't know the case, how are you supposed to know the case? And that is the definition of reasonable doubt, okay? We know that Karen Reed didn't do this, but we don't have to show you that. We're going to show you that they don't know what happened to that man because they didn't investigate it properly, okay? And then it's questionable if you want to say that they plant evidence so that they could seal it up for an officer because, hey, we need to get him justice. This is ridiculous. But you're going to be having 6-hour cross-examinations of people. Like, fuck, you need to hit hard on what it is, man.
That's what we just read, and that's
like whatever you testify, blow it up.
The first page.
I see it, yes.
May I approach?
Yes.
What's the date, sir?
June 1st?
2023?
Yes.
Like, what's his testimony when it comes to the fact that, okay, when did you see Karen Reed arrive in the vehicle? Like, what's his testimony when it comes to that? Higgins knew John went into the house, but I would never say John had a hat on. John had a hat on. The jury is not going to associate that with him, so he is going to have to say, and he knows who John is, so he would never refer to somebody as that guy. Like, you just point blank, did John go into the, he says that he didn't. I did not see John go into the house. Did you see John, period? So then you would have had to leave this house before John and Karen arrived, right? Because you would have saw a body on the motherfucking lawn, right? You're a goddamn fucking officer. Like, that's the type of stuff that, you guys, for all we know, John gets out of the vehicle. He's drunk. He walks down the street and goes off. He didn't go in the house, and he's not on the lawn. Where's John O'Keefe from 12:30 until 2 o'clock? What is the jury going to think? We need the jury to think that there's another option in a one that is logical. A logical option, because they're not going to believe that 7 to 12 people that are all congregating right there by the door are not going to see this man, and that these friends aren't going to, why don't they just say he came in? Well, because if they say that he came in, then clearly Karen Reed couldn't have fucking backed up into him. But I disagree with that, because he could have came in and said, I got to go back out there to tell Karen that we're all good to stay here. And then me and her get into it then, and then she fucking hits me. Okay? So their logic when they set this whole thing up is that they always thought that if he ever came into the house, then fuck, it's all over. And then you have to think to yourself, why do they think that? And that would have to do with timing. They knew the timing of things. So you have to think, like, why couldn't you say, yeah, he came in, but then he ran right out to go get her? Why couldn't it be that? And that's when I was like, and what it leads me to believe is that shit happened before he even got, like, going into the house. Because if everyone's arriving at a place around the same time, you're like getting out of your car and you're all seeing each other right then and there. Like, you're telling me that they didn't have words before they got in there, if that would have been the case. And if Richie and these guys are able to pull up and Higgins' car is not there, then that's That's giving, you would need to push it that, what's her name? That Karen wasn't tailgated in there then. I also believe that it's possible, right? To say, it's just, the jurors can't go back. They just need to stick with a couple things. If they stick with a couple things, then this is just so quick and easy. You need them thinking that all of this stuff, we don't know. We don't know. How do we know that she did this? This is what they're saying, but the witnesses are all saying that he wasn't on the lawn. I say you got to stick with the time. In order for Karen Reed to be guilty, this act had to have occurred before 12/28. You say it like that, you're going to get a not guilty verdict back. Because this man was not killed before 12:28 a.m. We cannot prove that beyond a reasonable doubt. The state cannot, or the Commonwealth cannot prove that John O'Keefe was killed or injured to the point that he then succumbed. The injuries, you cannot prove that the injuries began at 12:28 a.m. And in order for Karen Reed to be the culprit, the injuries would have had to have happened before 12:28 a.m. And that is not proof. You cannot prove that. Because it's cause and effect. In order for you to say that then, in order to test your, yes, that's possible, you would have to then say that's why they saw the body on the lawn. But they're saying we didn't see the body on the lawn. And not one person, but 12. It's cause and effect. We learned this in 3rd grade. We learned this in 4th grade, cause and effect. Fuck, man, these jurors, like, you just got to you got to put war rooms together, and you have to, like, weed stuff out and say, okay, yeah, we're going to lose somebody if we go this route, or we're throwing way too much at them, or you need to clean it all up in closing and say, you guys, we provided you guys all these possible scenarios. And the reason that we're able to provide you guys with all these possible scenarios is because they're all reasonable. And they're all reasonable because they were never eliminated. None of this stuff was eliminated. It wasn't eliminated in the investigation, and it sure as shit wasn't eliminated here in the trial. And in fact, we just went from having maybe a couple culprits that we now even have more people that, could have been involved in this based on, we don't know what happened to John between 12:30 and 6 o'clock in the morning. But we know that he wasn't on the lawn, and all of their witnesses say that, and he doesn't show up on the lawn until 6:03 or at some point, obviously before that, but it definitely wasn't at 12:28 when my client would have had to have left. And with that, you have to say not guilty, because it's unreasonable that you can say that you are convinced beyond any reasonable doubt that it happened by what the Commonwealth is saying when their own witnesses are going against it. Maybe even use a little thing to say, if all those witnesses were on this jury, they couldn't even convict Karen Reed. And they were there. They would have to tell you, fuck, I can't convict her beyond a reasonable doubt because I was there and I didn't see a body, you guys. You don't understand. I did not see a body. There's no way I would have missed that body. It's the lawn is this big. And there's no way that all of us would have missed it.
How long did you stay at the Albert residence in total? From the time you got there till the time you left?
Maybe like a half hour, less than an hour.
And what time did you leave? Say 12:30, you said?
I think I said between 12:30 and 1 a.m.
And you indicated that you pretty much didn't say goodbye to anybody, right?
Right there. We got him. You guys, the Canton Police Department, do you understand? Where the fuck did he go? We have him now on a phone at 1:34, okay? The Canton Police Department is literally minutes. Let's just even say that it's 10. Fuck, I'll give you 10, but it's not. It's like fucking 5. Let's say 10. I was there. It's 5 minutes away. We have you on a camera at 1:34 a.m. on a phone. And you get there and you're there. It's something like 1:30 or 1:34 by the time like he gets there, moves these cars around, and then he's like, leaving. Do you understand that now we get to go, woo, yeah, okay. He said that, yeah, 12:30, he's like, I would have left between 12:30 and 1. You guys, 12:30 and 1, he would have left. Maybe he's not lying about that. Who'd you leave with? Who left with you? Who was it also in your vehicle? Hey, I'm calling you. Hey, did you get those fucking girls out of there yet? Tell McCabe's to fucking take those girls home. Nobody can spend the night. I'm coming back there. Seems like Higgins would be calling to see, hey, did you get those girls out yet? I came to move these fucking, I left to, I'm over here to move the vehicles or whatever. Although, did they leave yet? Get them out of there. But you guys, if he would have left at 12:30 or 1 o'clock, where was he until he showed up now on a camera, which is exculpatory in my opinion, okay? Because I want to push the narrative that fucking John O'Keefe is in Higgins's vehicle, like I've said since last motherfucking year. And I didn't even know that the video ever existed. But now we have proof that he was at Canton Police Department at 1:34 p.m. Oh, hell yeah, Lana. You're absolutely right then, because if he would have left at 12:30 from this house or 1 o'clock, he would have been at Canton at 1:05 or 12:35. Or, if it was in between at 12:45 he leaves, he would have been at Canton Police Department at 12:50. Okay. Which means that where did he go? Either it means one of two things. He didn't go straight to the Canton Police Department when he left this house, right? Or he really truly left this house more like at 1:25 a.m. That makes a lot more sense that Higgins would call Brian and say, get those girls out of there. Yeah. Hey, have they left yet? What the fuck? Okay. So now think about this now. Now we get to really talk about where people were parked and why it's important. Higgins, for whatever reason, they were like, here, I'm going to say that I was parked on the street, right? Versus like, why can't I just be parked in the driveway? Well, I think the reason that he said that he was parked in the street is because he truly couldn't park in the driveway. So he really did park in the street, right? Because there was a driveway full of fucking people, like I've been saying. There's a driveway full of vehicles. Especially if Allie said she pulls into the driveway, okay, to pick up Colin. So that's another freaking car in there. And that's why I said, oh, he's just plowing Allie's car up too, and he's dropping plow. I got good things to add to this amazing timeline. Higgins, come clean. They're gonna pin it on you.
At the house?
Correct.
I just kind of left. I said, see you later. We'll turn around, left.
Matter of fact, at that same hearing that we just looked at, your statement was, I made a beeline out of it, correct?
I don't know if that's the verbiage I used, but I left.
Why the rush? Why did you leave so quick?
Because it was a long day and I just wanted to go home.
Except you didn't go home, did you?
No, I went back to Canton PD.
Right.
You're about to use that against him too, as it was a long day and I wanted to go home. Okay, well, did you go? So he's saying that he went straight to Canton PD. Well, then that means that you wouldn't have left until 1:30. So now we can use that against him. 1:25. Oh, God. Yeah, so that means you didn't leave until 1:25 a.m., but he had such a long day and wanted to get home. That's a lie. And look at how he changes the way that he answers that. It's defensive. And you want to start reading people's tells.
Why the rush? Why did you leave so quick?
Because it was a long day and I just wanted to go.
That half smile. Tell.
Go home.
Except you didn't go home, did you?
No, I went back to Canton PD.
Right. So it wasn't such a long day that you actually drove home. You went back to the Canton Police Department at 1 or 1:30 in the morning, correct?
To move vehicles, correct.
Well, let's talk about you leaving. You walked out the side breezeway door, correct?
Yes.
You walked down the driveway.
Yes.
There's nothing obstructing your view at that point of the lawn to your right, correct?
I didn't look over there, but I would not think so.
Between you and the flagpole, in other words, there wasn't some mound of dirt, something obstructing your view. You could see straight across if you wanted to, correct?
If I wanted to, yes.
It's just basically a flat, grassy lawn with a light dusting of white powder snow on it, right?
I don't know how much snow was, but there was snow there.
Yeah, you indicated that it wasn't even enough to stick to the pavement at that point.
Well, that's when I got there. Yes.
Well, you only stayed less than an hour, right?
That's correct.
So I'm assuming you didn't dump 3 feet in an hour, correct?
I think we can both agree that it's not free. It wouldn't have been 3 feet now.
Right. So it would have been a light dusting of snow.
More snow than there was there.
How far would you say it was from the edge of the driveway over to your Jeep?
From where the back of my Jeep was parked?
Correct.
Maybe a foot or two, or it could have been even with the edge of the driveway.
Oh, no, I'm sorry. That's probably a bad question on my part. When you left the house, as you started to walk down the driveway toward your Jeep, how long of a walk is that? Across the yard to down the driveway to get to your Jeep?
Short.
30 feet?
Maybe.
Okay. During the course of you walking out the door, heading to your Jeep, you didn't see anything out of the ordinary in the yard, correct?
No.
You certainly didn't see a body in the yard.
Of course not.
Right there. This is what they need to stick with, you guys. This is what they need to stick with. Of course not. I didn't see a body. Of course not. I didn't see a body. He just says right there, of course not. You would have seen a body. Yeah. There was a body there. Of course not. This is what they need to stick with. Let these jurors believe them. Let the jury believe them. Because the jury's not going to go back to the deliberating room and be like, you know what? I don't believe any of these fucking witnesses. I mean, because clearly that's what we've always asked them to do in other cases and they don't. So let them believe these fucking liars. Ask them these questions, okay? But let them believe them. Exactly, of course not. Okay?
Now, you get in your car, and it's facing directly toward the flagpole, correct?
It's facing directly up the street. The flagpole would be off to the 1 o'clock.
Right. So just a few degrees off to the right, the flagpole is, correct?
It's off to the right.
Just a few degrees.
I don't know how many degrees, but it's off to the right.
Well, you just said 1 o'clock. You're a former military guy, right?
I am.
Okay. 1 o'clock means 1 o'clock on watch. 12 o'clock is due north or right in front of you. 1 o'clock is just a few degrees to the right, correct? That's what you meant.
At the 1 o'clock, yes.
Okay. So you didn't see a body when you got in your Jeep.
No, I did not.
Then you turned the engine on, correct?
And the wipers, yes.
And the lights.
Yes.
And the lights lit up everything in front of you, correct?
Yes.
Still didn't see a body, did you?
No, I did not.
Sitting in the driver's seat, you put the car in gear and you begin to roll forward, right?
Yes.
But there was a plow on the ground that scraped for a foot, right?
Yes.
So you picked it back up,
Yes.
looked out the windshield to make sure the plow was situated, and continued to roll forward, correct?
I knew it was up when I continued to drive.
And as you continue to drive, you're looking ahead of you and probably to your left to make sure that there's no oncoming cars, right?
Well, I knew there was no oncoming cars. I was just driving forward.
Right. So your focus is directly in front of you.
On the road, yes.
And everything in your peripheral vision is right in front of you as well, correct?
Yes.
Nothing obstructing your view.
I mean, other than snow on the car.
Nothing obstructing your view outside toward the lawn. When another car parked there.
No, I didn't. There was no vehicles in front of me, no.
It was the roadway was relatively empty.
There was no cars.
And you didn't see a body then either, did you?
I did not.
And as you drive past that flagpole with everything lit up and everything in your peripheral vision, you still didn't see a body on that lawn, did you?
I did not.
Right here. And it's what you're going to be able to use now. You're now going to be able to really pinpoint this down because you're going to use the fact that, well, we have you on the Canton cameras here. That's you, right? You're making a phone call. So you would have had to be driving away to go to the Canton Police Department at 1:25, right? These are police officers. Let the jury believe them. This is about Karen Reed can then fucking sue these motherfuckers and do civil court and get all this shit out.
You're a former firefighter, is that right?
Yes.
That puts you in a position of being a first responder.
Yes.
And you're currently a law enforcement officer.
Yes.
That puts you in the position of being a first responder, correct?
I'm also a tactical medic, yes.
Which means that you have training to be an observer. You're a trained observer, more than the average person, correct?
Yes.
You look for things out of the ordinary. You look for things that don't belong. as an investigator, former firefighter, first responder, correct?
Yes.
And you did not see a 217-pound man bleeding out on the side of the road in the lawn or in the yard, just to your right by that flagpole, correct?
If I did,
I didn't
I
ask
would
you
have done
if you
something
did.
to help him.
I asked you if you saw one.
No, I did not.
And if I did, let him say that. And if I did, I would have done something to help him. Let him say that. You guys, this is really compelling. And the only way that Karen Reed could be guilty is if there is a body there. Like, I get everybody wants to get these fucking pieces of shit, but I want this nightmare to be over for Karen Reed. Like, every day this stress, you know what it would be like? Like, oh my God, this jury could just come back and say, I'm guilty. I couldn't imagine what, like, to hear the words, like, the jury's back in, like, it's like, wow, I may never walk without a fucking guard around me again.
And that's because there was no body there, correct?
I didn't see anything.
Because if there was a body there, you certainly would have seen that.
Objection.
How is that objecting to? How is that even objectable? In your line of field and what you do every day, if there was a body there bleeding out, you would have seen it.
Where exactly did you go when you left 34 Fairview?
I went back to the Canton police station.
When you were asked that on direct examination, you said you weren't sure where you went when you left 34 Fairview, either home or to Canton PD.
No, that's not what I testified to.
Did something jog your memory about where you went?
That is not what I testified to. That was in relation to where did I go after I left 34 Fairview the next morning.
Why did you go to Canton Police Department that morning?
What's the question?
Why did you go to the Canton Police Department that morning?
See, AJ can't get hung up on something like that. The way that the jury would look at that is like the defense just tried to trick him. That cannot happen. The jury has to like you. Okay, that question right there before that, to say that, and then AJ not being able to tell him and show him that he's the one that's wrong. So take that out.
The morning when I left 34 Fairview, the Friday into Saturday?
Correct.
To move 2 vehicles.
There's been quite an evolution of that story over the years, has there not?
I don't understand the question.
All right, let's talk about that for a second. You had an initial interview with Massachusetts State Police on February 3rd, 2022.
Yes.
Correct? And you indicated during the course of that interview, which was just a couple of days, 5 days after the events in question, that you left Brian Albert's house, went to Canton PD to, quote, fulfill some administrative obligations, end quote, correct? You later said, when you testified in front of the grand jury on April 28th, that you went to Canton PD to do, quote, administrative work, correct?
Yes.
You never mentioned.
I said administrative things.
You said administrative work was your testimony in your transcript.
I believe it was things, but okay.
Okay. Can we agree, Mr. Higgins, that you didn't mention anything about moving cars around, correct?
Well, that would be administrative.
So when you say I went to Canton PD to do administrative work or administrative obligations, you meant moving your car, your personal vehicle?
Yes.
Okay. Although you didn't say that you were going there to move your personal vehicle, right?
No, I said I didn't move my personal vehicle. I moved work vehicles.
Or either one. You just traded off vehicles, moved them out of the way, right?
I moved the purpose for going back there was to move 2 work vehicles.
And the reality is you'd gotten Canton PD earlier in the afternoon and actually moved some other vehicles, traded vehicles, didn't you?
I swapped vehicles out. That's correct.
Right. And you left the vehicles that you now claim you had to go move exactly where they were, even though you knew a blizzard was coming, correct?
That is correct, yes.
So you didn't move the cars a few hours earlier, knowing that you just have to come back and move those cars a few hours later.
I was more concerned to go eat and have a drink because it had been a long day.
So wouldn't you want to move those cars early on so you wouldn't have to go all the way back to Canton and play parking lot with these cars in the middle of the night?
Not really.
Mr. Higgins, you weren't actually at Canton PD to do administrative work at 1:30 in the morning, were you?
I was moving the vehicles. I'm sure it's on video.
And we'll talk about the video in just a second.
I'm sure it's on video. He knew it was on video. Aaron, he needs to ask him because of that line of testimony. I'm sure it's on video. He knew that it was on video. It's like he knew that the Commonwealth had that video, and here they really truly did. I would think that he would have seen that before. So you can ask him that. Well, you testified that in the first trial that and I'm sure it's on video. Is that because you knew that it was on video? Had you had seen it before? No, I just know that we have cameras type of thing. Because then you have to think of like a cop, you guys. Why truly go to, if you're doing something nefarious, why would you go to a place that you know has cameras? You wouldn't. Unless you're doing something in order to be seen to give yourself an alibi. Like, oh, that could, like, you know what I mean? Which would mean that you would know when something would have occurred.
You entered the Canton Police Station through which door?
I believe it was the door to the right of the Sally.
Okay, but think about this, guys. If he needed to feel like he had to establish an alibi, like at that time, what's the, if we're over here saying that something happened to John O'Keefe at 12:28 or 12:30, right? Then being on a camera at Canton at 1:30 does the fucking no good for something that could have happened at 12:30. Unless he knows that what happened and something that was going on was he going to try to claim that he was there longer at first until, like, just think about that, figure something out, because something's really interesting with that. Because who the fuck cares if you're at Canton at 1:30? This shit happened at 12:30, you know?
Report as you come in the main entrance.
And you made note of who was on duty that night, correct?
I didn't make note. I walked by, I saw somebody sitting in the control room, and then just went about my business.
So you immediately knew that your friend, Officer Good, was working dispatch, right?
Hear something? Or? Do you want to head over there? So why don't we take a 5-minute recess?
Court, all right. Let's put everything up.
Try to go through and, like, sometimes people tell on themselves with testimony.
Beth McLaughlin is so nice. She's the nicest person, Beth McLaughlin. Beth McLaughlin, oh my God, so good.
Who the fuck is talking on this hot mic?
Correct.
I don't know. I mean, it could have been 15 minutes. It could have been.
Oh, wait, right here. This is the part I want. So a juror had, like, an asthma attack. It's bad. Look at her.
Thank you.
Bad.
Hey, let's bring this to Higgins back. Thank you.
Thank you.
God, the rock star, Bev.
All right, Mr. Jackson.
Thank you. Mr. Higgins, if you went back to Canton PD at 1 o'clock, 1:30 in the morning, you would certainly be in a position to monitor anything that was happening at Canton PD at the time that at least you were there, correct?
No.
I mean, you would be inside the building, correct?
Yes.
With access to dispatch.
Now, okay, think about it. Now, he didn't go there to get fucking no alibi, y'all. Okay, I know exactly where AJ's heading with this. He went to go see, did Karen call the police? Did Karen call the police yet? You know, John's not home, right? He didn't come home yet. He's like, she was calling his phone, saying all these things. Did Karen call the police yet? And then he gets on the phone and calls and tells them there's been no calls. He goes there to see. Yes, now you can make a move to get his phone.
Anything else that was happening around that floor, that area, correct?
I did not go into dispatch.
You would have access to the interior of the police station at that time if you went back to Canton PD at 1:30 in the morning, correct?
I'd have access.
You could see if there was any activity going on, any calls, call outs, things of that nature.
I didn't have access to that. And I wasn't looking for it.
Not that you were looking for it, Mr. Higgins. My question is more simple than that. If you were there, you'd know what was going on inside the building.
No.
So if you walked in, you would just be completely oblivious to anything that was happening. For instance, if troopers started amassing to go out to a call, you wouldn't see that.
Objection. The objection sustained. Ask it differently.
You were able to monitor. You'd be in a position to monitor what was happening at the station around 1:30 in the morning when you were over there, correct?
No.
So how long did it take you to get home from Canton PD?
A little longer from after I moved the vehicles.
Correct.
I don't know. I mean, it could have been 15 minutes. It could have been 20 minutes.
You live alone?
I do.
You did then?
Yes.
What did you do when you got home?
I think I had something to eat, maybe a couple more drinks.
And you went to bed?
Was either on the couch or in the bed watching the news.
In any of the prior testimony that you've given in this case, have you ever indicated, ever, that you slept on the couch that night?
I don't know.
Well, you reviewed your testimony before you
Well, those would be the two options.
Okay. I didn't ask you about your options. I asked you if you reviewed your testimony before you testified today.
Yes.
Okay. When you reviewed your testimony previous to coming in here today, did you ever testify that you slept on the couch that night?
No, I slept in my bed, but I could have started somewhere else.
Did you ever testify in the previous hearing that you started somewhere else?
Not that I know.
Did you ever mention a couch in any of your description about what you did when you went home that night?
Not that I recall.
As a matter of fact, what you did mention under questioning in a different hearing was that you may have gotten something to eat, you then went to bed, put your stuff on the nightstand next to your bed, correct?
That would be the routine, yes.
Okay, so I would cut all of that stuff out and just ask, didn't you testify at a previous hearing that you, when you go to sleep, you put your phone on the nightstand to like charge it or whatever? Okay. Yes. You see what I'm saying? Like, that's letting the jury know that his phone is not in bed with him.
You did not make or receive any calls after returning home that night?
No.
You were clear when you went to sleep in your prior testimony that you put both your work and your personal phone. You had two at the time, correct?
Yes.
A personal and a work cell phone, right?
Yes.
You put them both on your bedside table because that's what you do every night. Is that right?
Most often, yes.
As a matter of fact, you were asked whether or not you have a charging station, and you said, yeah, it's right on my bedside.
I don't know that I don't have a charging station.
Right. You said no, bedside. In other words, you keep your phone by your bedside, on your bedside table.
Usually.
You also testified that you did not use your phone that night to go on social media, correct?
That's correct.
You indicated that you don't go on, you didn't go on social media because you don't have social media. You don't use it that much.
I don't.
You said, I don't have the gram. I'm guessing that means Instagram, correct?
That is correct.
And you don't use Snapchat and you quote, don't do those things, correct?
That's correct.
All right. So you testified that the first call you received after returning home on the 29th was a call from Chief Berkowitz just before 7 a.m., which woke you up. Is that right?
It was around 6:30ish, I think.
Okay. Your testimony previously was at some point before 7 a.m. That call was the one that woke you up.
So I added that to my 6:30 a.m. I think that's just a really interesting time. I think I noted that in my timeline. These people are just sick.
Yes. And it turns out, Mr. Higgins, that was a lie, wasn't it?
No, it wasn't a lie.
When you were asked that question at a previous hearing, you didn't know that the person questioning you had your phone records, did you?
I assume they did.
And you were thereafter confronted with those phone records, correct?
I was asked about them, yes.
And those phone records established that you and Brian Albert actually exchanged not one, but two phone calls at 2:22 a.m. that morning, at a time when you claimed you were in bed asleep, correct?
I have no recollection of any phone calls.
May I approach you on?
Yes.
Let me see how he questioned him.
That's correct.
You indicated that you didn't go on social media because you don't have social media. You don't use it that much.
I don't.
You said, I don't have the gram. I'm guessing that means Instagram, correct?
That is correct.
And you don't use Snapchat and you quote, don't do those things, correct?
That's correct.
All right. So you testified that the first call you received after returning home on the 29th was a call from Chief Berkowitz just before 7 a.m., which woke you up. Is that right?
It was around 6:30ish, I think.
Okay. Your testimony previously was at some point before 7 a.m. That call was the one that woke you up.
Yes.
And it turns out, Mr. Higgins, that was a lie, wasn't it?
No, it wasn't a lie.
When you were asked that question at a previous hearing, you didn't know that the person questioning you had your phone records, did you?
I assume they did.
And you were thereafter confronted with those phone records, correct?
I was asked about them, yes.
And those phone records established that you and Brian Albert actually exchanged not one, but two phone calls at 2:22 a.m. that morning, at a time when you claimed you were in bed asleep, correct?
I have no recollection of any phone calls.
May I approach you?
Yes.
Please. May I approach? Yes. Thank you. Take a look at those two documents and tell me if you recognize at least the top one.
Do they have a page number for me to follow or no?
I was just asking Ms. Little. I don't think we've introduced them, and no, they don't have a page number, but I'm going to ask that they be marked for identification at least at this point. Do you recognize those?
Yes.
May I approach?
Yes.
If it's okay with the court, may the witness maintain those documents?
Sure.
I'd like to have those two documents marked only for identification with the court's permission.
Okay. As one exhibit?
We can do it as one exhibit, that's fine.
Okay. Could you please hand those to Madam Clerk?
Yes, Your Honor.
Sorry, was it?
Thank you.
May I inquire?
Yes.
Mr. Higgins, you see the document on the lower right. It has a page number, or there's a numeric indicator 01770, in other words, 1770.
On the lower right-hand corner?
In the right, I mean in the red.
It says 01771.
Look at the next page. I think they're just out of order.
Why don't you come show
Am I
me?
missing something?
Oh, it's just marked over. Sorry, that's the protocol. It's okay, it's okay. I'll use the one with QQ and the one with 1771 because the other numbers.
When you're referencing them? When you're referencing them?
When I'm referencing them.
Okay.
Take a look at the one that's marked with the QQ.
I see it.
You've seen that document before, correct?
I think I've seen it maybe on a screen, not in my hand.
That was these were the records that were shown to you in a prior hearing?
Yes.
And you acknowledge that at least the one marked QQ is a record of your calls, correct?
It has my name, my telephone number, correct?
And it indicates that on January 29, 2022, at 2:22 and 35 seconds, you received a call from Brian Albert, duration of 1 second, correct?
Yes.
In other words, Brian Albert called you at 2:22 and 35 seconds, but it looks like you missed the call, correct?
I see the 1 second call, yes.
There's a second call just below that. On the same date at 2:22 and 52 seconds from you to Brian Albert. Do you see that one?
Yes.
And the duration of that call is 22 seconds, correct?
I see that, yes.
So 17 seconds after you missed a call, according to these records, from Brian Albert, you called him back, and there was a call lasting 22 seconds. Is that right?
That's what the records say.
May I approach?
Yes.
Okay, so the timing that I would have for all of this would be like this. If I'm at Canton, that's 1:34, and I'm leaving and I go straight home, okay? I could get home before 2, all right? But if I'm actually at, Canton to say, yeah, nothing's come in yet, okay, I'm heading back over then to Brian Albert's house because I have to help him clean up this mess, figure shit out, right? So that means I would be going back, to Canton or to their house, right? And if Higgins' Jeep actually pulled into the driveway and then his Jeep was parked in the driveway, I'm just trying to see if there's at all any way possible that for some reason he would have taken Caitlin Albert's Cherokee and how that would have happened. That here, take the Cherokee because we have John's body in the Jeep. And that's why he would have slipped and said he was in the Cherokee or a Cherokee. That's a Freudian slip with saying that. Okay, continuing on. Sorry, I'm just thinking out loud.
So the fact is, you were speaking to Brian Albert in the middle of the night, approximately 3 hours before Mr. O'Keefe's body was found in his yard, correct?
No, that's not correct.
And that was 5 minutes before 2:27 a.m. when there was a Google search for how long to die in the cold, correct?
Objection.
Sustained. And then, of course, you lied about that under oath in that prior proceeding by saying, I don't remember this phone call.
Objection.
Sustained. Did you, in fact, tell the truth at the prior proceeding when you said, I don't remember that phone call?
I always tell the truth.
Did you lie under oath, sir?
No, I did not.
Would you tell us if you did?
Objection, Your Honor.
Sustained.
Okay. Did he say? He's going to say that I was never asked if I made a call at 1:36 when I was at, or 1:34 when I was at the Canton Police Department. But it's who did you call? I don't recall. Well, you didn't call from your personal cell phone, right? Because we had those records, right? So you must have called from your work line, right? He had to have made that phone call from his work phone. Did they not have his work phone?
You acknowledge that there's a 22-second phone call in your phone records, correct?
That's what's reflected by the record.
And 22 seconds is quite an amount of time. Would you agree?
It's 22 seconds.
As a matter of fact, it's about this long, with the court's permission.
The court does not give permission. That's argument, Mr. Jackson.
If we were to count off 22 seconds, that's an uncomfortably long time, is it not?
No.
It's long enough to have a conversation, isn't it?
I didn't have a conversation.
Is 22 seconds long enough to have a conversation?
No.
A human being can't have a conversation in 22 seconds?
Sure they could. I don't think it's anything of substance.
Okay, so that's my question.
You guys, this is going to be amazing. If he called Brian Albert for that 1:34 phone call, he's so fucked.
Is it 22 seconds long enough to have a conversation?
I don't agree with it. No.
Now, when you were asked about this
conversation, what a fool.
And you were shown these records, that prior hearing, you had an explanation for what that 22-second call may have been and what the prior call may have been, correct?
Yes.
What was your explanation?
Well, I used a phrase that people commonly used as a butt dial.
So you think it's possible that you may have butt dialed Brian Albert for a 22-second call that you're not aware of?
I think it's possible that he could have been inadvertently called back, but I have no recollection of that, nor did I have any conversation with anybody.
But you admitted that you lived alone, correct, Mr. Higgins?
That's correct.
You had an iPhone at the time.
Yes.
Matter of fact, that number reflecting those records is in fact, or was in fact, an iPhone. Is that right?
Yes.
You already indicated under oath that you don't sleep with your iPhone. You keep it on your bedside table. Is that right?
Most often, yes.
There's nobody else in your room. Is that right?
That's correct.
And you had your ringer on because you were awakened the next morning by a call from Chief Berkowitz, right?
Yes, the ringer was on.
When somebody calls you and you miss the call, there's a notification that shows up on that iPhone. Isn't that right?
I don't know how mine's set up at the time. I don't know.
If you open up your phone app and you go to recents, it shows all the missed calls, correct?
I think you can get to them, yes.
And you know that the iPhone does not automatically call people back. That is not a thing, right? Miss a call from someone, it's not just going to automatically re-ring them.
Yes, I think we both know that, yes.
So to call somebody back, you have to go on your iPhone, open it up from a locked position, navigate to a phone application, then navigate to a contact, and then make a call, correct?
Objection. Sustained. You can break it down.
Sure.
How is that sustained? He is describing all the steps that would have to happen.
In order to call
compound, because it's all of those have to happen in order for a phone call to be mad. That is a bullshit objection and sustained. I'm sorry, but that's wrong.
Call somebody back if you've missed a call. You first have to unlock your iPhone.
You would have to, yes.
You can do that either through Face ID or through a 4 or 6-digit passcode, right?
Yes.
Don't tell me the code, but did you have a 4 or 6-digit passcode locking your iPhone at the time?
I don't know if it was a digit code or a Face ID.
Well, if you have a Face ID, you have to have a digit code
Holy
as well, right?
shit, that's even worse.
I guess so.
Okay. Did you open your...
Oh my God. My ass opens my phone, motherfucker. Sorry, guys. Shit.
Your phone with your Face ID or a multi-digit code?
I have no recollection of answering the phone or calling anybody back.
You also have to navigate, once the phone is unlocked, you have to navigate to the phone app, correct?
I don't know necessarily if you unlocked it with your face, if it would be right there. I've never thought about it.
Once you unlock the phone app, you have to manipulate the phone on the screen with your finger in order to make a call, correct?
You would have to hit at least one button, I guess.
At least one, right?
Yes.
So that's 3 or 4 interactions with the phone that have to be physically undertaken to just make one call, right?
But I didn't make any calls.
So how'd you butt dial?
I didn't make any calls. I have no recollection of any calls, nor did I speak with anybody.
See, these are the times you're going to quote all of this. So you didn't have any recollection of me making a call at the Canton Police Department. Well, you weren't asking me about that time. Well, you said that you had no recollection of any calls. Like, that's how you're going to, like, That's what you would say. You said any calls. Any calls that night. I just need you to remember calling somebody. Who did you call? I don't know. You don't know who you called. Well, it must have been really important. I mean, who did you think was going to be awake at 1:34 in the morning? How about that, you fuck?
After you were shown these phone records at that prior hearing, in that hearing at least, you finally admitted that you did in fact call Brian Albert back, but this time you claimed the two of you just sort of sat in silence. Isn't that right?
Objection. So I'm going to sustain it in that form. You can ask it appropriately, Mr. Jackson.
Did you ever previously testify that you did in fact make the call, but you did not have a conversation during the course of the call?
What I think I testified was something must have happened, but I didn't have any phone call.
Do you remember being asked, quote, did you call him back, end quote, and you answered yes? And then there was a question.
There was a series of questions there. That's only a fragment of what I said.
I'm not done yet, Mr. Higgins. Can you answer my question?
Yes.
To the question, did you call him back? Your answer was yes, correct?
I think it was kind of I must have.
Then you were asked, well, the answer was yes. And then there was a colloquy back and forth where you spoke over each other's words, right?
There was dialogue back and forth about this whole thing, yes.
May I approach?
Yes.
May I?
Yes.
You see the pink highlighted question and the pink highlighted answer?
Yes.
What's the question? Please read it for me.
See, this 134 call is going to give way more relevance to this than call. Okay? Because he left and he called somebody, which I'm telling you, if I'm a betting person, I'm taking all my chips and my money's on that he called Brian Albert, right? I mean, who else would he call at 1:34 in the morning? All right. And I think it was like, no, they've gotten no phone calls. Nobody has called in about John O'Keefe. Okay. Because he would have been able to, I don't even think he would have had to ask a homie, hey, did you get any calls in tonight about anything? I mean, that would be a weird question to ask somebody. I don't think that you would even have to do that. I think that you can check something, which would be like a log. No, I mean, but he went there to see if Karen Reed had called. I'm telling you about John. And then he calls to say she hasn't called up here. There's been no calls. Get those fucking people out of the house. When did McCabe leave again with those girls?
Did you call him back?
What's the answer?
Yes.
Thank you. May I approach?
Yes.
You then said a little bit further in that same conversation, I did not have a conversation, correct?
I did not have a conversation with anybody.
And the question following that was, you just listened.
See right there, you're gonna. I did not have a conversation with anybody.
Listen to the phone, what someone was telling you. Answer, it's possible that the phone picked up on the other end and nobody said anything, and then I terminated the call, end quote. That's what you said at the other hearing under oath, correct? Yes or no?
Can I see it?
Sure.
I terminated the call. That's a user has to do that. A buck call can just fucking keep going for hours.
Ma'am?
Yes.
Same page.
Thank you.
The bottom portion in pink. If you could read that answer to yourself, please. You have that in mind, sir?
No, can I have a minute, please?
Okay, this would make really good sense. All right. So we need the exact time because I think we have it based on I thought that the McCabes were driving back and they're back in the area. We need to know what time they would have left the house because, hey, nobody's called in here, but you need to get those fucking people out of the house. No, nobody's spending the night. Okay. So get like they were planning. Remember they were planning on sleeping there, you guys. The Nagel girl and Sarah, they were planning on sleeping there. All right. And so it would have to be something significant as to say like, hey, we can't have these people sleeping here. Okay. So what are you going to tell them as to why they can't sleep there? You know, Brian Albert Jr. is like, okay, girls, let's go to bed. Like, okay, guys, we're going to go to bed. No, you guys can't go downstairs and sleep. Remember they used to ask when they would spend the night and stuff where they would like where were you planning on sleeping when you were going to stay over there? Because that was the plan. The plan was never like, I'm going to take you home. Right? That became like, it was just, but they had to make that the plan because they had to get everybody out of that fucking house. Like, why wouldn't Julie Nagel and Sarah spend the night? How did they get them to get out of the house? Hey, guys, wake up out of your little, whoop, party's over. Like, you know, I think an option here is, this is where kind of maybe Chloe comes in, and where it's like, ooh, I have to think about that, because they should have spent the night, but no, nobody's staying here tonight. Like, my dad's being a complete fucking asshole. He says that everybody has to go. So I'm sorry, guys. Like, you're gonna have to leave. Like,
Yeah.
yes, you'd have to cause a fake fight, like a fake argument.
Thank you. Does that refresh your recollection about how you answered that question?
Yes.
And your answer was, it's possible that the phone picked up on the other end. And
They could have been barking and going crazy. I mean, I don't know.
nobody said anything. And then I terminated the call. That's the only thing.
Meaning it's possible it could have happened.
It's possible it could have happened that you had a 22-second call with Brian Albert,
I
correct?
did not have a 22-second call with Brian Albert. There was no conversation.
You've had some time to think about this 2:22 a.m. call, correct? Since that last testimony.
Some time to think about it?
Yeah.
I haven't really thought about it, no.
So for over a year, you haven't even considered the fact that you were caught with a phone record.
Or they could have said, hey, guys, it's going to get really, really bad. We don't, like, we're just going to take you guys home now because otherwise you guys are going to be stuck here. And don't you guys have stuff to do? So let's just do this now because I think that, like, this snow is going to, like, keep all of us. You could blame it on the snow, maybe.
You're lying about not having a conversation with Brian Albert at 2:22 in the morning.
Objection.
Mr. Higgins, what was so important that you and Brian Albert needed to discuss something at 2:22 in the morning?
There was no discussion. I never talked to Brian Albert.
Right there.
Then why the 22-second phone call, sir?
Objection.
Sustained.
He's going to be able to use that. I never talked to Brian Albert.
I want to talk about what you did after you woke up on January 29th, 2022. That was obviously a memorable day in your mind, correct?
It was a sad day.
The very first person you spoke to after waking up was who?
Well, I believe I said I got the call from Chief Berkowitz.
That's not my question.
Say that again?
Who's the first person you spoke to on the phone that morning when you woke up?
Brian Albert.
Whose idea was it for you to drive to Brian Albert's house that morning?
It was my idea.
Was it important to you to speak with Brian Albert in person rather than over text or phone call?
No, it was important to support the people that were there.
So, of course, you drove over to his house and had an opportunity to speak to him in person without any law enforcement presence, correct?
I was there with everybody, not just Brian Albert.
And Brian Albert was in the house and you were in the house, right?
That's correct.
So you had access to him and others without any law enforcement there. Is that right?
That's correct.
As soon as you got off the phone with Brian Albert that morning, who did you call? At 7:22 a.m. If you were.
I think I might have called Chief Berkowitz back.
So as soon as you got off the phone with Brian Albert, first thing in the morning, the next call you made was to Chief Berkowitz. Is that right?
Yes, because he had called me first. Yes, I called him back.
Did you request from Chief Berkowitz any information that he may have had concerning the investigation surrounding John O'Keefe being found at 34 Fairview that morning?
No.
Were you trying to see how much law enforcement knew right away?
Absolutely. I didn't even know what happened.
Were you trying to gather information about what happened so that you would know what happened?
Objection.
I'll allow it.
No.
What we're trying to do?
No, Your Honor.
Wait, I didn't even know what happened. What do you mean? You just got the phone with Brian Albert. What do you mean you didn't even know what happened? What the fuck? You got to call him on that. You just got off the phone with Brian Albert, and then you call Chief Berkowitz. You said, I didn't even know what happened. So Brian Albert didn't fill you in that fucking John O'Keefe was just taken up off his lawn?
What did Chief Berkowitz tell you about his knowledge of John O'Keefe's body being found just after 6 a.m.?
Objection.
Sustained.
Did you tell Chief Berkowitz that you had been with John O'Keefe and you were at the crime scene
Did
the night
Chief
before?
Berkowitz die?
Sustained. You can ask that differently.
Did you inform Chief Berkowitz that you had been with John O'Keefe the night before?
Objection.
I'll allow it.
I believe I may have told him at some point that I saw John at the waterfall.
Did you tell Chief Berkowitz that you'd been at 34 Fairview?
I believe I did.
Did you tell him that your vehicle was parked just feet away from where John's body was discovered?
No, because I didn't know where he was discovered.
Did you tell Chief Berkowitz that you and Brian Albert had a call at 2:22 in the morning?
Objection.
Sustained.
Did you tell Chief Berkowitz that you had been flirting with John O'Keefe's girlfriend in the weeks prior to his death?
No.
Did you ever tell Chief Berkowitz about the nature of your interest in Miss Reed?
No, I don't believe so.
Did you tell Chief Berkowitz that you had seen Mr. O'Keefe and Miss Reed the night before and that Miss Reed had ignored you?
Objection.
Sustained. You can break.
I still think that the biggest red flag for everybody, and it should be, you have to put this in the jury's minds. You were texting with Karen, right? The night before. You just find out that her fucking live-in basically boyfriend, right, is dead. And you don't text Karen Reed or call her at all to say, what the heck happened? Or I am so sorry, like, oh my God, how are you doing? What's going on? Are you okay? That is not normal.
Break that down, Mr. Jackson.
Thank you, Your Honor. If I may have just a moment. You indicated just a second ago that when I asked, did you tell Chief Berkowitz that your Jeep was parked just feet away from where John O'Keefe's body was found, you said, I have no idea where John O'Keefe's body was found, correct?
That's correct.
You just spoken with Brian Albert, right?
He said in front of the house.
All he said was, John O'Keefe was found in front of the house. He didn't say right outside on my front lawn.
I believe he said he was found out in front of his house, unresponsive.
Okay. If he was out in front of his house, then you would know, because your Jeep was also parked out in front of his house, your Jeep would just be feet away from him, correct?
Objection.
Did you tell Chief Berkowitz that you had texted John O'Keefe to have him come over to 34 Fairview just hours before he was discovered dead in the yard?
No.
Did you think any of that was important when talking to the Chief of Police of the Canton Police Department?
I'll let him have it.
No, I didn't. There was no reason to tell him.
You've been an investigator for some 15 years, and you were a firefighter for years before that, correct?
Yes.
You're very familiar with some of the tools that are used in conducting modern investigations, correct?
Yes.
You'd agree that searching electronic devices and phones is an incredibly important investigative tool that modern investigators use, correct?
Objection.
In that form, I'll sustain it.
Are you aware that searching electronic devices is an important part of investigations?
Objection.
Are you aware of that, sir? Do you agree with that?
I've utilized phone data during the course of my investigations at times, yes.
Okay. So another way to put that is, obviously, phone data and electronic data is an important part of investigation. Right?
Objection.
Sustain.
What time do you believe you got to Brian Albert's house that morning after you received the phone calls and woke up? What time did you make your way back over to Brian Albert's house?
Maybe around 7:15 in that area.
Was there any law enforcement presence there when you arrived?
I can't recall specifically. There could have been one police car. I'm not positive.
Did any officer ever ask you to take a look at your vehicle?
At what time?
That time. Actually, at any time.
No, to my knowledge, nobody from law enforcement associated with the investigation had ever asked to take a look at my vehicle.
So they certainly didn't ask that day, correct? On the 20.
What I'm saying is, to my knowledge, nobody has ever asked me that.
Right. So that's my point. I'm just trying.
You guys, where was his vehicle then? At 7? If you arrived at 7 or 7:15, they're taking pictures. How long was he there before he left and went to Canton? Okay, because where are these cars? Where is his vehicle? Where's his vehicle when they would have been taking pictures? How long was he there?
Trying to break it.
You want to tell me every instance when somebody could have asked me?
Correct.
Okay.
On the 29th, where you asked whether or not your vehicle could be searched.
Searched or inspected? What do you mean?
Either one.
Well, I would consider a search the inside of the vehicle more so than the outside. I would consider the outside more of an inspection. I would have been happy to show them it.
I'm sure you would have. I'm asking, did they ask?
No.
They didn't have to search it, they didn't have to inspect it?
No.
We met with troopers. Who was it that you met with on the 3rd of February?
Trooper Proctor and Trooper Buchanan. Did
Did either Trooper Proctor or Trooper Buchanan ask to inspect your vehicle, otherwise search it?
Not to my recollection.
And to this day, nobody from Massachusetts State Police has ever indicated that they would inspect your vehicle.
Wait, they talked to him on the day, right? You check him out.
When you entered the house that morning, Brian Albert was there, Nicole Albert, Jim McCabe, Matt McCabe, Brian Albert Jr., and Julie Albert were all there. I'm sorry, had Julie Albert gotten there yet?
She came after me.
Okay, so at some point, all the people that I just
Even more so, she came after me. Because remember, Canton Police Department takes photos. They take a round of photos, and that's how we were able to find, oh my God, they took a photo on the angle to show that, shit, his shoe was up against the curb, and then when the CERT comes back and they do it, oh, look at, same area, look at fucking shoe right there, cocksuckers. So he gets there before Julie. Julie's able to park in the driveway.
Off, they were all inside the house.
Brian Albert Jr., Nicole, Brian, Matt, and Jen.
Matt and Jen. You guys, Matt's vehicle. Where is Higgins' vehicle?
You all discussed the incident together, correct?
I wouldn't describe it that way, no.
Did each of you discuss your own perspectives about what had happened the night before in the early morning hours?
Objection.
I'll allow it.
People were in shock at the table, trying to figure out what happened. The math didn't make sense. John and the defendant never showed up. People were in shock.
Trying to figure out what to say, right?
No.
And you were all talking within earshot of each other, right?
This piece of shit says John and the defendant. He didn't even say Karen. He also said the defendant. You know how much practice that would be to remind yourself to say it that way? To train yourself to say that way? To not say Karen and to say the defendant?
We were all there in the kitchen talking together.
At this meeting, and these were friends and family, correct?
Excuse me?
These were friends and family amongst themselves, and you being a friend, these are friends and family inside that house discussing this incident, correct?
Yes.
So at this meeting, you actually instructed Jennifer McCabe to call Canton PD and ask someone to come back.
Objection.
Sustained as to that form, you can ask it to happen.
At some point, did an officer come back to re-interview Jen McCabe?
Yes.
So if it's just, okay, so before Julie gets there, so Brian Jr. But Brian Jr. said he was sleeping, but fuck no, he's not. I mean, these people are just ridiculous. Okay, so Nicole, and then Matt, and then Jen. That's who all knows. And Caitlin. These people would know everything for sure because you're not going to talk about it with people that wouldn't know.
Jen McCabe had told you that she had information about something that Ms. Reed had said, correct?
Objection.
I'll allow it. Did she tell you that morning?
She didn't specifically tell me anything. She made a statement at the table to the group of people and she clearly seemed like she was in shock. She was upset. And she made a statement, something to the effect that Karen had opined that she had hit John.
What she actually said was, I hope I didn't hit him, correct?
Objection. It's not what I heard. No.
Who did you ever tell this to?
I've reported that.
That she said, I hit him?
Yes, I've reported it.
What you reported was Karen said, I hope I didn't hit him. And you said, oh, you need to tell Canton PD that. Isn't that right?
No, I don't think that's what I said. No.
You're sure about that as you are about that 222 call, right?
Objection.
Mr. Higgins, what time did you leave Brian Albert's house?
It would have been, I believe, when Sergeant Lank arrived, and I think Lieutenant Gallagher might have been with him.
You weren't scheduled to work that Saturday, correct?
No.
Matter of fact, you weren't on duty at all.
No, I wasn't.
But you didn't go home and get some sleep or run errands. You went directly to Canton PD from 34 Fairview yet again, didn't you?
Who could sleep after somebody just was discovered like that?
Did you go home? Or did you?
I don't believe I did, no. I believe there might have been a stop at Canton PD before I went home.
As a matter of fact, you didn't just stop at Canton PD. You spent the entire day at Canton PD on the 29th, didn't you?
I don't know that I spent the entire day there, no.
Well, you've got a key card, right?
I do have a key card.
And that key card logs swipes.
That's correct.
So it logs where you go, access to, and access inside the
Yes.
Canton PD, correct?
Yes.
When you got to Canton PD, and you're telling this jury, you don't know how long you spent there.
I don't know how long I spent there. I don't know if I left and I came back.
Did
I don't
you have
recall.
water? So if the records indicate that you were there from 9 a.m.-ish, water? After 5.
I don't know how the records would indicate that.
I'll show you in a second.
Okay.
Wait a second. Hold on a second. While you were at Canton PD, did you speak again to Brian Albert?
I don't remember.
Boil water. While you were at Canton PD, did you speak again to Chief Berkowitz?
Most likely.
While you were at Canton PD, did you speak with Brian Albert's brother, Kevin Albert?
I don't believe so.
What you reported was Karen said, I hope I didn't hit him. And you said, oh, you need to tell Canton PD that. Isn't that right?
No, I don't think that's what I said. No.
You're sure about that as you are about that 222 call, right?
Objection.
So Higgins, what time did you leave Brian Albert's house?
It would have been, I believe, when Sergeant Blank arrived, and I think Lieutenant Gallagher might have been with him.
Okay. You weren't scheduled to work that Saturday?
Boom.
No.
Holy shit. Holy shit. Sherry, pull up Allie McCabe's testimony about where she was driving around that night. She said that she got home, and it was after 2, right? You guys, there's a vehicle missing here. What I mean by this is that I think there's a chance here that Brian Higgins never went home and slept, okay? Right? That Brian Higgins never went home and slept. There's his car's missing. His car's missing in the morning then when he comes back over there. We have all of these cars in the driveway or lack thereof rather, and his car should be in the driveway when Gallagher takes the picture of the house from being by where the mailbox. We're missing Higgins's vehicle as well. So we're missing the Ford Edge, we're missing Higgins' vehicle, which in my mind makes sense.
In fact, you weren't on duty at all.
No, I wasn't.
But you didn't go home and get some sleep or run errands. You went directly to Canton PD from 34 Fairview yet again, didn't you?
Who could sleep after somebody just was discovered like that?
Did you go home? Or did you?
I don't believe I did, no. I believe there might have been a stop at Canton PD before I went home.
As a matter of fact, you didn't just stop at Canton PD. You spent the entire day at Canton PD on the 29th, didn't you?
I don't know that I spent the entire day there, no.
Well, you've got a key card, right?
I do have a key card.
And that key card logs swipes.
That's correct.
So it logs where you go, access to, and access inside the
Yes.
Canton PD, correct?
Yes.
When you got to Canton PD, and you're telling this jury, you don't know how long you spent there.
I don't know how long I spent there. I don't know if I left and I came back. I don't recall.
So if the records indicate that you were there from 9 a.m.-ish, after 5.
I don't know how the records would indicate that.
I'll show you in a second.
Okay.
While you were at Canton PD, did you speak again to Brian Albert?
I don't remember.
While you were at Canton PD, did you speak again to Chief Berkowitz?
Most likely.
While you were at Canton PD, did you speak with Brian Albert's brother, Kevin Albert?
I don't believe so.
Your Honor, may I approach this one? Yes. Yeah, this particular area, but I just want to see if you have this. May I approach?
Yes.
Thank you.
It's a 167-page document. Just take a glance. Obviously, don't read the whole thing. Just glance through it and tell me if you recognize what that is.
So it says Canton Police, all events logged by day.
So don't read it out loud, please.
Oh, I'm sorry,
Just,
Your
do you
Honor.
recognize
Yes, I do.
it?
Okay.
May I approach?
Yes.
This appears to be a log of key swipes in and around Canton PD, correct?
Yes.
And it's in reverse chronological order, in other words.
I didn't note that, but okay.
Okay. You acknowledge that that is a record of the key swipes that everybody uses moving in and around Canton PD, going through doors, every place that needs a key swipe is logged.
I would assume that's what that is, yes.
It shows that you entered Canton PD for the first time on the 29th at 1:27 a.m. Does that sound about right when you got there? You say to move your cars.
It's possible.
All right. It shows that you were granted access to floor corridor 227. Does that mean anything to you?
No.
What about floor corridor 226 on the second floor?
Second.
Okay, so check this out. When he first arrived, he's around 7 or 7:15. He said that he thought maybe like one police vehicle was there. Okay, so one police vehicle is there, and then when he's about to leave, it's before. So let's see through the reports what police officer was the last one of Canton to leave that morning, based on the reports, possibly based on just their cams as well, because we'll know which person that would have been. And then he leaves as Lank and Gallagher arrive. Okay.
Floor would make sense because I went in the building and then to the second floor.
Let me have just a moment, Your Honor.
Sure.
Second floor, that means he would have went up a flight of stairs. I need to pull back John O'Keefe's data with his phone. You know, remember she said she couldn't remember who she gave, Carrie Roberts couldn't remember who she gave the cell phone to. I gave it to an officer. I can't remember. When Allie pulled into the driveway on the left side, yeah, which I said she would have gotten blocked in then. Everybody's just on top of each other, like I've been saying. All these cars are just on top of each other. Everyone's on everybody's laps.
By the way, did Brian ever mention what time the officers cleared the scene?
No.
Without telling me the substance of the conversation. Did he tell you when he talked to you at 7:20 or?
Not that I recall, no.
But you remember by the time you got there, the scene had basically been cleared. There wasn't a bunch of emergency vehicles, crime scene tape, nothing like that.
I didn't see fire trucks. I might have saw a cruiser. I can't be sure. I don't recall.
You're not sure about that either.
Sorry,
You're not sure about even seeing a cruiser, correct?
Not 100%, no.
Certainly we're not contacted by a law enforcement officer who took your name and ID or anything like that.
No, no, no.
Parked and walked in the house.
Yes.
God, where'd you park, AJ? Where'd you park? Parked and went to the house.
You want me to approach one more time?
Yes.
Same thing. I'd like to have that document marked as next in order base pages. It represents base pages 2850 to 3016.
All right, so marked for identification. Is there an agreement this is coming in, Mr. Lally?
There's not, no.
All right, so that's marked for identification, not next in order.
Where did they keep their Faraday bags?
Thank you, sir.
Thank you.
Mr. Higgins, if you will, I'm sorry, are we ready? Thank you. May I proceed?
Yes.
Mr. Higgins, if you'll look at base page 3015, which actually is in order, that's not reverse chronological, it's the second to the last page.
I have it.
Just one quick second. And you take a look at the 8th entry from the bottom.
I see it.
Does that indicate that this all occurred on 129/22? This entry at least?
Well, I mean, I only, on that 8th entry, I see that that's associated with my name. I don't know what the other ones are associated with.
Right. It would be other individuals in Canton PD. I mean, this is the entire log for 129, right?
Okay, but what all I'm saying is that just my name is next to that. I don't see any other names, so.
Right.
Okay.
So on 129/2022, I'm just trying to orient you. At 127 and 52 seconds.
I see
Access
it.
granted, Brian Higgins, rear entry to secure corridor, rear entry to secure corridor, correct?
Yes.
All right, so that appears to be what the log entry or the key swipe entry looks like when it's logged, correct?
Yes.
Oh my God.
If you look at page 2967.
Remember when they brought Karen Reed's vehicle and I was like, you guys, what vehicle was in there before? Because whatever vehicle was in there, remember there was like the snow before they pulled the vehicle into the Sallyport, right? It looked like there was a vehicle that had just been taken out because there was like snow around it.
I'm sorry, I said it backwards, 2976.
Okay.
Take a look at
You said 2976?
That's Bates page 2976. That's the bottom right hand.
I see it, yes.
Look at the time entry for 9:23 and 39 seconds.
$923 and what?
39.
And that's on 2976?
Should be.
Give me the time again, please.
How do we do it this way? May I approach?
Yes.
This is an exact copy?
Yeah, this time's all over the place. My apologies.
That's
Okay.
fine.
All right. Thank you.
At 9:23:39, I'm sorry, if you got that in mind?
I do. I see it. It's highlighted.
At 9:23:39, that shows that you were granted access to the Sallyport, to front entry to Sallyport, correct?
Yes.
There's only one Sallyport at Canton PD, correct?
Yes, and there's a door on each side of the Sallyport. Yes.
Two bay doors, right?
2 bay doors on each side, yes.
And then there's a
Pass-through.
personal pass-through door as well.
Yes.
May I approach, Your Honor?
Yes.
I'm going to try to speed this up just a bit because it's small print, reverse chronological order. On page 2976, there's also an entry, same page, should be right above that, 9:23:50, showing that you were granted access from booking to Sallyport as well, correct?
Okay, 2976. What was the time?
Page.
Yes.
It's about maybe 6 entries above, 6 entries up. You'll look for time 9:23 and 50 seconds.
I see. Yes.
All right, and that shows that you were granted access to the Sallyport and then from Sallyport to booking, correct?
It says booking to Sallyport, Sallyport to booking.
Okay, so that's a key swipe. You can enter into Sallyport from booking or from booking into Sallyport.
Yes.
Could you repeat the question? Of course, of course. May I inquire, Your Honor?
Yes.
That indicate, I have no idea what the last question was. I'll see if I can make a new one up. At 9:23 and 50 seconds in the morning, you were granted access booking to Sallyport and Sallyport to booking, meaning swipe the key card in the door going from booking to Sallyport.
Yes.
Okay. I don't want to belabor this because we could get bogged down into it all day long. Would you have any quarrel if those logs indicated that you were moving in and around Canton PD at 9:28, 9:53, 9:53, 9:54, 9:54, 11:40, et cetera? We can look at every one of them if you want to.
Well,
that doesn't refresh your recollection.
It would not be uncommon for me to move around Canton PD at various times or dates, middle of the night, during the day. But just because I swiped in somewhere, and then you have a swipe at the end of the day, doesn't mean I was there the whole day. I could have left, I could have come back, and I truly don't have a recollection, but I'm pretty sure I wasn't there all day.
Fair enough. If we moved from 11:40 to 11:44, 11:45, 11:47, 11:51, 11:52, and then jump to 2:05, would that be an explanation where you might have gone out for lunch, 11:52?
Could have.
Okay, come back. If
Yes.
there's a 2:05 and 56 entry, then obviously you're there, right?
If the card was swiped, I was there.
I mean, you're not giving that card to anybody else.
No, I'm not.
No way, right? Let's just look at 2905, because I want you to be comfortable. Page 2905, and let's look at that 2:05 and 56 entry.
When did they make the decision?
I'm at 2905. Where would you like me to look?
Car.
About right there. Basically, middle of the page. May I approach? Yes. This might be a little easier. Highlight it for you.
I see it.
Okay. So that would indicate that you were back at Canton PD at least 2:05:56, and you were granted access Sally Port to front door, correct?
That's what it says, yes.
Okay. At 3:10 p.m., you called Brian Albert's brother, Kevin Albert, correct?
I don't know. It's possible.
Okay.
I mean, I don't remember every phone call I made that day.
Understood. Do you remember talking to Kevin Albert?
I don't.
So you don't remember what you discussed with him?
No.
Do you remember that it was a 12-minute phone call?
No, I don't remember having any phone call, but I'm sure it's possible that we spoke.
Do you remember Kevin Albert providing you any information about the ongoing investigation into John O'Keefe's death?
No.
Did you ask him about additional information concerning John O'Keefe's death?
No.
Were you providing details back to Brian Albert that you were receiving while at Canton PD?
Absolutely not, no.
Do you recall that 2 minutes after you cleared the call with Kevin Albert, you then called Brian Albert?
It's possible.
So I think the question was, do you remember? Do you remember that?
Your Honor, there was a lot of phone calls made that day. It was an upsetting day. I spoke to multiple people at multiple times. I don't have a recollection. I'm sorry.
Okay. Yes.
Thank you.
Just to close this loop, that appears to be your phone record, correct?
Yes.
It appears that you made a call at 3:10 for 12 minutes with Kevin Albert, correct?
Yes.
3:10 plus 12 is 3:22, correct?
Yes.
You cleared the call about 3:22, is that right?
Yes.
And then it shows a 3:24 phone call to Brian, Brian Albert then calls you at 3:24, correct?
Yes.
And you two speak for 6 minutes, is that right?
6 minutes, 5 seconds, yes.
May I approach?
Yes.
Does that refresh your recollection that you made those calls?
I'm based on the record, yes.
Was that just a coincidence that you were talking to Brian Albert and Kevin Albert within minutes of one another?
Yeah, I mean, there was a lot going on that day. People were upset, and I don't remember the phone calls. I don't deny making the phone calls. I just don't remember them.
Do you remember providing information that you were learning from Kevin Albert to Brian Albert?
Absolutely not.
And then may I, Your Honor?
Yes.
Same record. If you look just below those phone calls to Kevin Albert and Brian Albert, there's 2 additional phone calls that you had with Chief Berkowitz and then Brian Albert again, correct?
Yes.
Mr. Higgins, it looks an awful lot like you're gleaning information from Canton PD. Were you doing that?
Objection.
So I sustain the objection in that form. You can ask one part of that question.
Sure. Were you getting any information from Canton PD?
No, I wasn't.
Did you provide any information to Brian Albert
No, I did not.
based on any conversations or conduct at Canton PD?
No.
May I approach?
Yes.
But you were, in fact, on the phone with all of those interested parties throughout the day. You'll agree.
I was.
Answer that.
Okay,
There's
yes,
no
Your
objection.
Honor. Yes, they're friends, and I was on the phone with them, yes.
And sir, you were not on duty that day, correct?
No,
You are not a Canton police officer, correct?
that's correct.
You were not assigned to this investigation in any formal capacity, were you?
I was not.
As a matter of fact, you're a witness in a homicide investigation. That's your only role in this, correct?
That's correct, but they're still my friends, yes.
And yet you're still having conversations with Kevin Albert at Canton PD while you're at Canton PD, correct?
Not about this.
And you're having conversations with Chief Berkowitz of Canton PD while you're at Canton PD, correct?
I had conversations with them, but not about this, no.
And you're consistently through the day calling Brian Albert, aren't you?
I had conversations with Brian Albert. John was found on his lawn. Yes, of course I had phone conversations.
So the way that you want to bring this up is that, are there any reports? Are there any reports from that Kevin Albert would have wrote up in connection with this case. Like, you talked to Chief Berkowitz. Did he write up a report because he talked to you and what it was about? You know what I mean? Like, showing that it wasn't in the capacity to obtain information like you would from a witness, that you're making up a report. I talked to so-and-so at this time.
He's with him.
I want to take you back for a second to a couple of other entries, including one at 357, one at 358, and one at 407. I'm going to draw your attention to 2885 and 2886. Once you have the pages, I'll give you the times once again.
2885?
2885 and 2886. We'll start with 2886 and then work backward.
Okay.
First entry is at 357 and 54 seconds.
357 and 54 seconds, I see it.
Brian Higgins booking to Sallyport, correct?
It says Brian Higgins, communication to pedestrian Sallyport, communication to pedestrian Sallyport.
Look at the one just above it. That's 358.24. Look at 357.54. Or the one it probably is going to be just below it because it's reversed.
You said 357.54, correct?
Correct.
That's what I just read.
Got it. Look at 6 entries below at 357.36.
357.36. I see it. Access granted, Brian Higgins, booking to Sallyport, Sallyport to booking.
Wait, communication.
There's one more
that
on page 2885. Look for 407.47.
.407.47?
Correct.
I have it. Access granted, Brian Higgins, booking to Sallyport, booking to Sallyport.
And there's no record in that document of you exiting, correct? That's just booking to Sallyport.
Yes.
it means you had to have left when the door was open, motherfucker.
Yeah, there's no record. I don't know if it records.
Do you understand what that means? That means, but if the Sallyport was to be opened, right? The garage opens. Then you don't ever have to swipe your card to leave because you're walking out the door of the garage opening.
That's,
That's fine.
There's no record of it, correct?
Not that I can see here now. I'm sorry.
And you're aware.
So what you want to ask right there so that the jury would get it is that if the Sallyport garage door was opened, Detective Higgins or Brian Higgins, you can just walk out the garage door, right? And that's why there would be no swipe that you would need to walk, to be able to leave that area. It would just be the garage door opening. You just walk right out, right? You wouldn't swipe anything.
Aware that that's about 90 minutes before Karen Reed's SUV was delivered to that Sallyport, correct?
No, I'm not aware of that.
You're aware that her car ended up in that Sallyport where you were at 5:36.
I'm aware her car ended up there, yes.
Are you aware that there was other evidence that was also being held in the Sallyport?
Objection. Sustained.
Did you see any other evidence in the Sallyport related to this case?
No.
Did you see a bag, grocery bag with 6 solo cups there?
Objection.
Did you see anything that seemed out of the ordinary there?
All I would do is use that as a cut through. I did not see anything.
Are you aware that at 5, well, let me ask you this. You and Chief Berkowitz were moving in and through, at least in some parts of the day, in and through Canton PD together, correct?
At some points we might have been together. We weren't together all day.
Matter of fact, he was also in the Sallyport around the same time you were, correct?
I don't recall that, no.
But the records would reflect that, correct? The records that are in front of you?
Objection.
Sustained. Have him read the fucking.
You were in the Sallyport the last time you're logged into the Sallyport. It's 4:07. Do you remember seeing Chief Berkowitz at the Sallyport at 4:14?
No, and if that says that I'm logged, that could be me cutting
So
through.
Higgins, all I'm asking you, I'm not asking what you did. I'm asking where you were.
I don't know where I was at that specific time.
Well, you walked into the Sallyport. You know that.
If I walked in, I
correct?
Cutting through, yes.
Right. Was Chief Berkowitz in the Sallyport at 4:14?
Not that I recall, no.
Was he there at 4:30?
I don't remember ever seeing him in the Sallyport, no.
Was he there at 4:33?
I don't remember ever seeing Chief Berkowitz in the Sallyport.
At 4:50?
Objection. Sustained. Let's move through this, please.
Finally, was he there at 5:36 and 37 seconds at the same time Karen Reed's vehicle was delivered?
I don't remember.
Wait, right there.
Do you remember Chief Berkowitz, or were you with Chief Berkowitz?
Wait. He said, I don't remember. He didn't say, I don't know because I wasn't there. He says, I don't remember. So he's saying, Higgins is saying, yeah. So that means Higgins was there at 5:36 and 37.
And he made a call to the front desk?
No, I don't remember anything like that. No.
Do you remember Chief Berkowitz calling the front desk at 5:42 and saying, shut the barracks?
Objection. Sustained.
Do you remember any kind of call shutting the barracks, meaning shutting the Sally Port?
Objection.
Do you remember that?
I don't remember anything like that, Your Honor.
Okay, next question.
You didn't leave Canton PD until close to 6 p.m., isn't that right?
I don't know what time I left.
Could it have been 5:50, 6 o'clock?
I don't recall what time I left.
You're aware that there's video surveillance feeds in the Sally Port garage, correct?
That's correct, yes. Around the building.
Were you in the Sally Port at 5:36 when the car was delivered?
I don't have any recollection of that, no.
It's one thing to say I don't remember. It's another thing to say, no, I was not there.
I don't remember being there, no.
Is it possible that you could have been there when that car was delivered?
I don't believe I was, no.
You don't believe you were?
I don't believe I was, no.
You're aware that the video surveillance feed from the Sally Port garage at or around 5:36, the precise time when the car was delivered, is missing, right?
Objection.
Sustained.
Did you receive a flurry of phone calls from Brian Albert and Chief Berkowitz indicating that some taillight pieces or a taillight piece had been recovered at 34 Fairview later that evening?
Objection.
Did you receive a call at all, without telling me what the conversation consisted of, around 6:12 p.m. from Brian Albert?
I don't know what day you're referring to.
The 29th.
No, I don't remember any phone calls like that.
Do you remember 3 minutes later getting another call from Chief Berkowitz at 6:16 p.m. that lasted about 5 minutes and 15 seconds?
No.
Wait a second. Are the 42 minutes missing from leading up to the 5:36? Because is that still unaccounted for? Or in this whole big thing that hasn't come out yet? Like, because that's going to be putting it at, I don't know, roughly 450. Holy shit. 450 when Chief Berkowitz was in there. 450. It could be like 4. Like 4:53. Why did they never call him to the stand? And now he's dead. So between 4:53 to 5:36 p.m., that's the missing time frame. Because I always thought that the way that it looks to me is it's like Karen Reed's car went in there more than once. It looks like it came in. And then it was like taken out to then like act like it just had come in at 5:40, if that's hence the snow little marking, because then it fits perfectly with when like that vehicle goes back in there.
Can I approach?
Yes.
If you look at the entries for 6:12, 6:16, see if that refreshes your recollection.
Are you referring to the?
6:12 and 6:16.
Okay, I see those, yes.
There was a call at 6:12 that Brian Albert made to you for a duration of 1 minute and 7 seconds, correct?
Yes.
And right after that, there was a call from Chief Berkowitz to you at 6:16. It lasted 5 minutes and 15 seconds, correct?
Yes.
That approach?
Yes.
They telling you that taillight pieces had been found at the location.
Objection.
Sustained.
Your Honor, may we approach briefly?
Okay.
How can that be sustained? Why can't you? It's hearsay. I mean,
Providing your friend Brian Albert information about the progress of the investigation or what you perceived it to be.
No, I didn't have any information on the investigation.
May I have just a moment, Your Honor?
how could anybody believe that? What were you doing there? Okay, you weren't working on this investigation. What were you doing then? Does that question ever fucking come in and get asked? Higgins, okay, fine. You weren't talking about the investigation whatsoever, right? Awesome. Then what were you doing? Why were you at the Canton Police Department from swiping in at 9:23 in the morning, walking all over between 9:23 and 9:54? Then you get some more action at 11:40, 11:44, 11:45, 47, 51, 52. Then there's a big gap until 2:05, where you enter the Sally Port at 2:05 p.m. Higgins Sally Port front door. You use it as a cut through, man. Well, then we have a 3:10 call. Kevin Alberts calls you, or you call Kevin Albert 12 minutes. Then you get a call from Brian Albert right after at 3:40, 3:24. Then we have 3:57 booking to Sally Port, 3:57 booking to Sally Point Communication to the pedestrian port, 3:58, 4:07 booking to Sally Port. Then Chief Berkowitz, did you see him there at 4:14, 4:30, 4:33, 4:50? How about 5:36? How about 5:36 and 37 seconds? Did you see Chief Berkowitz? No, I don't remember seeing him, or I don't remember. You're clearly there because it's your badge at 5:36 and 37 seconds. I don't remember. And at 5:42, it was then to shut the door. $5:36 p.m. car is delivered. Were you there? I don't remember being there. I don't remember seeing it. 42 minutes was missing from 4:53 to 5:36 p.m. And I personally believe that the 42 minutes that are missing, which is interesting when you actually line it all up, remember how I said, I was like, how did it take so long for that car to get there? Like, that doesn't even make any sense. I believe that the car was in there and then they backed it out. But then were they able to fuck with the time of when the actual, because they fuck with everything, the actual tow truck? Because remember, they had to destroy all this shit because then someone was actually going, hey, we're going to take a look and see if this has been manually fucked with. But it looks like her car was put in there and then it had been sitting there. And then it looks like it was then taken out. And why I say that is because there was a vehicle that was in there that had snow on it, clearly because there's snow mounds. What are those? How could there be snow mounds before the actual car ever gets in there? There shouldn't be anything there. And if you took something out, hey, well, you got to move that out because we're going to be bringing this vehicle in. Okay. And then I thought about it and I was like, could have been Higgins' vehicle that was ever put in there to like hide it. And they never thought in a million thousand years that we're bringing it back to Canton. Fuck, I got to move my vehicle out of there.
You were not interviewed about this case in any formal capacity until 5 days later, correct?
That sounds about right.
February 1st, Trooper Proctor?
I'm not exactly sure the date, but it was several days after, yes.
I'm sorry, I said February 1st. I said February 3rd.
I don't know the date, but we were into February.
Where did that interview take place?
Sharon, Mass.
I'm sorry?
Sharon, Mass.
At what location?
Sorry?
What location?
Objection.
Obviously, counsel, very quickly, it's sidebar.
Why? Why is there an objection to where the fuck he was interviewed? I don't even understand that. How is that even possible? And O'Keefe's just sitting here like this is all normal. Nothing to see here.
By the time you interviewed with Trooper Proctor, you had already had numerous conversations with Brian Albert. Is that safe to say?
Well, the interview was with both Trooper Proctor, Sergeant Buchanan, and of course I've talked to Brian Albert because of what took place.
Higgins, that was a yes or no question.
Yeah, of course I've talked to him, yes.
Okay, the answer is yes, right? Can we agree?
The answer is yes.
Thank you. By the time you spoke with Trooper Proctor and Trooper Buchanan, you'd already had numerous conversations with Chief Berkowitz, correct?
Yes.
You'd already had numerous conversations with Kevin Albert.
Yes.
You'd already had this meeting with the Alberts and the McCabe's over at 34 Fairview. Is that right?
I went to the house.
And discussed this case, as you earlier described in your testimony.
I discussed what we were trying to figure out what happened.
You discussed this case, Mr. Higgins.
Well, at that point, it wasn't a case.
Okay, I'm not parsing words about what a case is versus a matter versus an issue. You understood my question, didn't you?
Yes.
Is there a reason you don't want to answer that question?
I don't have a problem.
Objection, Your Honor.
Is there a reason? Why don't you
Well, I feel you're trying to make it sound like something it wasn't. It was.
I'm not trying to make it sound like anything, sir. I'm asking a question. Had you discussed this case or the issues surrounding this case with those folks?
I did discuss things when I went back to the house, yes.
And that was before you met with Trooper Proctor and Trooper Buchanan,
Yes, that's correct.
You had already spent an enormous amount of time at Canton PD. We've just gone through those records. Is that right?
I have been at Canton PD, yes.
And you had been able to talk to, you had access at least to all the officers, correct?
What do you mean by?
Everybody that was coming and going at Canton PD.
Access for what purpose?
Just to walk by, to hear what they were saying, see what they were doing.
Yeah, it's not what I was doing, no.
I'm not accusing you of doing anything. I'm saying you had access to the individuals within the Canton PD, correct?
To interact if needed, yes.
And very obviously, you had access to the Sally Port.
And access, yes, and that's a cut through I used all the time.
And anything that was in it, correct?
I wouldn't need anything in it.
It was only after all that Michael Proctor thought that you were worthy of a conversation.
Objection.
I'll rephrase it. It was only after all of that that you were interviewed by Michael Proctor and Trooper Buchanan, correct?
I wasn't interviewed to the following days, that's correct.
At some point on February 4th, Chief Berkowitz called you to personally inform you that he had personally found taillight at 34 Fairview. Is that right?
He did tell me that, yes.
And to be clear, that's the same Ken Berkowitz that you were with in the Sally Port.
I don't recall being in the Sally Port with him, no.
What did you do with that information when you learned from Chief Berkowitz that he personally saw a taillight piece as he drove by?
I didn't do anything with the information.
Did you call Brian Albert?
No, Brian Albert called me.
You were asked a specific question in the other proceeding in June of 2023, correct?
I don't know if it was the specific question. I was asked a series of questions on how the phone calls came in. That's what I was asked.
And your answer was, it's 100% probable that I told him about that, meaning I told Brian Albert about my conversation with Ken Berkowitz, correct?
It's possible.
Was that your statement or not?
It was my statement then, but I've thought about it, yes.
And you've changed your statement somehow?
I don't know if I changed my statement, but I think the way the phone calls came in is Brian Albert told me, you're not going to believe what was found on the front lawn. And then I believe Ken Berkowitz told me he found the taillight. And I'm referring to the taillight from the both of them. I didn't provide any information to anybody.
Well,
information was provided to me.
What you actually said was, it's 100% probable that I told him about that. Yes, 100%. I'm not hiding that fact. But you're asking me if I recollect specifically. I know I called him after
Objection, Your Honor.
All right, so too many facts. Go slowly.
Sure. You said, yes, 100%, correct?
In that testimony, I did, yes.
And then in that testimony, you went on to say, I'm not hiding that fact. But you're asking me if I recollect specifically, correct?
Well, I don't have it in front of me. That's what you're telling me.
You went on to say, I know I called him after that phone call, correct?
I don't know.
And you went on to say, if that's when Chief Berkowitz told me, listen, I didn't do anything wrong in this, end quote. That was your statement.
Objection.
Prior hearing, correct?
So I'm going to strike the end.
You're on the man?
Yes.
You said you don't recall that entire testimony, right?
Not that portion. I know I was asked about how the phone calls came in and what was said.
Do you think it would refresh your recollection to see a transcript of your answer?
Is this it right here?
That's it.
I'm going to read it.
So ridiculous.
Ma'am?
Yes.
Does that refresh your recollection to what your testimony was under oath in June of 2023?
I do.
And you said, if that's what Chief Berkowitz told me, I didn't do anything wrong in this, correct?
That was the statement I made, yes.
Why did you say, listen, I didn't do anything wrong in this?
Objection.
Why'd you say that?
Because I felt they were being accusatory, and I was trying to explain what was going on. And what I had said over that was, I believe what I said, something to the effect, I can't be 100% positive. And then when I went on to say, it's probable. But I felt like they were being accusatory, and I was trying to explain how the phone calls came in. I've had time to reflect about it after that, since that testimony. And that information about the taillight that was found was provided by each person. I didn't provide any information to anybody.
Next question. Thank you. You said, look, I didn't do anything wrong in this because it looks like you and Ken Berkowitz were colluding to provide information to Brian Albert, correct?
Objection.
Is that correct?
Absolutely not correct. That's wrong.
You knew that was going to look like collusion, which is why you said, look, I didn't do anything wrong in this.
Objection.
Objection sustained.
Mr. Higgins, if you wanted to get rid of, and you've dealt with cell phones and electronic devices in your career many, many times, correct?
Over my career, yes.
You've probably even written search warrants for them, things of that nature, right?
Yes.
If you wanted to destroy evidence on your cell phone, what kind of steps might you take to do that?
Objection.
If you wanted to just get rid of information on your cell phone that would be unrecoverable, what steps might you take?
Objection.
Do you know how to get rid of information on your cell phone?
Objection.
That's allowed. You can answer that.
Do I know how to get rid of information? I mean, I think there's different ways. You could wipe your phone.
Anything else?
You could wipe your phone. Factory reset.
Factory reset might be one, wiping your phone, taking the SIM card out.
I don't know that the SIM card's going to take information that's on the phone out.
So that might be one avenue. You can break the SIM card in half or snap it.
It could, yes.
You know, the SIM card stores an enormous amount of data that the phone's just break, right?
No, I don't know that.
Okay. You could also, if you take the SIM card out, just get rid of the phone somehow, right? Just destroy it.
Yes.
All right, we're going to stop right there. I wanted to review that for my personal knowledge. You guys all got to basically see me. I just thought I'd do my work live. There's a lot of issues here. I said it back in the day. I always thought that John O'Keefe was thrown in a vehicle. And right now it's looking very, very much like that's what might have happened until then they put him on the lawn. People think that they used a Ford Edge to maybe like, I don't know, block something or whatever. No. So, all right, guys, we'll see you on the flip side. These people are absolutely out of their minds. But you can't lose the jury. Like, you know how long this is to like listen to it? And this is at 1.5 speed. A jury to sit through this and listen to this. Like, just think about it from like the jury, and then you're trying to go back into a room, and if you keep it simpler, you're not allowed to get it. There won't be a South juror that can like spin shit. Did you not hear this when he said this and he said that, and you're comparing notes? Fuck all that, man. All right, you guys. Peace out, Girl Scouts.